Hello.
Okay. Nice, please.
ಹಾ
One matter.
ಅಯ್ಯೋ,
Your Lordship has
ನೀವು
disposed.
ಮಧ್ಯದಲ್ಲಿದ್ದೀರಾ? ಹಾ.
Yes, Your Lordship has disposed of directing constitution of SIT.
ಹಾ.
SIT is constituted. Report is ready. I want to place that report before Lordship.
ನಾಳೆ
Or-
ಎಸ್
This is abatement to suicide and cheating against the wife.
Pending or
PCR
fresh?
has been filed.
ಪೆಂಡಿಂಗ್ ಆರ್ ಫ್ರೆಶ್?
Fresh matter. 28th is the date, my lords.
Where?
In the trial court, PCR.
27th it will come, give it.
Matter is settled. Sorry.
When do you want it?
Nalige. Hello, the trial court matters coming up tomorrow. Fresh matters, it may be taken up tomorrow matters.
Tomorrow.
My
Okay.
lord,
ಯಾಕೆ?
This is a matter that I moved last week. The offence is under SC/ST Act, my lord. I specifically mentioned the urgency to your lordship, saying that a general council meeting is held tomorrow, and they're harassing me to withdraw my complaint against them. They've misled your lordships and taken an interim order, my lord. Your lordships have listed it today. It's not come.
Not, ಯಾಕೆ ಮೇಡಮ್? ಡೇಟ್ ಕೊಟ್ಟಿದ್ನ? Tomorrow.
Tomorrow, my lord. Grateful.
Your Lordship,
What have you filed? For the complainant?
Yes,
Vacating stay application.
my lord. It's a
ನಾಳೆ
vacating.
ಡೇಟ್ ಹಾಕಿದ್ರು.
Grateful.
Your Lordship, it's a fresh matter. Your Lordship, last week I moved the memo. It's not getting listed.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಂಡೇ ಬರುತ್ತೆ.
My lord, it is a matter where my lord mere rejection of wife visa, my lord, leads to a registration of a 498. My lordship has stayed the proceedings. My lord, wife files a DV case against the husband and in-laws, my lord. I file only for in-laws, my lord. My lord, the pendency of this matter is coming in the way of my lord sisters. My lord, sisters married, having a child 6
Tomorrow.
months old. Tomorrow, my lord.
Tomorrow.
Ex-party stay, the emergent notice was issued by the
You
court
come
on
this side.
1 month back.
No problem, give it. Yes.
My lords, if I can make a mention,
Your Lordship,
Wait. ಎಲ್ಲ I will come to men, wait. Fresh matters ಕೊಡಿ.
I'm moving court.
No problem, give it. Yes.
my lords, there is an old matter.
ಅಜಯ್, come this side. What's your problem? ಅವ್ರಿಗೇನೋ ವಯಸ್ಸಾಗಿದೆ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೂ ಅಲ್ಲೇ ಇಟ್ರಿ. ಬನ್ನಿ ಈ ಕಡೆ. Give it.
My lords, for
Vacating stay ಯಾವ ವರ್ಷದ್ದು? ಮೇಡಮ್ ನೋಡಿ vacating ಸ್ಟೇಗಳು ಹಾಕಿ.
My lords, there's a 24 matter for vacating stay.
Oh, seriously, tomorrow.
My lords, 24 matter for
Yeah, yeah,
vacating stay. I've been
24.
moving since,
Vacating stay tomorrow.
vacating stay, my lords, 24 matter. I've been moving since 6 months.
Give it, yes.
Your Lordship, the two foreign companies whose assets have been illegally frozen by the ED.
Fresh matter,
Fresh matter.
give it.
Monday, Your Lordship.
Wait,
Lords, it's a, your lords, this is a fresh matter, your lords.
give it.
Your lords, it's a pending.
ಆ ಕಡೆ ಬನ್ನಿ. Come that side. Come that side, sir. Yes.
Your Lords, it's a pending matter. There's no stay in this matter, my lord. It's a POXO case against the husband.
Give it.
Just
no
because the custody case is given to me, my lord, the
problem.
custody has been,
ನಾನೇ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ವಾ?
no, my
ಹಂಗಾರೆ
previous
ತೊಂದ್ರೆ
bench.
ಇಲ್ಲ. ಏನ್ ಬಂದ್ರು ಅಷ್ಟೇನೆ. Yes.
Yes, there are,
It is a case and counter case, your lordship. The offences are one.
Fresh matter or pending?
Fresh matter, your lordship.
27th ಎಲ್ಲ. All Monday fresh matters.
Has been passed in this matter.
Huh?
Special orders has been passed in this matter.
Special orders. What special
It
orders?
was posted before Justice Suraj Goendraj.
ಯಾವ್ದು ಮೇಡಮ್ ನೋಡಿ?
CMST.
CM?
Stamped registration.
ಆಯ್ತು ಹಾಕಿ. ಅಲ್ಲ ನೋಡಿ ಸ್ಪೆಷಲ್ ಆರ್ಡರ್ ಯಾವ್ದಾಗಿದೆ ನೋಡ್ಬಿಟ್ಟು ಹಾಕಿ ಮೇಡಮ್.
One submission, my lords, 230 minutes.
Why? Threat of arrest? All right, to that, yes.
My lords, fresh,
ಈ ಕಡೆ ಬನ್ನಿ, ಇಬ್ರು ಈ ಕಡೆ ಬನ್ನಿ.
my lords,
Fresh
fresh.
matter, my lord.
Give.
There is a reasonable apprehension of arrest, my lords.
230.
Connected matter disposed of like this.
ನೀವು ಆ ಕಡೆ ಬನ್ನಿ ಸರ್, ಅವಾಗ್ಲೇ ಹೇಳ್ದೆ.
My lord, my name is not there in complaint or FIR, my lord, but NBW is issued.
Fresh matter,
Yes, my lord.
Monday.
Kindly have it.
NBW,
NBW.
ನಾಳೆ.
My lord, fresh matter. I'm 94 years old, my lord. I've been summoned to
There
the
are
police
three
station.
accused in the same matter.
Huh? Why 3?
3 accusers are there in the same matter, my lord. It's connected
The
to.
day after tomorrow. Yes.
My lord, 498A case.
Wait,
94
fresh matter.
Fresh matter.
Monday.
My lord, they're bedded in, my lord, and they've been called to
ಏನ್
the
ತೊಂದ್ರೆ ಆಗಲ್ಲ ಅಲ್ಲಿ ಇವ್ರಿಗೆ ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಯು ನಾಟ್ ಟೇಕನ್ ಬೇಲ್? ನಾಟ್ ಟೇಕನ್ ಬೇಲ್?
No, sir.
ಆಲ್ ರೈಟ್, ಡೇ ಆಫ್ ಟುಮಾರೋ ಹಾಕಿ.
Thank you.
ಹಾ ಸಾಕು ಆಯ್ತಲ್ಲ? ನಾವು
Fresh matter, your lordship.
ಗಿವ್ ಇಟ್ ಆಫ್. ಎಸ್ ಸರ್. ಜನರಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ.
Your Lordship,
ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಪ್ಲೀಸ್ ಗಿವ್.
Your Lordship,
ಮೆನ್ಷನಿಂಗ್ ವೇಟ್, ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಪ್ಲೀಸ್ ಗಿವ್. ಡೇಟ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಮೆಮಲ್ ಕೊಟ್ಟಿಲ್ಲ ಡೇಟ್, ಬಟ್ ನಾಳೆ ಹಾಕ್ಬಿಡಿ ಮತ್ತೆ ಗಲಾಟೆ ಮಾಡ್ತಾರೆ. ಈ ಕಡೆ ಯಾರು ಇಲ್ಲ ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ, ವೇಟ್. ಎಸ್ ಕೊಡಿ ಎಲ್ಲ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವಿದೆ ಎಲ್ಲ ಕೊಡಿ. ಆಲ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಇರೋ ಮೆಮೋಸ್ ಕೊಡಿ. ಗಿವ್ ಸರ್. 2005 ಇಲ್ಲಿ ಯಾಕೆ ಬಂತು ಈಗ? 25ಗೂ 5ಗೂ ವ್ಯತ್ಯಾಸನೇ ಇಲ್ವಾ? ಆಲ್ ರೈಟ್ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್. ಆಲ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ವಿಲ್ ಕಮ್, ಗಿವ್ ಇಟ್. ಎಸ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಕೊಡಿ. ಎಸ್. ಆಲ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕೊಡಿ. And whoever is wanting settlement, please give.
Reporting settlement.
Reporting settlement, all memos, please mention the date you want. Mention the date you want. All right. With all withdrawals, give. Without taking sanction, tomorrow. ಅದೇನು ವಾಟ್ಸ್ಆ್ಯಪ್ ತಾನೆ, ಹೋಗ್ಬೇಡಿ. ಎಸ್, ಡೋಂಟ್ ಗೋ ಎಟ್ ಆಲ್, ಡೋಂಟ್ ಗೋ ಟುಮಾರೋ. ಇಫ್ ದೇ ಇಶ್ಯೂಡ್ ನೋಟಿಸ್ ಆನ್ ವಾಟ್ಸ್ಆ್ಯಪ್, ಡೋಂಟ್ ಗೋ. 3 ಮೆಮೊ ಇದೆಯಾ, ಕೊಡಿ, ನಾಳೆ ಕೊಡಿ. ಕೊಡಿ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಕೊಡಿ. ನೋ ಸರ್, ಗಿವ್ ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್. ಸೋ ವಾಟ್ ಸರ್, ಇಟ್ ವಿಲ್ ಕಮ್. ಎಸ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಡೇಟ್ ಕೊಡಲ್ಲ ಸರ್, ಕೊಡಿ. ಡೇಟ್ ಕೊಡೋದೇ ಇಲ್ಲ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. ಫ್ರೈಡೆ. ಹಾ ವಿಲ್ ಸಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್, ಗಿವ್ ಇಟ್. ಎಸ್. ನೋ ಲೇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಲೇಟ್ ಕೊಡೋದಿಲ್ಲ. ಕೊಡಲ್ಲ ಸರ್, ಏನಾದ್ರೂ ಕೊಡಲ್ಲ. ಈಗ ಒಬ್ರು ಕೊಟ್ರೆ ಎಲ್ಲರೂ ಕೊಡ್ಬೇಕು ತಾನೆ. ಎಲ್ಲರೂ 65 ಕೊಡಿ ಎಲ್ಲ. ಎಸ್. ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಅಟಿಕಾ ಗೋಲ್ಡ್ ಕೊಡಿ ಇಲ್ಲಿ. ಹಾ ಕೊಡಿ ಟುಮಾರೋ ಹಾಕಿ. ಅಟಿಕಾ ಗೋಲ್ಡ್ SPP ಎಲ್ಲಿದ್ದಾರೆ ಬರ. ಹಾ ಓಕೆ. ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟಾ? ಮಂಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಅದೇನು ಪರವಾಗಿಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಇದ್ರೆ ಕೊಡಿ ಸರ್. ಮಂಡೇ ಬರುತ್ತೆ, ಕೊಡಿ. ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಫಾರ್ ಮಂಡೇ, ಗಿವ್ ಇಟ್. ಅನ್ಲೆಸ್ ದರ್ ಇಸ್ ಎಕ್ಸ್ಟ್ರೀಮ್ ಅರ್ಜೆನ್ಸಿ. ಡೋಂಟ್ ಸೂಡೋ ಅರ್ಜೆನ್ಸಿ ಬೇಡ. ನಿಜವಾಗ್ಲೂ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ, ಇಲ್ಲಾಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ. ಏನ್ ತೊಂದರೆ ಇಲ್ಲ ಸರ್. ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? ಎನಿಥಿಂಗ್ ಎಲ್ಸ್ ಸರ್? ಏನು NDPS ಏನು? ಬಹಳ ಸಂತೋಷ. ಇರಲಿ, ಇನ್ನೊಂದೆರಡು ದಿನ ಆದ್ರೂ ಪರವಾಗಿಲ್ಲ ಬಿಡಿ. ಏನ್ ಪರವಾಗಿಲ್ಲ, ಕೊಡಿ ಸರ್. ನೋ ಪ್ರಾಬ್ಲಮ್ ಸರ್, ಕೊಡಿ ಸರ್, ತೊಂದರೆ ಇಲ್ಲ. ಮಂಡೇ ಸರ್. ಎಸ್. ಸಾರಿ, ಕೊಡಿ. ಅದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಹಾಕಿ. 7A ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ. 7A ಕೊಡಿ ಎಲ್ಲ. 23rd ಬರುತ್ತೆ, ಕೊಡಿ. ಎಸ್. ವೆಕೇಟೆನ್ಸಿ ಕೊಡಿ ಸರ್. ಹಾ, ನೀವು ಕಂಪ್ಲೇನೆಂಟಾ? ಕೊಡಿ ಅದು. ಅದನ್ನ ಮೇಡಮ್ ನಾಳೆಗೆ ಹಾಕಿ. ಅದು ಅಬೇಟ್ಮೆಂಟ್ ಸೂಸೈಡ್ ಸ್ಟೇ ಆಗಿದೆ. ಆಯ್ತು, ಕೊಡಿ. ಟುಮಾರೋ, ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ. ವೆರಿ ಗುಡ್ ಸರ್, ಗಿವ್ ಇಟ್. ದಟ್ ಇಸ್ ನೋ ಅರ್ಜೆನ್ಸಿ ಅಟ್ ಆಲ್. ಇಲ್ಲಿದೆಯಾ ಇಲ್ವಾ? ಗಿವ್ ಇಟ್. I'll give you another 7 minutes, 8 minutes. Astral ಖಾಲಿ ಮಾಡಿದ್ರೆ I will not take any memo. Yes. ಎಲ್ಲರೂ ಹೇಳ್ಬೇಡಿ. Yes. Why? For 2:30. ಕೊಡಿ. Fresh matter. Yes. Monday. Why Avinash? Avinash, wait. Yes. ಈ ಅವಿನಾಶ್ ಕೇಳಿದ್ದು ನಿಮ್ನಲ್ಲ. Yes. ಅವಿನಾಶ್, wait. ಮತ್ತೇನು? Tomorrow, sir.
My lords, if I may mention.
ಎಷ್ಟು ಮೆಮೊ ಇದೆ? No problem. ನಾಳೆ. Not today.
Lord, end of the list, my lord.
Wait, ಎಲ್ಲರೂ ಹೇಳಿದ್ರು ಒಂದ್ ಮೆಮೊನು ತಗೊಳ್ಳಲ್ಲ ಹೇಳಿದೀನಿ. If there is chaos, not a single memo I'll take, I'll start the list. If you want memos, please be disciplined. ಅದ ನಾಳೆನೆ ಕೊಡಿ. ಯಾವ್ದು ನಾಳೆ ಬರುತ್ತೆ? Yes.
With my lord's permission.
My lords, ಅದು ಬರಲ್ಲ. If you comply, it will come. I will not. Go and comply. Don't complain. Yes.
My lords, I'm mentioning 1088.
Please wait.
All right.
You are in the luxury of your office. Please wait. People are waiting here. Yes. Give it, sir.
My lordship.
ತೊಂದರೆ ಇಲ್ಲ ಕೊಡಿ.
My lordship.
Monday or Tuesday it will come. Give it. Yes. ಮತ್ತೆ ಎಲ್ಲರೂ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಒಟ್ಟಿಗೆ. Yes. No problem. Give it.
My lordships, I'm mentioning a matter.
Tomorrow ಇಲ್ಲ, Monday ಇಲ್ಲ, fresh matters.
Matter for tomorrow, my lords. Offense is under 498A.
So what?
The first complaint was filed against the partner and has been acquitted.
Monday.
My lords,
Monday,
tomorrow,
sir.
The urgency is this.
Monday. Yes.
Offenses against the petitioner and the entire family for false promise of marriage and rape. Matter is
2:30.
Matter is settled and for
Settlement.
notice has to be issued for the respondent to appear.
ಹಂಗಾರೆ ನಾಳೆ. Tomorrow.
ಇಬ್ಬರಿಗೂ alliance ಇದೆ ಅದು.
Tomorrow.
My lord. Same complaint has filed
Can't you be quiet?
The same complaint has filed 3 cases, 3 FIRs registered.
ಕೊಡಿ. Monday.
For settlement.
Atrocities, sir.
Yes, my lord.
Atrocities day after tomorrow.
Your lordship, this matter had to be listed yesterday. It's a 498 fresh matter.
Had to be listed ಅಂದ್ರೆ ಯಾರು ಹೇಳಿದ್ರು?
The office objection have been complied. It's
So
been
it has to be listed.
Day after tomorrow, before the honorable apex court. That's the reason, your lordship.
Apex court.
Yes, your lordship.
ಕೊಡಿ.
A connected matter in regard to this. It's a 498A.
Why apex court?
She has, the wife has filed an, this thing, petition there.
For what?
Seeking transfer.
Anyway, then let it come after the apex court.
Your lordship.
Monday, fresh matters.
The matter is posted for regularization of bail as well.
No problem. Yes. Let the apex court take the transfer petition.
498A, senior citizens.
Monday. Yes.
Lord, petitioners are foreign nationals, my lord. They have detention sentence covered by SOP, my lord.
At least
Monday.
may request a date, your lordship.
Monday, sir. Fresh
May
matters
request
on
a
Monday.
date.
Yes.
Monday.
My lords, for settlement.
All Monday.
My lords, for settlement at 2:30, my lords.
Monday. Yes.
Charge frame, day for tomorrow.
My lord, 2:30.
ಸುಮ್ನೆ ಹೇಳ್ತಾ ಇದೀರಾ, ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಇಲ್ಲ ಎಂತದ್ದು ಇರಲ್ಲ. ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ? ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕಿ ಮಾಡೋಣ.
Your lordship, kindly.
Yes, ಕೊಡಿ. ಇನ್ನ 4 minutes ಇದೆ ಅಷ್ಟೇ. Yes. Tomorrow.
My lords, for settlement at 2:30, my lords.
Settlement, please give, sir.
My lords, at 2:30, my.
Settlement ಯಾವಾಗ ಬೇಕು ಕೊಡಿ ಅದು. Yes.
2:30.
Tomorrow. Fresh ಮತ್ತೆ ಫ್ರೆಶ್ ಹೆಂಗಾಗುತ್ತೆ? ಬೇರೆ ಕೊಡಿ. Yes. Tomorrow. No problem. That's a pending matter. Give it. Yes. ಕೊಡಿ ಸರ್ ಎಲ್ಲ. Give it. Give it. No problem. Monday.
Pending matter for withdrawal.
Please give. ಕೊಡಿ. Monday fresh matters ಕೊಡಿ. Tomorrow. Fresh pending. Monday. Monday. Thank you. Give it. Yes. Why? ಕೊಡಿ 2:30.
Milord.
Wife is habitual. Against how, against ಒಂದೇ husband ತಾನೆ? 3 husbands. Tomorrow. ಪರವಾಗಿಲ್ಲ, ಏನಾಗಲ್ಲ ಸರ್, ನಾಳೆ. ಎಸ್. ಮಂಡೇ. ಎಸ್. ಫ್ರೆಶ್ ಆದ್ರೆ ಮಾತ್ರ ಅವಿನಾಶ್. ಮಂಡೇ. ಎಸ್. ಸಾಕು, ಇನ್ನೊಂದು ಮೆಮೊ ಕೊಡ್ಬೇಡಿ ಈಗ. ಎಸ್. ವೇಟ್. ಪೆಂಡಿಂಗ್ ಆದ್ರೆ ಬರಲ್ಲ. ನೋ. Fresh Monday, yes.
Milord, end of the list, Milord.
Don't worry, yes. Give it, sir. No problem, give it, sir, yes.
After 6 months from the date of accident, my lord, the petitioner has been charged with 304A, my lord.
What is Monday?
Milord, I'm a public servant, Milord, end
Very
of the
good.
list, Milord.
Monday, yes. ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ.
Milord, since the matter is very emergency, Milord, there is a serious
Emergency,
apprehension
public
of
servant
arrest.
emergency ಇಲ್ಲ.
Serious apprehension of arrest, Milord.
Arrest, why, sir?
Yes, Milord.
ಏನ್ offense?
420, Milord.
Public servant 420.
Yes, Milord.
Why?
Milord, alleging that.
ಆಯ್ತು ಕೊಡಿ 2:30.
2:30, Milord.
2:30, sir.
Yes, Milord. Most grateful, Milord.
Tomorrow, settlement
ಸ್ಕೂಲ್
tomorrow.
ನಡೆಸ್ತಾ ಇದೀವಿ ಅನಾಥರೈಸ್ಲಿ ಸ್ಕೂಲ್ ನಡೆಸ್ತಾ ಇದೀವಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ರು. ರನ್ನಿಂಗ್ ಸ್ಕೂಲ್ ಅನಾಥರೈಸ್ಲಿ ಅಂತ ಕಂಪ್ಲೇಂಟ್.
Fresh matter, sir.
ಫ್ರೆಶ್
ಕೊಡಿ ಮಂಡೇ.
138 case, my lord.
ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ ಸರ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಬೇಕಾ? ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ವಿಲ್ ಸಿ. ಕೊಡಿ ಸರ್, ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದ್ರೆ ಕೊಡಿ. ಎಸ್ ಕೊಡಿ ಸರ್. ರಾಜು ಅವ್ರದ್ದು ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಯಾವ್ದು ನೋಡಿ. ನಾಳೆ ಯಾವ ವರ್ಷದ್ದು ಮೇಡಮ್? ಅದು ನಾಳೆ ಹಾಕಿ ಅದನ್ನ ಮೇಡಮ್. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ನಂಬರ್ ಕೊಡಿ. ಎಸ್.
ರಿನ್ಯೂವಲ್ ಆಫ್ ಪಾಸ್ಪೋರ್ಟ್ ಇದೆ. 27ನೇ ತಾರೀಕು ಲಾಸ್ಟ್ ಡೇಟ್ ಇದೆ. ಮಕ್ಕಾ ಯಾತ್ರೆಗೆ ಹೋಗಿ
ನಾಡಿದ್ದು ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ.
What's this 138 case, my lord? 311
Monday.
applications been dismissed.
ಮಂಡೇ.
ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ ಪ್ಲೀಸ್.
ಆಲ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಮಂಡೇ ಕೊಟ್ಬಿಡಿ.
Lordship, can you?
ಎಸ್
Lordship.
ಕೊಡಿ ಎಲ್ಲ
My lord,
ಕೊಡಿ ಸರ್.
Without considering the
That's all right, give it now.
my lord's 420 pending. Petitioner is 62 years
No
old.
problem, that's not a age at all. Yes, give it.
Lordship, can you? It is a pending matter.
ಅದೇ ಯಾವ್ದು ಕೊಡಿ ಮೇಡಮ್, ತೊಗೊಳ್ಳಿ.
Your Lordship, it is a pending matter.
Give it, sir.
Before vacation, it was posted. Your
Give it,
Lordship has
sir.
ordered to.
If you want to give the memo, yes, what's your problem?
Lordship, I have
Lordship,
submitted.
can we fix the date?
No date fixing, sir. Give it.
Lordship, I have submitted vacating stay
Because
IA
the-
on 3rd of June, Lordship.
When do you want it?
I have submitted
When do you want it?
this week, anytime.
Friday.
Your Lordship,
Thanks, Lord.
in this case, because the trial court is framing the issues
No
and
problem.
proceeding with the matter, your
Yes,
Lordship.
yes, give it, sir.
Your lordship,
Madam.
four petitioners, my lord, they are foreign nationals, they are in detention center, my lord.
SOP
It is covered by the SOP.
tomorrow. Fresh matter, Somana? Comply ಮಾಡಿ ಹೋಗಿ first.
Kind submission, please.
This is the fourth memo, your Lordship.
Who said fourth memo?
This is the fourth memo.
Move another 4 memos. Yes.
No, your Lordship, may kindly fix the date.
No,
Because
fix it.
in the
No,
absence
sir.
of stay,
I will
the
not.
trial court issue.
Vacating stay ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ, vacate,
stay
ತಾವು ಕೊಡ್ಬೇಕು ಸ್ವಾಮಿ.
ಕೊಡ್ಬೇಕಾ? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
ಇಲ್ಲ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ಪೋಸ್ಟ್ ಮಾಡಿದ್ರು.
ತೊಂದ್ರೆ ಇಲ್ಲ.
ಬಟ್ ಬಂದೇ ಇಲ್ಲ.
ಬರುತ್ತೆ. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ಡೇಟ್ ಫಿಕ್ಸೇ ಮಾಡಲ್ಲ ನಾನು. ಎಸ್.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸ್ವಾಮಿ.
ಮಾಡಲ್ಲ ಸರ್. ಫಿಕ್ಸೇ ಮಾಡಲ್ಲ ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ಸ್. ಎಸ್.
Your lordship, it's a pending ED, it's a pending ED matter. B report is already filed.
No problem,
Matter may
give
be
it.
taken up.
No problem, give it. Yes.
My lords, if I may mention.
My lord,
My lords, with your kind permission.
2:30 ಅಂದ ತಕ್ಷಣ ತಗೋಕೆ ಏನದು?
public servant.
ಏನು so?
Without considering the internal report.
No problem. Tomorrow.
Filed a
Tomorrow,
absconding charge
sir.
sheet.
Tomorrow.
My lords, with your kind permission, if I may mention. My lords, memo number.
If it's adjournment, don't move.
Yes.
Don't mention it.
No, my lords, it's a fresh matter. It is a quashing for the FIR emanating out of extramarital relationship. My lords, I am a 64-year-old man.
You have extramarital relationship at 64?
My lords, it's a consensual relationship, 40-year-old relationship.
Oh, bar.
Lords,
Anyway, when do you want it, sir?
my lords, day after. My lords, I am put to
Day
on the
after.
trial.
All
I'm
right,
so
day
grateful.
after tomorrow.
So
Fresh
grateful.
matters. Yes.
So grateful.
All the cases.
List one, fresh matter, still number one.
One HCGP, two emergent notice. Next.
Number two.
I'm appearing for the petitioner, my lord.
Covered. Recreation.
Yes, ma'am. Kindly state the
Judgment is there. Copy.
that I will give you, my lord. As per the directions of this honorable court only, we are running the recreational club.
Bada Santosh. Yes.
So,
Disposed. Yes. Next. Recreation.
Number three.
Vinay Kumar. ಒಂದು ವರ್ಷ old ಆರ್ಡರ್ಗಳೆಲ್ಲ. Petitioner to serve on the council who represents the respondent and place on record the stage of the proceedings as on today by the next date. List the matter on 29th in the fresh matters list. Next.
Fourth.
2, 3 and 4, 85, one husband, no stay. Yes.
In this case, my humble submission, sir, direction may be given to dispose the as possible as early
ಇದು
as
ಬೇಡವಾ?
6 months.
ಯಾರಿಗೂ ಸ್ಟೇ ಬೇಡವಾ?
ಅಲ್ಲ, evidence.
Comments ಆಗಿದೆಯಾ?
Comments
The
ಆಗಿದೆ.
petitioner is before the court seeking the following prior. The learned HCGP on instructions and verification of the records should submit that the trial has commenced and the matter is at the stage of evidence. In that light, there is no warrant of interference in the judgment of the apex court in the case Meenakshi Bala. The learned counsel of the petitioner would now submit that if a direction is issued for expeditious conclusion of the trial,
Court is decreed my favor and
no
appeal
problem, sir. Expeditious conclusion of the trial, it would suffice. ಯಾವ ವರ್ಷದಿದು?
So 2014, please, Lord.
The issue is of the year 2014, languishing in the court, in the concerned court for about 12 years now. Therefore, I deem it appropriate to infuse finality into the proceedings with a direction to the concerned court to conclude the proceedings with an outer limit of 8 weeks from the date of receipt of the copy of the order in accordance with law. In the event the parties to the list would not cooperate for closure of the proceedings, the concerned court is at liberty to pass necessary orders in accordance with law.
Correct.
Yes.
Five.
Same order, 2014, the iduno, same speedy disposal. Dispose, sir.
Still
Yes.
number six.
I appear for the petitioners in the matter, Your Honor, Your Lordship. It's against.
What is this petitioner's name? Innocent MDMA? Serial number 8, right?
6 here, Your Lordship.
6.
Against the
That is
husband.
second list, madam. Wait, this is first list.
Yes, I am serial number 6 for cause list 1.
What's your name?
Azhar Mir.
Who appeared now for expeditious disposal? Sidmallappa yavudಕ್ಕೆ madam?
In this case, my lord, it is on the date and I am challenging the section 9.
First 5 mugili, wait madam. Yes.
Number five.
ಜೇವೈ ಸ್ವಲ್ಪ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿದೆ. This ಸಿದ್ಮಲ್ಲಪ್ಪದ್ ಮಾಡಿದ್ವಲ್ಲ, serial number 4, serial number 7 ಸೇಮ್. ಓಕೆ. ಆಮೇಲೆ serial number 5 ಅಲ್ಲಿ one learned counsel for the petitioner to serve on the counsel who represents the respondent in the trial proceedings and file an acknowledgement to that effect. List on 30th in the fresh matters list.
Please,
Yes.
in the meantime,
ಆಮೇಲೆ
just-
serial number 6, 2, 3 and 4 stayed. One husband, no stay. Yes.
Eight.
Serial number 7 ಏನ್ ಹೇಳಿದ್ನಲ್ಲ ಅವಾಗ್ಲೇ speedy disposal. Yes.
My lord,
next.
7, CC has to be numbered. Cognizance is already taken. Detailed order is passed. Page
7
number 51.
No, 7 ಏನ್ prayer ನೋಡಿ.
My lord, I have only asked for speedy disposal
I have
along
granted.
with it to convert into CC. Crime number
In
is
accordance with law, sir. 2014, right?
2014.
Now
my
it is
lord.
renumbered.
ಆಗಿಲ್ಲ ಸ್ವಾಮಿ.
ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಮಾಡ್ತಾ
In
ಇಲ್ಲ.
accordance with law ಅಂದ್ರೆ ಮಾಡ್ತಾರೆ.
My lord, already detailed order is passed in 24. He is again issuing summons to expert witness without accused being present,
ಅದನ್ನ
my lord.
12 weeks ಅಂತ ಮಾಡ್ಬಿಟ್ಟು the prayer court ಮಾಡ್ಬಿಟ್ಟು ಆಮೇಲೆ order ಮಾಡಿ. In terms of the aforesaid prayer, the concerned court shall take action for disposal of the proceedings with an outer limit of 12 weeks. Yes. Next. Who is
If I may, serial number 6, if I may.
husband illa madam? I will not
There
grant.
was the one who was attacked in
No,
January
no,
2026
whatever it
by
is,
the
no
family.
problem.
I
Yes.
produced photographs.
I have
as
seen
Your Lordship.
ಕತ್ತಲ್ ಗಾಯ ಆಗಿರೋದು ನೋಡಿದ್ದೀನಿ.
Yes, Your Lordship. Grateful, Your Lordship.
8.
My lord, in this case.
Yes, what is innocent MDMA?
Innocent Madhav.
Madhav?
Madhav, yes, yes, Your Lordship.
Your case is MDMA, NDPS.
Yes, my lord, it is a.
So why you call yourself innocent?
No, my lord, if Your Lordship may kindly see the factual matrix of the case.
Matrix?
My lord.
Gautam Dev Ullalili?
My lord,
ಇಲ್ಲ,
kindly,
ಬನ್ನಿ.
kindly see.
Yes, sir.
The offense alleged by the respondent number one, according to them, happened on 27th of March, 2023.
So,
However, on 28th of March, the petitioner was found to be in the custody of respondent number two,
No.
FRRO.
Yeah.
Now, on
Which country you come from?
Nigeria.
You should go back now.
Yes, Your Lordship. I
In
want,
terms of the SOP, we'll send you back unless the punishment is beyond 7 years.
no, what I'm saying, my Lord, my
You
Lord,
may
is,
say anything, wait, yes. Parvailla, if it is below 7 years, let him go out of the country. And if he is here, he is not innocent anyway. He will sell MDMA only. Yes. Yes, Gautam?
Passover.
Passover, why?
My lord, I just.
Get instructions with regard to the offense and the SOP. If you want any clarification, ask Shanti Bhushan. Right? Yes.
my Lord, they have
Passover.
booked- they have- okay.
Yes.
I'll request Your Lordship to kindly see the facts when the,
No, sir, not at all.
because
The only relief you can get in terms of the SOP is you should go out of the country.
Yes, my Lord, I want to go out of the country. However, my Lord, the offense booked is a commercial quantity. So
Oh,
commercial
then you will
quantity-
not, you will be here only. Yes.
So-
Anyway,
so-
get instructions and come.
That's why I'm requesting Your Lordship to look
I
at
will
the
not,
facts.
there's no question of stay. Trial has commenced.
No, I'm not asking for stay, Your Lordship.
Then what do you want now?
I want to quash the thing.
Oh, higher relief. Wait.
Yes, my Lord.
Very good. The petitioner is before the court seeking the following prayer. The learned HCGP on instructions and verification of the records would submit that the trial has commenced and the evidence is on. The allegation against the petitioner is the recovery of MDMA from his hands in the year 2023, and in the light of the trial pending, there is no warrant of interference seeking quashment of the proceedings under section 528 of the BNSS. In the light of the judgment of the apex court in the case of Meenakshi Bala, whatever be the reason, therefore the petition stands disposed with the liberty to the petitioner to urge all the contentions before the concerned court during the trial, ordered accordingly. Next.
Your Honor, Your Lordship, I request one relief. If Your Lordship is inclined to dispose it of, I request Your Lordship to give a direction to the trial court to dispose it of within, just like in the previous case,
No,
6
I
weeks.
won't. Not necessary. Yes. Next.
No, my Lord, see.
Next
my Lord,
case.
My Lord,
Yes.
he has been in detention
I
for
will
1.5
impose
years.
costs now. Yes. You are in detention center not for any good deed or by mistaken deed. You are selling MDMA and caught.
No, my Lord, Your
So
Lordship.
yes, next.
The interim order passed by on the continuation of delay, Lordship.
5 ದಿನ ಡಿಲೇನಾ?
ಡಿಲೇ ಇದೆ, ಅದಕ್ಕೆ ಎಂಟೈರ್ ಅಮೌಂಟ್ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ಅಂತ ಕಂಡೀಷನ್ ಹಾಕ್ಬಿಟ್ಟು
ಖಂಡಿತ ಎಷ್ಟಿದೆ ಸರ್?
50% ಮೇ ಬಿ
ಎಷ್ಟಿದೆ ಅರಿಯರ್ಸ್?
ಅದನ್ನ ಕ್ಯಾಲ್ಕುಲೇಟ್ ಕೈಂಡ್ಲಿ ಸಿ ಮಾಡಿ.
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
ಅದರಲ್ಲಿ ಆಂಬಿಗ್ಯೂಟಿ ಇದೆ. ಇದು ಟ್ರಯಲ್ ಕೋರ್ಟ್
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ?
ಒಂದೇ ಒಂದು
ಸ್ಟ್ರೈಟ್ ಕ್ವಶನ್ ಸ್ಟ್ರೈಟ್ ಆನ್ಸರ್.
ಪ್ಲೀಸ್ ಮೈ ಲಾರ್ಡ್, ಐ ಆಮ್
ಗೊತ್ತಿಲ್ವಾ? ಡಿಸ್ಮಿಸ್ಡ್.
ಅಲ್ಲ 35 ಒಂದೇ ಒಂದು ಪೇಜ್. ಇಂಕ್ ಪೇಜ್ 35 ನಾನು ಬೇರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಲ್ಲ ಸರ್. ಆಂಬಿಗ್ಯೂಟಿ ಇದೆ ಆರ್ಡರ್ ಅಲ್ಲ, ಅದನ್ನ ತಾವು ನೋಡಿ.
ನೋ ಆಂಬಿಗ್ಯೂಟಿ ಅಟ್ ಆಲ್.
ಇಂಕ್ ಪೇಜ್ ನಂಬರ್ 35.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಪ್ಲೀಸ್ ಲಾರ್ಡ್.
ಹಸ್ಬೆಂಡ್ ಪ್ರೊಜೆಕ್ಟಿಂಗ್ ಆಂಬಿಗ್ಯೂಟಿ ಫಾರ್ ದಿ ಸೇಕ್ ಆಫ್ ಎಸ್ಕೇಪಿಂಗ್ ಮೇಂಟೆನೆನ್ಸ್.
50% ಕಟ್ಟಕ್ಕೆ ಮಾಡ್ತೀನಿ ನಾನು ಸ್ವಾಮಿ. ನೀವೇನು ಆರ್ಡರ್ ಮಾಡಿದ್ರೆ
ಎಷ್ಟಿದೆ ಅಂತ ಗೊತ್ತಿಲ್ಲ, 50% ಹೆಂಗ್ ಹೇಳ್ತೀರಾ?
ನಾನು ಕಟ್ತೀನಿ ಸ್ವಾಮಿ. 50%
ಎಲ್ಲಿದೆ? ಎಷ್ಟಿದೆ?
100% ಅಂತ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅವರು.
ಅರಿಯರ್ಸ್ ಎಷ್ಟಿದೆ ಸರ್?
ಅದನ್ನ ನೋಡಿ ಹೇಳ್ತೀನಿ.
ಏನ್ ನೀವು ಗ್ರೌಂಡ್ ಒಂದೇ ಒಂದು ಇರೋದು, 5 ದಿನ ಡಿಲೇ.
ಅದೇ ಡಿಲೇ ಕಂಡೌನ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
ಕಂಡೌನ್ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಎನಿಥಿಂಗ್ ಎಲ್ಸ್?
50% ಕಟ್ಟಕ್ಕೆ.
ನೋ ಸರ್, ಅಮೌಂಟೇ ಗೊತ್ತಿಲ್ಲ, 50% ಏನ್ ಬಂತು?
ದಯವಿಟ್ಟು ಇಂಕ್ ಪೇಜ್ 35 ನಲ್ಲಿ.
ನೋ, ಐ ವಿಲ್ ನಾಟ್.
ಅಲ್ಲ, ಅದೊಂದೇ ಒಂದು ಪ್ಯಾರಾ ಓದ್ಬಿಡ್ತೀನಿ. ಇಂಕ್ ಪೇಜ್ 35 ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ನ ತಾವು ಒಂದೇ ಒಂದು ಪ್ಯಾರಾ. Interim maintenance at rate of 5,000 PA each to the petitioner and her son as per the order of appellate court so and so on the file of additional decision judge Mysore is payable by the respondent till the date of this order. Same order holds good.
ಪರವಾಗಿಲ್ಲ ಬಿಡಿ, ದುಡ್ಡು ಕೊಡಿ.
Already
ಈಗ
50%.
5,000 ರೂಪಾಯಿ ಕೊಟ್ಟಿದ್ದಾರೆ ತಾನೆ?
50%
ಅಲ್ಲಿವರೆಗೂ ಅದು ಹೋಲ್ಡ್ಸ್ ಗುಡ್ ಅಂತ ಹೇಳಿರೋದು. ಫ್ರಮ್ ದಿ ಡೇಟ್ ಆಫ್ ದಿಸ್ ಆರ್ಡರ್ 6,000 ಹೇಳಿದ್ದಾರೆ.
ಅದು ಮಗುಗೆ.
ಪರವಾಗಿಲ್ಲ,
ಮಗುಗೆ
ಕೊಡಿ.
ಕೊಡ್ತೇನೆ ಸ್ವಾಮಿ.
ಯಾವಾಗ
Lordship on the within
ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರೆ ಅವರು FLW ಹಾಕೊಂತಾರೆ.
within 4 weeks ಅಲ್ಲ 50%.
ನೋ ಸರ್, ನಥಿಂಗ್ ಡೂಯಿಂಗ್.
ಅಲ್ಲ, ನಾನು ಕಟ್ಟಕ್ಕೆ
ಐ ವಿಲ್ ಪೋಸ್ಟ್ ಇಟ್ ನೆಕ್ಸ್ಟ್ ಫ್ರೈಡೆ. ಅಷ್ಟ್ರಲ್ಲಿ ದುಡ್ಡು ರೆಡಿ ಮಾಡಿದ್ರೆ ಇದು ಎಂಟರ್ಟೈನ್ ಮಾಡ್ತೀನಿ.
50%.
ನೋ ಸರ್,
ಅಲ್ಲೇ ಕಟ್ಬಿಡ್ತೀನಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್.
ನೋ ಬೇಡ, ಇಲ್ಲೇ ತಗೊಂಬನ್ನಿ. ಗೆಟ್ ದ DD and come here. Lest the matter on 31st. Interim order would be considered to be granted only if the husband would show bona fides by placing a demand draft before this court for payment of maintenance to the wife and the child. ಎಷ್ಟು ವರ್ಷ? ಮಗು ಎಷ್ಟು ವರ್ಷ?
9 years.
Huh? So and so. List on 31st. In the event no demand draft is placed before the court, the petition will be dismissed without hearing
Please, sir.
the husband. Yes.
Number 10.
85, 2 and 3. Next.
Great.
The petitioner is before the court calling in question the action of the concerned court in allowing an application, taking cognizance of the offense under section 138 of the Negotiable Instruments Act without condoning the delay of 63 days in filing the subject petition, in the filing the proceedings before the concerned court. In that light, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing.
Please, madam, please. Notice 12.
Huh?
Notice.
Madadnala.
Please,
Notice
please,
is
please.
responded.
12.
Offense is 341, 323, 504,
In the meantime, next.
13.
During the course of the investigation,
Huh?
during the course of the investigation, she withdrew the complaint.
13.
Yes, ma'am.
Abhinay.
Yes, ma'am. During the course of the investigation, she withdrews the complaint.
Withdraws.
Withdraws the complaint, my lords.
Mm.
B report is filed. Based on that, a notice goes to the complainant. On the very same day, she files
Second complaint.
Second complaint. Mother is included.
In the meantime, yes, next. So PSI stay ಕೊಡಬಾರ್ದು ಅಂತಿದೆ. ಎಷ್ಟು ಕಂಪ್ಲೇಂಟ್ ಆಗ್ತಾರೆ? How many complaints? You stop, don't talk. How many complaints? Forced to withdraw what? Where is the withdrawn? B report ಅಲ್ಲಿ ಇದೆ ಅದು. Yes, sir. ಏನ್ ಮಾಡಿದೀರಾ ಸರ್ ನೀವು?
Lords, the allegation is, if my lords may,
First complaint ಏನಾಯ್ತು ಹೇಳಿ?
first complaint, my lords, it's an allegation of promise to marry.
Promise to marry.
Yes, my lords. If my
First
lords,
complaint ಏನಾಯ್ತು?
first complaint during the course of investigation.
ಯಾರಿದು? Complainant is a lawyer, is it?
She files withdrawal, seeking withdrawal, my lords.
Where is it?
28, page number
The
28.
B report ಅಲ್ಲಿ close ಆಗ್ಲಿಲ್ಲ.
Close agila, notice hoಯ್ತು. On this very same day, she files one more.
Where is the withdrawal?
28, 27, my lords, 28 relevant paragraphs, my lords. 6th paragraph. 28. Page number 28, my lords. 27 in the start ಆಗುತ್ತೆ.
ಆಯ್ತು.
If I can read from
ನಾನು
paragraph 6.
ವಿರುದ್ಧ ಕೊಟ್ಟಿರುವ ದೂರನ್ನು ವಾಪಸ್ ತೆಗೆದುಕೊಳ್ಳುತ್ತೇನೆ. ಹಿಂತಿರುಗಿದ್ದು ನನ್ನ 3 ತಿಂಗಳಲ್ಲಿ. ಯಾವತ್ತಿದು?
This is on, my lords.
20th.
Yes, my lords.
ಯಾವ ಡೇಟ್ ಏನಿದೆ?
This is, my lords, on 20. This is received on 26, 2026. After this, my lords, the police files a B report on notice.
On the basis of the withdrawal B report, not on investigation.
Not on investigation. Investigation also, but based on this also, both, my. So on the very same day, notice.
ಆಮೇಲೆ next complaint ಯಾವುದು?
Next complaint, my lords, on 18/6/26, when the notice is sent from the court to her. When the B report is filed in the court, 18/6/26.
B report.
My lords should see at page number 33. Police notice is issued to complainant. FIR complaint or enclosed.
How did you meet her?
Lords, it is said that there were messages exchanged on Instagram.
Instagram.
And they met later on. Even in her withdrawal letter, she says that ಈ complaint ನಾನು ಸಿಕ್ತಿರ್ಲಿಲ್ಲ ಅದಕ್ಕೆ ಕೊಟ್ಟೆ. I was not reachable to her, so she gives this complaint. Now I'm taking back this complaint.
ಯಾರು?
You're, the complainant, my lords. Relevant paragraph, my lords. Page number 11. Page.
She was forced to withdraw that.
That's what she alleges in her next complaint, my lords. Now my mother is included, stating that complaint ವಾಪಸ್ ತಗೊಂಡ್ಬಿಡು ದುಡ್ಡು ಕೊಡ್ತೀನಿ. Now my mother is also included in the second complaint.
In the second complaint, has she stated that she was forced to withdraw the first one?
She has stated, my lords.
She has stated.
She has stated. She has stated.
Mother, we will stay, but trial against, investigation against you will continue. You're a PSI, yeah?
Yes,
ಎಲ್ಲಿ? The petitioner is before the petitioners are the mother and son. Accused number 1 is the son, the second petitioner, accused number 2 is the mother. The second respondent is the complainant. The second respondent is the complainant. The first petitioner, accused number 1, is a police sub-inspector at Tunganagar Police Station, Shivamogga. The complainant is a practicing advocate. Where does she practice, Shivamogga? At Chitradurga. The two get acquainted through social media - Instagram. Messages are exchanged, contact develops, the contact blossoms into friendship, friendship into relationship, physical as well. This happens over a year. It is the allegation that the petitioner, accused number 1, has promised that he would marry her and had indulged in sexual activities with the complainant. When the promise was breached by the accused number 1, a crime comes to be registered in crime number 128 of 2025, 2025, alleging the said offense. The police then file a B report in the said crime on the strength of a withdrawal memo that was filed before the concerned court by the complainant. The complainant then registers a second complaint narrating that the police had forced her to withdraw the complaint or threatened her to withdraw the complaint. The accused had threatened her to withdraw the complaint. The second complaint therefore is filed immediately on the police filing a B report on the strength of the withdrawal in the earlier case. The second crime is what has driven the petitioner to this court in the subject petition. Finding the allegations against the mother improbable, there shall be an interim order of stay only insofar as accused number 2 is concerned. It is made clear the proceedings or investigation shall continue against accused number 1, notwithstanding the earlier withdrawal of the complaint. Next.
14.
My lord, the provision of MMDR Act invoked by
Learned
police
HCGP is
without
directed to
My
accept
lordship
note.
covered by judgment, my lord.
That's not covered at all, sir.
Alla, MMDR Act and invoke ಮಾಡಿದ್ದಾರೆ, my lord.
ಏನ್ ಬೇಕಾಗಿತ್ತು, sir?
The police itself is the police inspector itself is the complaint, my lord.
That is exactly what is said in the judgment. Yes. List the matter on the next Wednesday in the fresh matters list. Yes. Next.
15.
Lordship co-accused acquitted 399 402. He is A2. Lordship judgment is
Split.
Split case. Only-
What is?
Yes, madam.
Yes, madam, we'll close it. The petitioner is before the court calling in question the continuance of the proceedings in a C-36 of 2026 within bracket split case in crime number 388 of 2022. The petitioner is accused number 2 who gets embroiled in a crime along with others for offense punishable under section 399 and 402 of the IPC, preparation for commission of dacoity or commission of dacoity as the case would be. The petitioner at the relevant point in time was not available for trial. The person who was available for trial, i.e. accused number 1, was tried and is acquitted of the offense by the concerned court on the following reasons. Page 39 to
3-4. my lord. They are acquitted.
39 to 46. If the offense is the one punishable under section 399 and 402 and the acquittal is on the reason that the prosecution has miserably failed to prove the guilt beyond all reasonable doubt, it cannot be said that on the same evidence the petitioner would get convicted. In that light, the permitting further trial against this petitioner would be wastage of precious judicial time. Therefore, I deem it appropriate to exercise my jurisdiction so and so and obliterate the view of mine. Yes. Next.
I'm appearing for petition in this case.
OS number. OS number.
Please, my lords. 457 of 2025.
ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿರೋದು
No.
ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿರುತ್ತಾನೆ. The complaint institutes OS so and so and in the same breath sets the criminal law into motion. In that light, there shall be an interim order of stay for the proceedings by the petitioner till the appearance of the complainant. List the matter on 12th August. Emergent notice returnable by 12th.
17.
I appear for petitioner. My lord.
A4.
A4, my lord.
Get the investigation papers. Learned HCGP is directed to accept notice, secure the investigation papers and place it before the court on the next date, 12th August. Next.
In the fresh matters.
Fresh matters.
18.
I'm affirm for petitioner, my lord. Petitioner 1 and 2 is the friend of the petitioner 1 and 2, SC/ST, my lord.
Charge sheet is ready for and scrutiny is ready.
Challenge the charge sheet.
My lord, already 85 BNS already stay agide. Family matter is
Challenge the charge sheet. Yes. Next.
19.
Case and counter case.
Please, my lords.
1 HCGP to emergent notice.
My lords, there is
No.
a voice, my lords.
No.
I have filed a case first.
ಅದೇನು ಅದು ನೀವು ಹೇಳಿದ್ ಕರೆಕ್ಟಾ?
There is an injunction order in my favor.
ಪರವಾಗಿಲ್ಲ ಸರ್.
The land is granted in my favor.
ಅದು ಲ್ಯಾಂಡ್ ಅಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಇದು.
Please, my
Yes,
lords.
that's
That
why.
is the issue, my lords.
No sir. Yes. Let it come. Next.
20.
Omkar Basoprabhu. You are the owner of the vehicle.
Yes,
The petitioner is the owner of the vehicle and the driver drives the vehicle in a rash and negligent manner and the vehicle meets with an accident. The petitioner is now drawn as an accused, notwithstanding the fact that he has nothing to do. In that light, there shall be an interim order of stay of further proceedings where the petitioner, the owner of the vehicle. It is made clear that the grant of stay here will not become applicable to any liability in a proceeding instituted by the claimants before claimants for compensation.
May I please, my lord, the accused number 1 was the unauthorized operative of
ಗೊತ್ತಿಲ್ಲ
the
sir.
vehicle.
Whatever.
Accused number 2 was the driver.
ನೀವ್ಯಾರು?
It's accused number 3. The
3
petitioner is accused number 3.
3, fine, yes.
I'm grateful.
Next.
21.
BDA forgery.
Lords, I am, my lords, accused number 1 and 4. I am, my lords, a bona fide purchaser. I sold it, my lords, in 2021 itself. Accused number 2 is the one who executes, my lords, the sale deed in favor of CW7. My lords, 1, my lords, aspect I want to bring to court's notice. CW4 is, my lords, the son of my vendor. My lords, he keeps quiet, my lords.
Let's see, wait. Yes, 1 HCGP2 emergent notice returnable by the 11th of August, list on 11th in the fresh matters list. That day we'll see. Please.
22.
Land
Who
boundary.
is in possession?
Lords, I am in possession of my land. This boundary.
Yes.
23.
Latif, notice.
My lords, petitioner is residing in abroad, my lord, at least interim protection may be granted. My lords, the allegation in the, my lords, kindly peruse to page number 21, my lords. The petitioner is residing in the Dakshin Kannada and the Aadhaar card was issued of the Andhra Pradesh, my lord. My lords, the only allegation is that, my lord, about forgery of the Aadhaar card, my lord.
Yes.
Lords, the petition.
1 HCGP2 emergent notice. Next.
Lords, interim protection.
No,
may-
sir.
Lords, he is residing in abroad, my lords.
ಅಲ್ಲೇ ಇರಿ sir, ತೊಂದ್ರೆ ಇಲ್ಲ. Yes.
24.
I appear for the petitioners, my lord. Lord,
498.
yes, my lord.
ಎಲ್ಲರ ಮೇಲೂ allegation ಇದೆ.
ಇಲ್ಲ, my lord.
No.
The petitioner number 4 and 5, there is no allegation.
Get the investigation papers.
Lord, petition-
1 HCGP2 emergent notice returnable by the 13th of August, the petitioner the state shall secure the investigation papers and place it before the court on the next date. Yes.
25.
Lords, all I am seeking.
The
give me, lords,
petitioner to sir.
I'm sorry. Lords, just.
What is that all you're seeking?
Lords, leave to produce 2 documents, my lords, and matters.
ಗೊತ್ತಾಯ್ತು. Serve on the council. The
Please,
petitioner to serve on the council who represents the respondent in the trial proceedings. Further proceedings shall remain state till the next date. List the matter on 11th August.
Deeply
In the fresh matters list. Yes.
It's number 2 being spoken to still number 1.
498A, they have compromised. And that day we have reported.
ಅಲ್ಲಿ ಏನಿಲ್ಲ ಕಾಂಪ್ರಮೈಸ್ಗೆ.
ಇಲ್ಲ, ಇದೆ. MC petition.
ಎಲ್ಲಿದೆ ಸರ್? ಅದು ಕೊಟ್ರೆ ಕಾಂಪ್ರಮೈಸ್.
ಇಲ್ಲ, page 37. Let's me kindly turn to.
Page 35 ಅಲ್ವಾ?
35.
ತೋರಿಸ್ಬಿಡಿ ಸರ್. ತಗೊಳ್ಳಿ. ಹಿಂಗೆಲ್ಲ ಸುಮ್ನೆ ಸೆಟಲ್ಮೆಂಟ್ ಮೂವ್ ಮಾಡೋ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡಿ
Para
discuss
para
ಮಾಡ್ತೀವಿ.
9, para
ಇದು
9.
ತಗೊಳ್ಳಿ ಸರ್.
Para 9 of the
ಇದ್ರಲ್ಲಿ
petition.
ಕೊಟ್ಬಿಡಿ. ಇದ್ರಲ್ಲಿ ಕೊಡಿ. ಎಲ್ಲಿದೆ ಕೊಡಿ. ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಅದು?
She has agreed for 10,50,000.
Agreed ಅಷ್ಟೇ. Where is the?
No, we have paid it.
Where is the final decree there?
ಅಲ್ಲ, final decree ಇಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ why did you move it?
You let me kindly period. 10,50,000 she has agreed.
No,
We have
sir.
No, it is.
Where is the judgment on this?
There is no judgment.
Leave it. Yes. This court on.
May I make one request?
No, sir.
ಅಲ್ಲ, one
This
second.
court on
Make
so
one
and so
request.
date
May I
had disposed the petition recording settlement on the score that the divorce should be agreed on a mutual consent of payment of money. There is no decree after this decree of divorce later, but the settlement is projected before this court saying that the wife has agreed and they have also paid the amount unless the
10 lakhs,
respondent wife comes and submits the same, the settlement will not be, there can be no warrant of settlement in the case at hand. The order stands recalled post the matter for admission. Yes. Next.
Seal number 2.
Matter, my lord, that four times investigation. Your lordship felt it.
Again, being spoken to yake?
My lord, it was disposed of. Lord, I'm seeking expungement. My lord, your lordship felt that application should be on record.
Correct.
I filed application also, seeking permission.
maybe allowed.
Yes. ಅದು ಯಾವ paragraph ಅಲ್ಲಿ ಇದೆ ಅಂತ ಹೇಳಿ.
68 ಅಂತ prayer ಅಲ್ಲಿ ಹಾಕಿ.
ಸರಿ. ಅದು for the reasons indicated in the affidavit accompanying the application, the observations made against the investigating officer by the
And the
concerned
investigating agency.
and the investigating agent, ಲೋಕಾಯುಕ್ತ ಮೇಲೂ ಮಾಡಿದಾರಾ? And the investigating agency shall stand expunged. ಯಾವ paragraph ಇದೆ ಅದನ್ನು quote
68.
ಮಾಡಿಬಿಟ್ಟು the aforesaid observation shall stand expunged.
Great.
Yes. From the final order, from the impugned order. Yes.
Yes, my lord, impugned order, not.
ಅದೇ
my
impugned
lord's
order, correct, ಗೊತ್ತಾಯ್ತು. Yes.
Hearing on IS, seal number 3.
Also for petitioner, I'll hear the full. Last time I have submitted. It's a matter of where both first complainant and the so-called petitioner before the court got acquainted through Bumble dating app.
Yes, sir.
It is covered in the judgment.
Yes,
on
my lord.
No adjournments at all. Yes. Come on, merits. Yes, sir.
This, my lord, 164 statement is recorded. My lord. That may be ascertained, my lord, then. That only I have to produce.
ಯಾಕೆ extortion ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ?
He is, my lord, he is making, he is everyday demanding. That's why, my lord, complaint was lodged. She is not made any allegation in respect of their relationship. When she not interested to continue with the relation, these things are happened. And he started to threatening to circulate the photographs and video of private videos.
All right. Where is the 164 statement? Put madam.
That's, I am also not.
ರೇಪ್ ಏನಿಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಇಲ್ಲ. That I have not made.
Yes, sir.
He made an allegation later.
Come on,
self-serving. When they were
come on, no problem, sir. You
when
come
they
on,
were-
sir. Come on, merits. Yes.
On the merits, like on 1/3/2023, she files a complaint in the FN number with the saved allegations, and subsequently on 24/3/2023, another complaint is registered in the same crime number in Visakhapatnam.
Yes, sir.
And after the said, she says that he was forced me to have a live-in relationship. That is the only allegations. And other than this, when they were in good terms, there was an exchange of monies. When he demanded and asked the monies, that has been texted as extortion, money extortion of 45,000. That is the one thing. And coming to this, in the verge of the investigation, kindly peruse Annexure D, my lord. Annexure D, his father was been beaten to the blow by the so-called police authorities.
Police,
Out Swami, Mangalore police.
ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಳೋಣ ಬಿಡಿ.
The aged parent was been beaten to the blow. 1/3/2023, the complainant, who is 33-year-old doctor. Doctor. And he is a medical officer in the same thing.
Who is medical officer? Petitioner.
Petitioner is a medical officer who is 36 years old. So both can't claim. After filing the complaint before Mangalore police station, the same complaint I have perused a copy where she has filed with regards to the same on 24. Sir, is on copy. And I ought to make lot of gallant exercise and jugglery with regards to the text and embellishment of the so-called it is covered under judgment, wherein like I went to the human resource and various authorities. to
Human
do that,
rights.
like, yes,
Not resource, yes.
Human Rights Commission kindly see Annexure G. And with regards to the missing complaint, Annexure F, that being a male,
Your complaint is not taken?
my complaint was taken and only the missing complaint was been registered. The human
So
rights,
Who went missing?
my aged parents who have been beaten in search of me.
You have not registered the complaint?
Yes, I have registered the complaint.
Then action will be taken in that also. FIR ಆಗಿಲ್ವಾ ಅದು?
FIR ಆಗಿದೆ. ಅವ್ರದ್ದು 2 FIR ಹಾಕಿದ್ದಾರೆ. One in Mangalore police. Yes, my lords. One in Mangalore police and one before the Visakhapatnam on 24/3. So subsequent complaints with regards to the same things where they have set the criminal law in motion. And whereas coming to the 354.
ಅದು 376 ಹಾಕಿರೋದು ಆಂಧ್ರ ಪ್ರದೇಶಲ್ಲಿ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Same
offense.
ಯಾಕೆ ಎಲ್ಲೆಲ್ಲ ಹಾಕ್ತೀರಾ ನೀವು?
No, 376 is not registered.
ಅಲ್ಲಪ್ಪ ಆಂಧ್ರ ಪ್ರದೇಶಲ್ಲಿ.
When she visited to native place, my lord,
Allon-
then he has harassed there.
It's a mere.
ಎಷ್ಟು ಕಡೆ ಹಾಕ್ತೀರಾ ಸೇಮ್ ಕ್ರೈಮ್ಗೆ?
No, my lord, the first it is, my lord, happened at Mangalore, where she is working. And later, my lord, when she visited to parents' house, again, my lord, he started to do the same thing.
Kindly peruse. I'll read out the text and embellishment of the complaint. Page number 16, Annexure B.
What happened to your complaints?
My complaints is static. ನಮ್ದು ಯಾರ್ದು ಗಂಡ್ ಮಕ್ಳು ತಾನೆ. We don't.
Yes,
nobody
which
will-
are the FIR numbers? ನಿಮ್ದು?
My FIR number is 97 of 2023.
97. What is the investigation? ಏನಾಗಿಲ್ವಾ?
ಏನೂ ಆಗಿಲ್ಲ. It's static.
That is only missing of their parents.
ಆಮೇಲೆ?
ಅದು ಒಂದೇ. Human Rights Commission ಅವರು even they have not taken any action. And even the FIR that is recently, after filing FIR in Mangalore, another FIR in crime number 120 dated 24/3/2023. Even that is static. ಏನೂ ಆಗ್ತಾ ಇಲ್ಲ. It's a complete.
ಯಾವ್ದು
abuse of-
ಹಾಕಿದ್ರಿ ನೀವು? Which is the second crime?
Same crime filed by the first.
ಅವ್ರದಲ್ಲ ಸರ್. ನೀವು ಒಂದು ಇನ್ನೊಂದು ಸ್ಟಾಟಿಕ್ ಅಂದ್ರಲ್ಲ ಯಾವ್ದು?
After my complaint.
After your complaint, my
What is that?
parents went missing with regards
ಅದಾಯ್ತು.
to
ಆಮೇಲೆ ಇನ್ನೊಂದು ಹಾಕಿದೀನಿ ಅಂದ್ರಲ್ಲ?
only to the Human Rights Commission.
ಅಷ್ಟೇನಾ?
ಅಷ್ಟೇ, ಬೇರೆ ಎಂತ.
The-
And
Anything else?
with regards to the judgment that is.
ಕೊಡಿ ಸರ್. Yes. ಇಲ್ಲಿ ಏನೇನಿದೆ? 354D ನಾ?
ಹೌದು ಸರ್.
ಸ್ಟಾಕಿಂಗ್.
He's having photographs, videos, my lord.
It's an axiomatic claim.
Huh?
ಅವ್ರು ಮಾಡ್ತಾ ಇರೋದು it's an axiomatic claim. sir.
Yes. The petitioner.
Even state also filed vacating.
ಅದೇ ನೋಡಿದೆ ಮೇಡಮ್. The petitioner, the sole accused in crime number 18 of 2023 stands at the doors of this court, calling in question the registration of the aforesaid crime for offense punishable under section 354A, 354D, 323, 384, 504 and 506 of the IPC. Heard so and so. It is the case of the complainant that the complainant and the petitioner meet on a dating app called Bumble. They develop relationship and did have a physical relationship for close to a year. Close to a year.
3 months.
Close to 3 months. The relationship turns sour and the complaint emerges at 2 jurisdictions, one before the Andhra Pradesh, one in the state of Andhra Pradesh and one before the jurisdiction police at Bangalore. The subject petition concerns registration of a crime in crime number 18 of 2023 for the aforesaid offences. The police then begin to investigate the matter and the petitioner is at the doors of the court calling in question the said investigation. This court had granted an interim order of stay and the investigation has not progressed any further in the light of the interim order of stay in crime number 18 of 2023. The learned counsel for the petitioner submits that there is the crime. So the parents of the petition, the father of the petitioner was beaten black and blue by the police on the instructions of the complainant, who is a doctor, who was a doctor and the petitioner, you knew doctor, who was a colleague at the KMC hospital at Mangalore or another?
Mangaluru.
KMC hospital, Mangalore. Therefore would submit that the consensual relationship between the two is projected to become plethora of offences as indicated here in above.
They are not colleagues.
Oh, you're buried,
They were
doctor.
working in the same department.
It's all right, leave it. Yes, so and so. The learned counsel for the petitioner would contend that the registration of the crime itself is an abuse of the permitting registration of the crime itself was an abuse of the process of the law, and if it is permitted to be investigated into, would undoubtedly result in miscarriage of justice. Therefore, would submit that the crime must not be permitted to be continued. He would seek to place reliance upon the judgment rendered by this court in criminal petition 8596 of 2024, which had obliterated the crime under 354D of the 354D of the IPC. The learned counsel Kashinath JD, appearing for the petitioner, would refute this. Appearing for the complainant, would refute the submission, contending that there is no allegation made by the petitioner of promise of breach of promise of marriage or repeated rape. It is the acts of the present petitioner of threatening the complainant to circulate the intimate photographs or videos that are in his possession and extorting money on the said score. The complaint comes to be registered only on the harassment meted out by the petitioner and not on any other score. The learned counsel submits that the crimes registered by the complainant, by the petitioner, also could be investigated into. It is no law that just because the crime that the petitioner has registered is not investigated into, the crime registered by the complainant should not be investigated into. The learned counsel submits the matter is still at the stage of crime. It needs investigation in the least in the teeth of the offences that are found. The learned counsel, learned HCGP Wahida would also toe the lines of the counsel appearing for the complainant in contending that the investigation in the case at hand is in the least necessary. I have given my so and so. Therefore, narrated facts are not in dispute. Therefore, narrated facts are a matter of record. They would not require any reiteration. The entire issue has triggered from the registration of the the relationship between the petitioner and the complainant is a matter of record. The relationship turning sore is again a matter of record. The entire issue triggers from registration of a complaint on 1/3/2023. The complaint reads as follows, page 16. The moment the complaint is registered, the petitioner is before the court and there is an interim order of stay granted on the score of consensual acts between the two. The acts may be consensual with regard to the physical relationship between the complainant and the petitioner. That does not mean that it becomes a license to the accused for indulging in all acts that are alleged in the complaint, which would prima facie meet the ingredients of the offences.
She's already married, my lord.
No problem, sir. Prima facie meet the ingredients of the offences. In such a circumstance, when the issue is still at the stage of investigation and is shrouded with seriously disputed questions of fact, there is no warrant for this court to interfere or interdict investigation in the case at hand, reserving liberty to the petitioner to knock at the doors of this court. Insofar as the judgment relied on by the learned counsel appearing for the petitioner, that was after a full-blown trial, a full-blown proceeding. The offence of stalking was not met in the said case. That would not become applicable to the facts obtaining in the case at hand, which is at its nascent stage. In that light, the reserving liberty to the petitioner to knock at the doors of this court in the event a final report is filed and the final report would go against him, the petition stands rejected. Yes.
Number 4.
Please. The registration of the crime is under challenge. The offences.
Oh, offence, sir.
69.
69.
Please. This honorable court has granted interim order and it was extended the last two occasions.
I said,
My Lord, may kindly turn to page 18 is the complaint. But they were previously colleagues.
What do you mean previously colleagues?
Thereafterwards, my Lord, there was a development of the
Development?
relationship between them, and the narration in the complaint
Then crime charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ crime stage ಅಲ್ಲೇ ಇದೆ. And what she alleges, my Lord, on 13/11/2024, which is in the second page of the complaint, where it is boldened, that's the only day wherein both of them had into physical relationship. Lord, 5 dates wherein the respond number 2 has make out to lodge this complaint. Around 5/8/2024, they were introduced, and 7/9/24, the petitioner has introduced the respond number 2 to his family. And on 13/9/24, my Lord, he has left to US, wherein the respond number 2.
Why did the talks break?
Lord, the respond number 2 is a Muslim, and
ಅದಕ್ಕ
Adu.
And
And once
160
that is one of the reason. And taking into consideration, my Lord, by enlarging the scope of whatever happened between them, my Lord, she lodges the complaint after 5 months. It is 17/3/2024-25. This is the only day wherein she narrates. 17/3/25 is the day on which the report was lodged to the police.
Yes, madam.
Madam, your lordship, the thing is, the respondent number 2 and petitioner knew each other from 2023 as a colleague. And both are from Bengali background, but from different states, not from West Bengal. And she has left the company in the month in 2024. After she has left the company, respondent has petitioner has approached the complainant, respondent number 2. And from 31st/8/2024, their relation has started, love affair relation that has started. And on 13/11/2024, they have physical relation, your lordship, and there are and it has started on the pretext of marriage only from the very initial stage. It is there. We have produced all the documents regarding his chat for interfaith marriage within 7 days. Within 7 days of proposal, and there is only 1 day intimacy because of this promise of marriage, your lordship. He has given one ring also. That also he has not.
Ring,
platinum ring.
Ring.
She was ready with the platinum ring.
That one also
Many
not
things has
returned
been
him.
narrated.
After I have filed the first complaint in the month of February, he has returned some of the amount he has used in USA.
All right, please.
This thing.
Yes, sir.
Please, my Lord.
Investigation agli.
Even reading of the complaint, my Lord, whether he was having such a dishonest intention from the inception.
It is there, your
My Lord,
lordship, in page 49.
only on 1 day, at 13/11/24, if they, I mean, were into physical relationship, and subsequently, my Lord, if she turns,
It is he who told because of mother.
whether this would suffice to.
Grandmother.
Is 69 376?
ಇಲ್ಲ ಇದು 69 ಇದೆ ಮತ್ತೆ and threatening ಇನ್ನೊಂದು 2 offenses are
ಅಲ್ಲ ಅದೆಲ್ಲ
351 350
ಅದು 504 506 ಇಲ್ಲದೆ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಲ್ಲ.
69 only. But whether this would attract
and from the very first day they were new, they
and in
are
fact,
from different religion.
2 judgments of this honorable court only.
We'll see. Yes.
May I pass it on?
List on 7th will dictate. Yes. List on 7th at 4 p.m.
Lordship, I may be allowed to file any synopsis of this case.
ಇದಿಲ್ಲ ಏನ್ ಸಿನಾಪ್ಸಿಸ್ ಇದೆ ಮೇಡಮ್?
Synopsis.
69 ಅಲ್ಲಿ what synopsis you want to file? Yes.
Interim order of fixed.
That will continue. Yes.
Good.
Number 5.
In this matter, my lords, my senior is engaged, my lords, Mr. Prasanna Kumar.
Sudanwa is your senior.
No, no, my senior, Mr. Prasanna Kumar, my lords, is engaged. He's been hospitalized, my lords. Kindly have it, my lords, in the next week. A date may be
Let's
fixed.
after 2 weeks.
Lords, interim order.
Tomorrow continue. Next.
Right.
Seal number 6.
So the respondent number 2, my lord.
Vacating stay. No, what's the offense?
My lord, it's 318 subclause 3 and 31336 subclause.
Yes, madam.
I am 73 years old, my lords.
Does not absolve you from offense. Offense ಏನು ಹೇಳಿ?
Offense ಏನಂತಂದ್ರೆ ಸ್ವಾಮಿ, my lords, like I have, respondent number 2 is my second daughter. And petition number 2 is my first daughter, my lords. My husband passed away on 17/3/2000. My husband passed away on 17/3/2015, my lords. And respondent number 2 left to Singapore in December 2009. From December 2009 to mid of January 2016, I and my husband were staying at my daughter's, that is respondent 2's house, and taking care of her property and paying all the property tax. And also she used to compel us to repair the house, which my husband did, my lords. Later on, after my husband passed away, I was residing there, my lords. In the month of January 2016, she sent some broker saying that, Amma, please do signature on all the papers wherever your signature wherever this guy says. So according to her instruction, I have signed the papers. I don't know who has signed the affidavit of the respondent number 2, even petitioner number 2 also, my lords. Petitioner number 2 is not aware of this transaction at all, because petitioner number 2 is staying with her husband and in-laws in her house. So later on, my respondent number 2, my daughter, she threw away from the house, my lords. And
Whose
I
house?
was constrained from her house. And I was constrained to stay in the house built by my husband in the year 1949, my lords. So she has initiated the original suit 5900, partition suit 590024 on 17/8/2004, my lords. So here, my lords, after filing this suit, she has been harassing me in one or the other way, my lords. Adu nanira mane bandu 45 ವರ್ಷದ old, my lords. I have produced the photographs of the house also, conditions of the house also. And respondent number 2 is living in Singapore. She owns 2 houses and she is a qualified engineer. I am 10th past, my lords. And recently, my lords, here I'm filing this memo.
ಏನು ಹೇಳಿ?
She has taken stay
In which petition?
in OS, my lords.
OS.
She has taken stay on even my pension account, my lords. Now I have, ನನಗೆ ಏನು ದುಡ್ಡ ಇಲ್ಲ, my lords, ಇವಾಗ ಬದುಕಲಿಕ್ಕೆ. ಈಗ ನನ್ನ ಮೊದಲನೇ ಮಗಳ ಮನೆಗೆ ಹೋಗೋಣ ಅಂದ್ರೆ her in-law, her old age in-law is staying along with her, where I'm not able to live. I was leading my life respectfully in this old house. Even she has brought the stay. Now I am left with no money and suffering to stay, my lords. With all these grievances, just nan 10th pass ಆಗಿರೋದು, ನನಗೆ ಇದು ಟ್ರಾನ್ಸಾಕ್ಷನ್
ಅದಕ್ಕೂ ಇದಕ್ಕೂ ಏನು ಸಂಬಂಧ ಮೇಡಮ್?
ಅಲ್ಲ, ನನಗೆ ಇದು ಟ್ರಾನ್ಸಾಕ್ಷನ್ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಏನನ್ನೋದು ನನಗೆ ಗೊತ್ತೇ ಇಲ್ಲ. ಈಗ ನನ್ನ ಮೇಲೆ ಫೋರ್ಜರಿ ಮಾಡಿದ್ದಾರೆ ಅನ್ಬಿಟ್ಟು ಇವರು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದ್ದಾರೆ, ಮೈ ಲಾರ್ಡ್ಸ್. ಅಂಡ್ ಪೊಲೀಸ್ ಆಲ್ಸೋ ಹರಾಸ್ಡ್ ಮೀ ಎ ಲಾಟ್, ಮೈ ಲಾರ್ಡ್ಸ್.
ಹೌದು, ಅವ್ರು ಯಾರಿಗೆ ಬೇಕು ಅವ್ರಿಗೆ ಹೆರಾಸ್ ಮಾಡ್ತಾರೆ, ತೊಂದರೆ ಇಲ್ಲ. ಅವ್ರಿರೋದೇ ಅದಕ್ಕೆ. ಕಂಪ್ಲೇನೆಂಟ್ ಯಾರಿಗೆ ಹೆರಾಸ್ ಮಾಡಕ್ ಹೇಳ್ತಾರೆ ಅವ್ರಿಗೆ ಮಾಡ್ತಾರೆ.
Kindly look into the photographs, sir, my lords. Also in original suit, my lords. Just one more submission, my lords. In original suit also, she has in page number 57, my lords. You can see even she has claimed my jewelry. Nan my mele hakira odvenu saha hakidare, my lords. And she and in OS, my lords, you can see that she has stated all the the FDs or anything which were in the names of my husband. She know everything. I don't know about this documents at all. She has taken away all the documents. ಯಾವ್ದು ಇವಾಗ ಇದಾಗಿದೆ ರಿನವಲ್ ಆಗಿದೆ ಅದ್ ಮಾತ್ರ ಬ್ಯಾಂಕ್ನವ್ರು ನನ್ನನ್ನು ಕರೆದ್ರು ನಾನು ಮಾಡಿಸಿದೀನಿ ಅದು ಇಟ್ಟಿದ್ದೀನಿ ಯಾವುದೇ ರೀತಿಲಿ ಯಾವಿದನ್ನು ನಾನು ಅಲಿನೇಟ್ ಮಾಡಿಲ್ಲ my lords. See the atrocity she has done to me my lords. ಅದಾದ್ಮೇಲೆ my lords to mediation ಅಂತ ಕರೆದ್ಬಿಟ್ಟು they are not turning up my lords. They are making me to wait in the mediation center. Yesterday also I had gone. They have not turned up, saying one or the other reason. They are harassing me like this, my lords. I am very innocent in this for whatever the document, whatever the transaction has
Yes, sir.
happened.
ಸಾಕು.
The issue only boils down to one particular document.
Mike.
Well, as the issue only boils down to one particular document, which has been produced to the statement of objections, annexure R2, my lords.
Very good.
Whereas my father expired in 2015. There comes to be a certain amount of assets that he has left behind. One pertains to two properties, one which property already my mother has sold in 2024 without even obtaining any signatures or anything from me. The second property, what happens is she's gone and got the entire property transferred into her name. Now she has produced certain documents to
Whose name, sir?
to her name.
Mother's name.
Yes.
ಇನ್ಯಾರಿಗೆ ಬರ್ಬೇಕಾಗಿತ್ತು ಸರ್?
My lords, I am entitled to that share, my lords.
ಬರ್ಲಿ ಆಮೇಲೆ.
No,
Yes.
my lords,
Anything else, sir?
No, my lords, it's very, the document is right in front of my
Very good,
lordship.
sir. Yes.
Annexure R2, my lords,
I will permit malicious prosecution to be initiated by the mother against you now.
My lords,
That is going to be the order.
No, my lords, my lordship could kindly look into this document.
Yes.
My lords, in the passport, I was not even present in India.
Anything else,
No,
sir?
my lords, 1 minute. My lords, the document that has been produced, my lords, and annexure R2 clearly states that when this document came to be executed, my signature which is present there, I was not even in India. From 2009, I'm residing in Singapore, my
Very
lords.
good.
My entire passport details have been given.
Absolutely.
Now, what comes to here is there is about 1.5 crores of FT amount which has been left by my father. There are two properties, my lords. Now, my mother goes and gives an affidavit of declaration impersonating my signature saying that I have permitted her to get the kata exchange in her name. Now, this is what is the issue that stands at large. I have filed an OA suit. If my lordship, if it comes to the concept that I have not been taking care of my mother, my lordship could kindly peruse exhibit R8, my lords, at page number 51. From the year 2018 onwards, financially I've been supporting my mother. It is
Very
not
good.
that I am not derived from that obligation of not supporting my
Oh,
mother.
great daughters.
No,
Yes.
my lords, the only issue is when my sister and my mother conspicuously try to get some document executed, infringed only for the purpose of deriving me of the assets which particularly belongs to me, that is where the issue crops up. Well, this is very preliminary stage. It's a premature stage. Let the documentation go for any kind of a forensic investigation to show that the signature is mine. The only defense what they have adopted is they say that the document was sent to my house. They asked me to sign it. I have signed it at the instigation of respondent number 2. My lords, I'm not even completely aware of it. Only after I file my original suit in seeking partition, I come to know that the property has been transferred to my mother's name. Under what? Under a document which they claim that I have signed. There was no necessity for me
Mother
to
is
sign.
entitled to get it, sir.
She's entitled, my lords. We are not denying the share that she's entitled. In the partition also, I have claimed only 1/3 share. But that does not give her the rights to infringe my signatures and get the
Absolute.
entire property transferred into her name. my lords.
Anything else, sir?
No, my lords,
Yes.
there is a clear document which needs to go for an
Absolutely.
investigation, my lords.
The-
I say
Yes,
that
sir.
leaving all the other merits outside, my lords,
Yes,
I
sir.
say a document has been created, it's been fabricated.
Very good, sir.
My sign is appeared on it, which I have not signed. Well, there is a motive in that to say that the
Absolutely.
property had to be sold. Let that go for an investigation, my lord. Let them approach this court after a charge sheet is filed.
Perfect.
This is a very preliminary stage, my lord.
Very good, sir. Yes.
Even my lords, I had gone
Anything
to
else,
human
sir?
rights also, in elderly helpline also, my lords. No, I
Lords,
did
there
not
is
get
1
any
crore
help
50
anywhere,
lakhs
my
of
lords.
Fixed deposit.
And it is
Singapore,
there
sir.
only, it is
Stay in
laying there
Singapore.
only,
My
my
lords.
lords.
My lords, there was 1 crore 50 lakhs.
Sitting in
laying there
Singapore,
only,
you're,
my lords.
don't try to interfere here.
No, my lords, when there is a document in which
We'll
I've got
see,
a
sir.
share in that
We'll see,
property, a sign has been given to the extent the kata could be transferred. There's a document before your lordship. Let
Yes.
that go for an investigation, my lords. My
Absolutely.
lordship
Very
will
good,
get to know
sir.
what is
Very
the
good,
actual
I will
truth
direct
behind it.
investigation into the complaints that are registered by the mother against you now.
My lords.
That
the-
I'm going to write
Yes, my lords. The only intimation
definitely I'm
there
going to
was,
write.
I was trying to intimate and
No,
say that
that's
this
enough.
case is
Why
pertaining.
crime is not registered against the daughter? I will
My
now
lords, there is
take
no
them to
ingredients of crime.
No problem,
No,
sir.
my lords, what she says is this is an counter blast to the complaint which I
Correct,
have
sir.
given.
Let that also be investigated
My lords,
into.
let this also be investigated.
No.
What I'm saying is, no, my lords, there is a document which is there before my lordship. Please consider
Anything
it,
else,
my
sir?
lords. My lords, be considerate of the fact that
Anything
there is
else,
a
sir?
document which we say that the entire allegation in that document is that there is no signature pertaining of mine which exists there. My lords, that has to be looked into, my lords. Of course, the mother and the daughter relationship is bound and it is binding. But my lords, please give it at least at the stage where an investigation could be conducted
And
by
you
respondent
want,
number 1.
the acts of crime to divide it? We'll see, sir. Yes.
My lords, there is a
ಸುಮ್ನೆ
prima
ಮಾತ್ರ
facie material which is existing.
actions
my lords.
speak louder than words, sir. ಮಾತಾಡೋದ್ರಲ್ಲ.
My lords, it's not about that. All that I'm trying to say is there's a document, my lords, in which I'm saying
I
I was
think
not even in India
more
when
I
when the
hear
document.
about, more I hear about this, I'll impose costs now. Yes.
My lords, I've even produced
The
passport
petitioner
copies.
is the petitioners are accused 1 and 2 are before the court calling in question the registration of a crime in crime number 182 of 2025, registered by the daughter of the first petitioner and the sister of the second petitioner. The heard so and so. The facts enumerated are as follows. The petitioner is the wife of one Vasantarangan, who dies in the year 2015, is it?
Yes, my lords.
Who dies in the year 2015, leaving behind 2 daughters and several properties or fixed deposits, as the case would be. The mother obviously was entitled to the properties that were left by the husband, unless it was separately bequeathed. The petitioners are said to have created certain documents which comes to the knowledge of the second respondent complainant, who does not reside in India but resides in Singapore, married and resides in Singapore. On allegedly coming to know of creation of certain documents, a complaint comes to be registered on 22/10/2025 from Singapore, communicated to the jurisdictional police of certain fraudulent transactions, alleged fraudulent transactions, unauthorized transfer of the khata in the name of the mother of the properties that belonged to the father. The police has issued certain notices to the petitioner, and all of this same time either.
ಹೌದು my lords.
ಅಲ್ಲ ಸಿವಿಲ್ ಸೂಟ್ ಯಾವಾಗ?
Civil
Civil
suit
suit
to
is
17/8/2024.
Before the registration of the complaint, this very complainant has instituted a civil suit in OS 5900 seeking partition of the property, and on the same breath and for the same reason or on the same grounds has set the criminal law into motion as observed herein above. The registration of the crime has driven the petitioner's mother and the daughter, the mother and the sister of the complainant, before this court in the subject petition. This court has granted an interim order of stay to protect interim order of stay, and the same is in operation even today. The respondent has preferred an application seeking vacation of the interim order, and therefore the matter is heard. The learned counsel appearing for the petitioner, the mother and the sister, would contend that the complainant sitting in Singapore is wanting to influence the police here and has created complete harassment or left the mother in the lurch. At every stage, she has been harassed and takes this court through the photographs of certain people stalking the house, or the person stalking the house, or the police interfering with the possession of the mother, notwithstanding the fact that she is 73 years old. And insofar as the sister is concerned, the learned counsel would submit that she has nothing to do with with the allegations, as she is married and resides elsewhere. So therefore, for the sake of property which the mother was entitled to in law, the daughter has created serious problems to the mother, and would therefore submit that if this is permitted to be continued, it would become an abuse of the process of the law. The learned HCGP, however, would submit that if this court would permit investigation, they would investigate into the matter and file their final report as the case would be. I have given my anxious considerations. The afore narrated facts are not in dispute. Are not in dispute, or rather a matter of record. The petitioner, the first petitioner, is now a septuagenarian. The second petitioner is about 50 years. The two have a relation with the complainant. The relation is that the second The complainant is the daughter of the accused number 1, sister of accused number 2. The tussle now is with regard to the property or the fixed deposits or even the gold that is left with the mother, the first petitioner, accused number 1, which comes to her on the death of the father, the husband, one Vasanta Rangan, on 17/3/2015. The desire for taking the property crops up all these problems. The complainant who did not reside then nor that does reside now in the shores of this nation, sitting at Singapore, institutes a suit in OS 5900 of 2024. The prayer in this suit is as follows. The items sought to be partitioned in the suit is for partition. The items sought in the partition is as follows, page 52 to 59. This suit is pending adjudication before the concerned court. After the institution of the suit comes the impugned crime. The crime is registered on the score that the mother has taken kata in her name on the death of her husband. It is obvious in law that she would be entitled to. Nonetheless, the unauthorized transfer of kata is projected to become a crime by registering one on 23/2/2025. The complaint reads as follows, page 17 to 19. After the complaint begins the harassment to the mother. The mother fouls cry of goons coming near her house and the police repeatedly harassing her, complains it to the commissioner Kotter complaint. Complains it to the police commissioner on 23/10/2025. The complaint reads as follows, page 92 to 95. The daughter does not keep quiet. Again, appears to have spoken to the police and created a ruckus near the residence of the petitioner, the accused number 1, the mother. Therefore, the petitioner then calls up the elders helpline. The call recording reads as follows, page 100. Not stopping at that, the petitioner, accused number 1, also complains to the Karnataka State Human Rights Commission on the strength of the photographs that are produced along with the complaint. Even then, nothing is done. What the police would do is only investigate into the complaint of the second respondent complainant, which the police ought not to have registered the crime even, as the issue was purely civil in nature. Civil suit was pending. A partition is pending. Partition of the property is sought for before the concerned court. It is unnecessarily the police poke its nose into the affairs of a family in a partition and create this problem, that too between the aged mother and the daughter who is wanting the share of a property. If the daughter is wanting the share of the property, it is rightly so before the concerned court in OS 5900 of 2024. Intimidating the mother or the second daughter for parting with the property by registering the crime cannot be countenanced. It is a fit case where the mother must be permitted to initiate proceedings for malicious prosecution against the daughter for having harassed the 73-year-old mother with the support of the police in registering a crime which on the face of it is purely civil in nature. I leave it open to the discretion of the mother if the mother is wanting to initiate malicious prosecution against the daughter, while these proceedings cannot be permitted to stand even for a minute. Therefore, the allowed cost.
Obliged.
7.
Complaint, my lord, deposited, my lord, and file it in the registry.
IA number 2 of 26 for vacating stay, my lord.
Yes, sir.
15,000 interim maintenance has been
ಇದನ್ನೇ
granted.
ಮೂವ್ ಮಾಡ್ತಿರೋದ ನೀವು? Yes, sir.
My lords, I've deposited, my lords, I've filed it in the registry. My lords, it may be taken up, my lords, in the next
No,
week,
no,
any
no,
day.
no, adjournment ಮಾತ್ರ ಕೇಳ್ಬೇಡಿ vacating stay ಅಲ್ಲಿ.
My lords, I've sought
Yes, sir.
some documents, my lords, any date may be fixed.
No
in the next
date
week.
fixing, sir. You tell me what's on the merit.
My lords, because my lords, there's
No
another-
adjournment, sir. Period. Come on, merits.
My lords, one submission.
You are the husband, ah?
Please, my lords, husband.
Yes,
My
sir.
lords, one submission. My lords, there is another, my lords, petition filed. My lords, challenging the FR, my lords, by husband and family. My lords, the stay is granted, my lords, only to the family member. My lords, in total, there are 6 members. Against husband, my lords, there is no stay. My lords, from 3 years, my lords, the matter is pending. I request, my lords, both the matters may be taken up.
No,
my lords,
sir, I
any
won't.
day.
Request rejected. Come on.
My lords,
All sorts of indirect adjournments will not entertain.
my lords, may
Come
I
on, come on.
request At least for tomorrow, please.
Come on, no, sir. Come
My
on,
lords,
merits.
I sought for, my lords, some documents, my lords.
No
Tomorrow-
documents, sir.
My lords, from,
We'll go by the order of the court. That's all. Come on, come on.
my lords, because, my lords,
No, unless, yes, sir. ನೀವ್ ಹೇಳಿ. What's the matter?
My lord, the husband is a software engineer. My lord, their marriage performed on 10/9/2023. And the very next day, what is the 11/9/23, he undergone surgery for his genitals at Bangalore. And my lord, she was been deserted from since 2023. And my lord, she also filed a criminal case that is also pending before the concerned court at Tiptur. And the petitioner is in a software engineer earning more than 3 lakhs per month. His father is a principal at a government college in Tumkur.
Yaru? Father?
A father of
Father
the
irli.
petitioner.
What's the wife?
Father of the
Wife works?
wife is a BCom, MCom holder.
No, no, she's not working.
She is not working.
Why?
She, soon after the marriage, soon after the completion of course, she married.
So after marriage, she was asked not to work?
Not work. She is in Tiptur itself. Apart from
ಈಗ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 15,000
15,000.
15,000. I submit this, my lords. At the time of filing of the petition, my lords, she was working. My lords, I produced document to that effect, my lords. And also, my lords, the father-in-law of the, my lords, the complainant, my lords, he was retired. My lords, what she does, my lords' wife, she goes before the administrative office. My lords, she says that, my lords, any benefit should not be given to him because a criminal case is pending against him. My lord,
ಫಾದರ್ ಇನ್ ಲಾ ಬರ್ತಾ ಇದೆಯಲ್ಲ?
my lords,
ಫಾದರ್ ಇನ್ ಲಾ ಪೆನ್ಷನ್ ಎಲ್ಲ ಬರ್ತಾ ಇದೆಯಾ?
no, my lords, they have stopped it, my lords.
ಕರೆಕ್ಟ್. ಅದನ್ನ ವಿಲ್ ಡೈರೆಕ್ಟ್ ನಿಮ್ ಸ್ಯಾಲರಿ ಅಟ್ಯಾಚ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ.
No, my lords,
ಈಗ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ?
My lords, I'll give, my lords.
ಯಾವಾಗ?
My lords, I already deposited, my lords, 1 lakh.
Where? What's the arrears?
Before the trial court. Before the trial court, I have deposited.
Wait. Arrears?
Arrears almost in 1 lakh.
1 ಲಕ್ಷ ಡೆಪಾಸಿಟ್ ಮಾಡಿದಾರಾ?
1 lakh deposited on 26/5/26.
26/5/26. ಸೊ ಅದು ವಿಡ್ರಾ ಮಾಡಿದೀರಾ?
ಇಲ್ಲ ಮಾಡಿಲ್ಲ. ನಮ್ಮ
ಮಾಡ್ಬಿಡಿ.
permission.
ಅದು ಮಾಡ್ಬಿಡಿ. ಅಂದ್ರೆ ಅದಕ್ಕೆ ಬರೀತೀನಿ ನಾನು. ಎಸ್. ಇನ್ನೊಂದು ಲಕ್ಷ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಸರ್?
I'll check your instructions, please.
No instructions, sir. You will dismiss it right away. Which company are you working?
TCS company bank.
TCS, sir. Yes, sir. I will pass a judicial order, TCS, to stop your salary.
No, my lords, I'm only
Straight
requesting
away.
for, my lords, I'm only requesting for tomorrow, please, my lords. My lords,
Interested in?
My lords,
Only interested in?
no, my lords, I'm only requesting for tomorrow, my lords.
No, I am not grant, sir. No time at all.
Maybe disposed of tomorrow.
I will direct TCS to stop your salary now.
My lords, in the statement of affidavits and liabilities.
Don't
filed by
worry
my-
about that, sir. Don't worry about it.
My lords, only for a moment.
Your salary slip ಎಲ್ಲಿದೆ?
ಕೊಟ್ಟಿಲ್ಲ sir.
Your salary slip ಎಲ್ಲಿದೆ?
ಕೋರ್ಟ್ಗೆ ಹಾಕಿ.
ಮತ್ತೆ ಕೋರ್ಟ್ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಕೊಟ್ರು?
It is admitted fact that he is working in TCS and he is drawing some of rupees 3 lakhs.
Who admitted it?
My lords,
ಎಲ್ಲಿದೆ?
my lords,
ತೋರಿಸಿ.
it was ex parte.
Wait, sir. Yes.
It was stated that the petitioner has a handsome salary of 3 lakhs. And
Petitioner is handsome or salary is handsome?
handsome salary of rupees 3 lakhs. And he is in a software engineer working abroad. And the father of the petitioner is in a principal at a government college, degree college, Tumkur. And he is also drawing a sum of 3 lakhs. He is the only son. Apart from that, they have several landed properties at Tumkur.
Anything else?
No, my lords, in the statement of assets and liabilities, my lords.
For your conduct of not paying till now, we will dismiss it.
No, my lords, my lords, this honorable court, my lords, has asked me to deposit 1 lakh, my lords. I have deposited, my lords.
ಈಗ ಮಿಕ್ಕಿದ 1 ಲಕ್ಷ ಯಾವಾಗ ಕೊಡ್ತೀರಾ? ನೆಕ್ಸ್ಟ್ ವೀಕಾ? ಇಲ್ದಾರೆ
Not
ಸ್ಯಾಲರಿ
three-
ಅಟ್ಯಾಚ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ TCS ಅಲ್ಲಿ.
It's not 3 lakhs, my lords. My lords, I'll check your instructions with
ಎಷ್ಟಾರು
regard to
ಇರ್ಲಿ.
that regard, my lords, because my lords,
The petitioner and the respondent complainant shall file their respective assets and liabilities before this court as obtaining yesterday. This court on 21/4/2026 had passed the following order. Pursuant to the order, the petitioner is said to have deposited rupees 1 lakh. The contention is that the husband earns about 3 lakhs working as a software engineer in Tata Consultancy Services -TCS. The salary is said to be close to 3 lakhs per month. Therefore, if the petitioner shall deposit the arrears of rupees 1 lakh by Friday the next, list on 31st in the fresh matters list. The 1 lakh deposited before the concerned court shall be permitted to be withdrawn by the respondent wife without broking any delay or any delay by the concerned court on production of the account details by the wife. List the matter on 31st, subject to the aforesaid interim order idea.
please.
Subject to the aforesaid interim order continues till the next.
Education expenses is not.
ಅದಾಮ್ ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೇಳ್ಬೇಡಿ, ಒಟ್ಟು ಒಂದೊಂದಾಗಿ ಕೊಡುವ. ಈಗ ಒಂದು ತಗೊಳ್ಳಿ, ಇನ್ನೊಂದು ಕೊಡುವ, ಆಮೇಲೆ.
One submission, please. May I request, my lords, it be listed with 7355 of 24.
ನೋ ಸರ್, ಅದೇ ಬೇರೆ ಇದೇ ಬೇರೆ.
Please, my lords. My lords, the
ಅದು
difficulty
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬಿಡ್ತೀನಿ ಆಮೇಲೆ.
No, my lords, the only
ಇನ್ಲಾಸ್ಗೂ ಹೋಗ್ಬಿಡುತ್ತೆ.
No, my lords, the only difficulty is this, my lords. The sister of the petitioner, she is 29 years old. My lords, from 3 years, criminal case is pending against her. My lords, as marriage prospect, my lords, cannot be forwarded. Lords,
ಕರೆಕ್ಟ್ ಸರ್, ಅದಕ್ಕೆ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
My lords,
You
both
pay
my-
maintenance, I will quash everything.
My lords,
Sir, I have nothing against the in-laws, nor he would have anything against the in-laws. The husband should pay everything now.
please, my lords, by next date of hearing, my lords, we will file assets and liabilities. My lords,
And arrears.
please, my lords, arrears also, my lords, as your lordship directed. And my lords,
ಆಯ್ತು, ಟ್ಯಾಗ್ along with ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ.
much.
Two cows,
Lord, one is recovered. I can
ಇನ್ನೊಂದು
only,
ಕೌ ಬೇಕಾ?
Lord, ಇನ್ನೊಂದು ಅವ್ರ ಹತ್ರ ಇದೆ. If they return, we have no objection for closing this.
ಇದಕ್ಕೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್. What is all this?
Lord, I advise them.
What advise them? ಎರಡು ಹಸು 2 ವರ್ಷದಿಂದ ಮಿಸ್ ಆಗಿದೆ ಅಂತ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಅದಕ್ಕೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್, ಪೊಲೀಸ್ ಮಿಷನರಿ ವೇಸ್ಟ್.
Lord, what happened is I wanted to purchase 2 cows.
ಆಯ್ತು.
ಹೋದಾಗ ಇದು ಇವ್ರ ಹತ್ರ ಇದೆ ಅಂತ ಗೊತ್ತಾಗಿದೆ. Then on enquiry, we learned that.
ಅದು 2 years ಆದ್ಮೇಲೆ.
Lord, I was.
There should be some semblance. What is this, Venkatesh sir?
I have advised them.
ಎಲ್ಲದಕ್ಕೂ ಕ್ರಿಮಿನಲ್ ಕೇಸ್.
Lord, if they return one more, my lord.
ಏನ್ ರಿಟರ್ನ್ ಒನ್?
ಎರಡು ಅವ್ರ ಹತ್ರ ಇದೆ, ಒಂದು ಸಿಕ್ಕಿದೆ. ಒಂದು
ಸಿವಿಲ್
ಆಲ್ರೆಡಿ
ಸೂಟ್ ಹಾಕಿ. ರಿಕವರಿ ಆಫ್ ಕೌ, ಅದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್. ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ ಕಂಪ್ಲೇಂಟ್ ಮೇಲೆ. ಇಫ್ ದಿಸ್ ಇಸ್ ಮಿಸ್ಯೂಸ್ ಆಫ್ ಕ್ರಿಮಿನಲ್ ಜಸ್ಟಿಸ್ ಸಿಸ್ಟಮ್. 2 ಹಸು 24ರಲ್ಲಿ ಕಳುವು ಆಗಿದೆ ಅಂತ 26ರಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್. ಎಲ್ಲ ಪೊಲೀಸ್ ಮಿಷನರಿ, ಸರ್ಚ್ ಆಫ್ ಕೌಸ್. ಅಲ್ಲಿ somebody is killed someone ಅಂದ್ರೆ wait, we are searching the cows. What? ಅಲ್ಲ, not saying animal should not be searched. ಏನು ಅಂತ animal then ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ ಇದರಲ್ಲಿ, ನಿಮ್ದು ಪ್ರಾಬ್ಲಮ್. 2 years ಆದ್ಮೇಲೆ ರಿಜಿಸ್ಟರ್ ಅ ಕಂಪ್ಲೇಂಟ್. 2 years ಇಂದ 2 ಹಸು ಕಳೆದೋಗಿತ್ತು.
I had no idea who had taken it.
ಸೊ ಆಮೇಲೆ ಅದಕ್ಕೆ ಪೊಲೀಸ್ ಬೇಕು ನಿಮ್ಗೆ.
When my instructions are, when he went to purchase, same cows were shown.
ಓ, ಸೇಮ್ ಕೌಸ್
By one of the mediator. Then my lords,
ಅದೇಂಗ್ ಗೊತ್ತಾಯ್ತು ಸೇಮ್ ಕೌ ಅಂತ? ನೀವು ಕೂಗಿದ ತಕ್ಷಣ ಬಂತ?
photographs ಎಲ್ಲ ಇದೆ.
ಇಲ್ಲ, ಕೂಗಿದ ತಕ್ಷಣ ಬಂತ?
Photographs ಎಲ್ಲ ಇದೆ.
ಓ,
ಪೂಜೆ ಗೀಜೆ ಮಾಡಿ. Anyway, my lord, ಇನ್ನೊಂದು ಇಟ್ಕೊಂಡು ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ?
ಅದೇ 2 ವರ್ಷ ಬಿಟ್ಟು ಅದು ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಯಾಕೆ ಸರ್ ಅದೇಳಿ?
ಅಲ್ಲ, it was without.
ಅಲ್ಲ, ಹಸು ಕಳೆದೋಗಿದೆ ಅಂದ್ರೆ ಹಾಕಿ, ಹೆಂಗ್ ತಗೋಬೇಕು ತಗೊಳ್ಳಿ ಅದನ್ನ. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಅದಕ್ಕೆ. ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಲಾ? The petitioners accused, ಅಯ್ಯೋ ಅದಕ್ಕೆ ಏನ್ ಫ್ಯಾಮಿಲಿ ಪೂರ್ತಿನಾ? ಕೌ ಫ್ಯಾಮಿಲಿನಾ? ಫ್ಯಾಮಿಲಿ ಪೂರ್ತಿ. The petitioners are accused 1 to 4 now stand at the doors of this court calling in question registration of a crime in crime number 47 of 2026 on a strange circumstance. The complainant did own 2 cows. The cows go missing not yesterday but 24 months ago. The petitioner, complainant is said to have gone for purchase of cows stolen 24 months ago, runs to the police station, registers a complaint. The police, without any rhyme or reason, blindly register a complaint for theft that has allegedly happened on 18/8/2024 and register a crime on 26/3/2026. The moment the crime is registered, the police machinery is put to action against the petitioners for allegedly stealing a cow 24 months ago. Brand ಮಾಡಿದ್ರ ಅದ್ರ ಮೇಲೆ 24 months ago. The petitioners then rushed to this court seeking protective orders, and this court has granted an interim order of stay. It is shocking that the complainant registers a crime 2 years after the alleged missing of a cow, and the police, without any preliminary inquiry of when the cow has gone missing or how the petitioner is alleging that it is his cows or otherwise, blindly register the crime and issue notices to the petitioner for appearance. The police machinery or the criminal justice system is completely abused and misused by the complainant for on the specious plea of thieving of 2 cows, which he even today does not know whether it belongs to him or not. It is only his wild guess that they are missing since 2 years. Therefore, the cows must be with the petitioner. If this would be permitted to be investigated into, even it would be putting a premium on the complainant's registration of a complaint, and the story that he has twined that it was tied for grazing in 24 months ago and they did not come back to the house. So non-return of the cows to the house on the evening of 18/8/2024 has resulted in registration of a complaint 24 months later. If this is a classic illustration of abuse of the criminal justice system by the complainant and the police giving hand to such abuse. For the aforesaid reasons, allowed quashed.
Fine.
Petitioners.
This was a matter, my lords, where your lordships had heard last week regarding, my lords, a lease deed, my lords, of a cold storage unit. I am the tenant, my lords. I pointed out that essentially the complaint relates to arrears of rent, and a suit filed by me for possession is pending. So, I don't know.
Only one ಡ್ಯಾಮೇಜ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಒಂದು ಕಂಪ್ಲೇಂಟ್ ಇದೆ 75 ಲಕ್ಷ ನಮ್ಮಲ್ಲಿ ಇದಾಗಿದೆ ಮಿಸ್ಚಿಫ್ ಇಫ್ ಅಟ್ ಆಲ್ ಇಟ್
ಅದು ಅಲ್ಲೇ ಕೇಳ್ಬಿಡಿ ವಿಲ್ ಪರ್ಮಿಟ್
ಅಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ ನಾವು ಹಾಕಿಲ್ಲ
ಅಲ್ಲ ಆ ಸೂಟ್ ಅಲ್ಲಿ ನಿಮ್ದೇನಾದ್ರು ಕ್ಲೈಮ್ಸ್ ಇದ್ರೆ ಮಾಡ್ಕೋಬಹುದು ಅಷ್ಟೇ ಕೌಂಟರ್ ಕ್ಲೈಮ್
ಹೇಳೋದು
nothing else. So allowed quashed the any claims of the complainant against the husband.
ಅಲ್ಲಲ್ಲ against the
against the petitioner. ಈ husband and wife ಬೆಳಗ್ಗೆಯಿಂದ ಬರೀ husband ಬರ್ತಾ ಇದ್ದಾರೆ.
That my lord really so painful.
And the last 8 months ಇಂದ ಇದನ್ನೇ ಕೇಳಿ ಬರೀ husband wife ಬರ್ತಾರೆ. Yes.
Sometimes not even husband wife yet, in the 69 stage ಅಲ್ಲಿ ಇದೆ.
ಅದು 60 correct, ಅದು ಬೇರೆ. Because yesterday I saw a record number I proceeded fast only for this reason. 78 498A cases, yesterday listed. 78, all of 2025 and 26. Imagine the number that is being done.
We also pitch in, my lord.
Yeah, correct.
Where we shouldn't, we
Yes.
should bring about some
Any,
approach. Anyway.
any claims by the respondent complainant against the petitioner is, the complainant is permitted to register any claims any claims against the petitioner in a manner known to law. Allowed cost. Heard the learned senior counsel Vikram Huligold, senior counsel Uday Hulla, ಅದೆಲ್ಲ ಹಾಕ್ಬಿಟ್ಟು ಮಾಡಿ.
Let's
Serial
say
number
case
10,
encounter
husband,
case,
my
my
lord.
lords, investigated by two different investigators.
Two different,
Please.
two different.
My lords, yes, my lords, two different, my lords, but the parties are not same, my lords.
ಅಯ್ಯೋ ಮೇ ಬಿ ಸರ್ ಪಾರ್ಟಿ ಸೇಮ್ ಇರಕ್ ಸಾಧ್ಯನೇ ಎರಡರಲ್ಲಿ.
Allegations are of the same incident, my lords.
What is the date of the incident, sir? Date of registration of the crime 28/10/2019.
Yes, my lord.
ಇನ್ನೊಂದ್ರಲ್ಲಿ
My lord, 22.
Same day, my lords.
29/10.
22/10/2018, same day, my lord.
20.
My lord, same day, my lord.
28/10/2019.
Same day, na?
Please.
Different INV.
Yes, my lord, 294 is mine, 295 is theirs.
Case and counter case.
Case and counter, husband and wife.
Two
The
different.
petitioner. ನಿಮ್ದು ಹಾಕಿದ್ದೀರಾ?
Please.
ಎಲ್ಲಿದೆ?
But in the second case, my lord, 10.1, evidence ಆಗಿದೆ, my lord, charge ಆಗಿ evidence ಆಗಿದೆ.
ಬಹಳ ಸಂತೋಷ. ಕನ್ವಿಕ್ಷನ್ ಸೆಟ್ ಅಸೈಡ್ ಆಗ್ಬಿಡುತ್ತೆ ಆ ಗ್ರೌಂಡ್ ಅಲ್ಲಿ. The petitioners in both these cases are the accused in a case and a counter case. One 294 of 2025, 2019, and the other 295 of 2019, registered for the respective offences. ಎಲ್ಲಿದೆ FIR ಗಳು ಕೊಡಿ ಎರಡು. Page 43 ಒಂದಿದೆ ಮೇಡಮ್. ನಿಮ್ದ್ರಲ್ಲಿ ಯಾವ ಪೇಜ್?
Page 14, my lords. In the
14.
criminal petition.
ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ
Page 14.
ಒಂದು ರೆಡ್ ಪೆಟಿಷನ್, ಇದರಲ್ಲಿ ಪೇಜ್ 43, ಇನ್ನೊಂದು ಕ್ರಿಮಿನಲ್ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಪೇಜ್ 14. What is discernible from the aforesaid is that it is a case and a counter case springing from one solitary incident which happens on 28/10/2019. Which happens on 28/10/2019. The issue is not with regard to the fulcrum of the crime so registered. The issue is with regard to who has investigated into a case and a counter case. The case and counter case, though is before the concerned court at a very advanced stage, is investigated by two different investigating officers, contrary to the law declared by this court and the circular issued by the state in furtherance of the law declared by this court. Both of them have been thrown to the winds by the state in appointing two different investigating officers on a case and a counter case. The parties may vary. That would not mean that it is that a case and a counter case must be investigated into by two different investigating officers, as it has sprung from one solitary incident. In that light, both these petitions deserve to succeed, albeit in part with the obliteration of the crime and the commencement of investigation from and the proceedings to recommence from the stage of the investigation, and the investigation to be handed over to the same investigating officer. The investigating officer shall now conclude the investigation within 3 months and place the final report before the concerned court. Ordered according. Concerned court for the aforesaid reasons. Allow ಹೇಳಿದ್ನಲ್ಲ operative portion? Yes.
7 for the petitioner, my lord. My lord, matter pertains to a complaint that has been filed by a college student against her classmate for him commenting on an Instagram post. If I can take my lords directly to the offending messages, allegedly offending messages, 35 ತಾವು ನೋಡಿದ್ರೆ.
Snapchat?
ಅಲ್ಲಲ್ಲ, Instagram. ಏನೋ ಸ್ಟೋರಿ ಹಾಕಿದ್ರಂತೆ. My lord.
Sorry,
Page 35, my lord.
ಏನಿದು ಪ್ರಿಟಿ?
ಅದಕ್ಕೆ ಅವರು ಥ್ಯಾಂಕ್ಸ್ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಅದಾದ್ಮೇಲೆ ಎರಡನೇ ಕಾಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ she has her father is a senior police officer. I don't want to name him. The name is available in the cause list, in the cause title. They have then picked him up, filed an FIR. Then they have impounded his laptop and his phone, and for the last 2 years have kept it in their custody. And they've put up offenses of voyeurism, stalking, ಮತ್ತೆ act to insult the modesty of any woman, and 66E violation of privacy.
ಇದಕ್ಕೆ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳಿಲ್ವಾ ಅವರು?
ಈ ತರ ಹೇಳಿದ್ದಾರೆ.
ಅಲ್ಲ, ಇದಕ್ಕೆ ಥ್ಯಾಂಕ್ಸ್, ಈ ಕಾಮೆಂಟ್ ಥ್ಯಾಂಕ್ಸ್ ಹೇಳಿಲ್ವಾ?
ಇಲ್ಲ ಅದೇ instead of saying thanks, she has asked her father to file an FIR on her behalf. He's a student, my lord. They're both classmates.
Gen Z lingo. Yes.
In fact, while confiscating his laptop and his phone, they haven't followed any procedure. My lords also have observed in several matters that
When a police officer's family is the complainant, nothing is followed. ಯಾರಿಗೆ ಕಳಿಸಿದ್ದಾರೆ? ಇದ್ಯಾವ ಫ್ರೆಂಡ್ಸ್ ಕಳ್ಸಕ್ಕಾಗತ್ತೆ? It's a DM on Instagram. DM on direct message. Yes. ಏನ್ ತಪ್ಪಿದೆ ಇದರಲ್ಲಿ?
ಇದು ಯಾರಿಗೂ ಕಾಣಿಸಲ್ಲ ಸ್ವಾಮಿ.
She must be happy.
A private chat.
It's a private chat, true. What's wrong with this? That's why I say Gen Z lingo. And said underrepresented, ಯಾಕೆ ಈಗ ಪೊಲೀಸ್ ಆಫೀಸರ್ ಅಲ್ಲೋ ರಿಟೈರ್ ಆಗ್ಬಿಟ್ರ?
ಇಲ್ಲ ಇನ್ನೂ
ಇದಾರ? The petitioner, a student, is before the court calling in question the registration of a crime in crime number. Madam,
0363 of 24, my lord. Page 23 ಅಲ್ಲಿ FIR.
Crime number 363 of 2024 registered for offences punishable under so and so. Stay there.
Stay there.
The petitioner and the who is the complainant?
The complainant is the classmate herself.
The petitioner and the respondent, who are 21 and 20 years respectively, are classmates and have classmates and friends as well. The issue relates to an Instagram chat. The petitioner, in his zeal, communicates to the complainant by DM, direct message, on Instagram with regard to how the complainant looked on a particular day, describing her to be beautiful, but in a Gen Z lingo. The message is said to have been shown to the father, who the petitioner submits that is an IPS officer. IPS, is an IPS officer in the state. Trouble crops up to the student. A crime comes to be registered. And the career of the petitioner is put to jeopardy, as the petitioner was a state level cricket player and had to then represent a U19 team in Tamil Nadu. The crime then is begun, the crime gets into investigation. Arrest madidra?
Unofficial arrest ಮಾಡಿದ್ರು ಹಿಂದಿನ ದಿನ. There is no record of that.
The
He's been asked
The
to stay.
laptop and the mobile phone of the petitioner were allegedly seized, which the learned counsel for the petitioner submits that completely contrary to law. Be that as it may, the petitioner then knocks at the doors of this court, and this court stays further investigation qua the petitioner. The complainant, though served 2 years ago, has remained unrepresented even today. Therefore, the petitioner and the respondent state are heard. The petitioner heard sounds. The learned counsel appearing for the petitioner takes this court through the documents appended to the petition or the chat, the direct message that was sent to the direct message that was sent to the complainant. The learned counsel submits this would not even attract any of the offences as obtaining under section 77, 78, 79 of the BNS. It was two classmates, two friends chatting, describing how the complainant was beautiful. The learned counsel would further submit that if investigation is permitted, it would become an abuse of the process of the law and jeopardize the career of the student, the petitioner. The learned HCGP, however, would put up vehement opposition to any order that would be passed by the court quashing the investigation itself, contending that be it the classmate, he has no right to speak on how beautiful the complainant looks. So would seek investigation into this matter. And dismissal of the petition. I have given my anxious consideration to so and so. The entire fulcrum of the crime for the aforesaid offences revolves around the chat. The chat is not a public chat. It is chat between two individuals, i.e. the petitioner and the complainant. The chat is as follows. The chat described in the language that the students of this day deploy. This they deploy without knowing that it could land the petitioner in the web of these proceedings. Beyond this, there is no chat. The chat that has become the chat that has become the fly in the ointment is what is quoted here and above. The offences alleged are section 74, 77 and 79 of the BNS, which would be outraging the modesty of a woman, stalking and voyeurism. If this chat can lead to all that, it would on the face of it become an abuse of the process of the law to permit investigation on the chat afore quoted for it to become the ingredients of voyeurism, outraging the modesty of a woman, or stalking, as the case would be. There is neither stalking nor voyeuristic act of the complainant, of the petitioner, nor it would amount to outraging the modesty of a woman. Yes, it is a particular word used is inappropriate, but that is the word that is used by students of this day. Therefore, that cannot become a crime for the aforesaid offences, and permitting further investigation into the case at hand would not only jeopardize a student's career, but also would become an abuse of the process of the law and result in miscarriage of justice. Allowed quashed.
My lord, there's an IA for direction to release
in the event, in the light of the quashment of the proceedings, the investigating officer shall forthwith return all the items of the petitioner that are seized and kept in the custody.
Deeply obliged.
If kept in the custody, yes.
Deeply obliged.
Next.
Number 12.
For the respondent. 3 petitions, my lord, arising out of the relationship between the landlord and tenant.
Joseph Chaku.
Yes, my lord.
Oh, yes, sir.
See, I am filing a snapsheet.
Yes, sir.
Serving copy.
ಏನ್ ಅಲಿಗೇಷನ್ ಸರ್?
Lord, what happens, I have built 215 apartments.
You have built?
Yes.
Yes, sir.
I am a builder.
Oh.
215 apartments. The land I purchased in the year 2000. Lord, out of which I sold 135 plots to various NRI customers, retaining 80 flats. Out of which 20 flats I used for running a hotel.
Hotel?
Hotel.
Which hotel you run, sir?
Kirti restaurant in the same building.
Seriously?
Please, my lord. Then during COVID, I could not continue it. This respondent approached me, I rented it out. Not collecting any advance amount. The understanding was he should renovate, spending some money. Lord, as on this day, not even 1 rupee paid as a rent.
ಇದು ಬರೀ
Rent
ಹೋಟೆಲ್ ಅಷ್ಟೇನಾ ಇದು?
There are several other suits. What has happened, my lord? He filed a suit against me in the year 2023 that was dismissed for default. I filed another original suit. I took a injunction order. My lord, also, my lord, police protection order passed by the civil court. My lord, on 18/2/2026, my manager goes there, Chaco's manager.
Chaco's manager.
Manuel goes there. I did not go over there.
Chaco's manager Manuel.
His
name is Manuel.
Manuel.
Yes.
Manuel goes. Manuel is his manager's name. He goes there with the court order. My lord, the respondent, my lord, abuse him, threaten him. Then he calls the police. Police go to the spot. My lord, they secured the presence of everyone. There was a complaint and counter complaint. My lord, my complaint, that is respondent's two's complaint, registered as NCR. NCR, non-cognizable.
Whose complaint? NCR?
Yes.
Then why are you here?
My lord, this petitioner files a complaint.
That is registered as
a NCR. The respondent's complaint. Yes, please, my lord. The respondent files a complaint that was registered into an FIR. My lord, without following the mandatory provisions of the BNSS, no notice was served. My lord, there was a direction by the DCP to arrest me. A group of police go to Kerala. My lord, that is 12.1. That is 12.1. Not in which this honorable court granted stay. 12.1. That was initially registered in crime number 86/2026, registered on 19/2. The stay is granted. Then, my lord, I also filed a complaint. They did not register as an FIR. Then I filed a private complaint. Thereafter, crime number 106 was registered based on the direction given by the learned magistrate. When the matter stood thus on the same point, same allegation, my lord, this writ petition number 10/575, my lord, 15/3 on the same allegation, my lord, another complaint came to be filed. That was registered in crime number 130/2026. Your lordship may kindly refer to page number 24, annexure A. Page number 24, annexure A in WP 10/575.
ಈಗ ಎರಡು ಅವರು ಹಾಕಿದ್ದಾರೆ, ಅದೇನು?
ಅದೇ ಸಮಿತಿ ಎರಡನೇದು, ಎರಡು ಕಂಪ್ಲೇಂಟ್.
ಅಲ್ಲ, ಒಂದ್ರಲ್ಲಿ ನೀವಿದ್ದೀರಾ?
ಹೌದು, ಎರಡಲ್ಲಿನೂ ನಾನೇ ಇದ್ದೀನಿ ಸರ್.
VB Shivkumar is the petitioner.
Shivkumar is the petitioner counsel.
You are appearing for him.
I am appearing for.
ನೀ ಎಲ್ಲಾದ್ರೂ ನೀವಿದ್ದೀರಾ ಈಗ?
ಹೌದು ಸರ್.
ಸರಿ, ಆಯ್ತು. So all petitions ನೀವೇ?
ನಾನೇ. The 12.2 is filed by me. That's it. My lord, in 10/575, the complaint your lordship may kindly.
Vacating stay ಹಾಕಿದಾರಾ?
Yes. ಅವ್ರು ಹಾಕಿದ್ದಾರೆ ಸರ್. 24. Page number 24. Complaint against Mr. Joseph Chaco and Manuel D and Mr. Shiba for offense of fraud, cheating, criminal breach of trust, forgery, use of forged documents, criminal intimidation, extortion, defamation, harassment, wrongful restraint, unlawful assembly.
ತುಂಬಾ ಇದೆ ಬಿಡಿ, ತೊಂದರೆ ಇಲ್ಲ.
ಇಷ್ಟೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ. Not even 1 rupee is interested, criminal breach of trust. Not even
Again,
1
civil
rupee
suit
is.
civil suit ಹಾಕಿದಾರಾ?
ಹಾಕಿದ್ದೀನಿ ಸ್ವಾಮಿ. ಅದು there are 3 suits against him. 3 suits, 2 suits filed by the different plot owners. 1 suit is filed by me, that your lordship gets at ink page number 135. 134, the order, my lord. In all, there are 4 suits. My lord, the suit filed by them dismissed for default. That, then the suit filed me, the court passed an order. My lord, now, lordship may kindly appreciate, the entire complaint is taken into consideration. My lord, even admitting as it is, there are absolutely no material. Because, my lord, they have not even given me 1 rupee as sort of advance. No money was given to me. Then they say extortion. If the complaint is read as a whole, may I read, my lord? I invite your lordship kindly refer to page number 26. Here, para number 3, we further state that in 2023, a civil suit was instituted against Joseph Chacko, and the honorable court pleased to grant injunction. Then, my lord, they also speak about giving complaint.
Yes, sir.
There are many suits.
Balkrishnan, sir.
My lord.
Milords, the suit that was filed was, it is true, it was filed in 2023. Milords, the same is not dismissed for default. It is restored. It is ongoing.
All right.
That
Why criminal law?
The criminal law was set into motion only for the reason that they barged into the property, Milords, and threatened my employees. I produced the CCTV footage, the WhatsApp entire conversation record to the police, and only subsequent to it, on the basis of considering the documents that are produced, that the complaint came to be registered and an FIR, Milords, on the basis of the same. Subsequent to it, Milords, they had filed a suit. The suit was pending. All those are matters of record, Milords. I'm not going to dispute and take my lord's time on that. Milords, the entire property was leased out to me.
Investigation ಆಗಿದೆಯಾ?
Investigation ಇಲ್ಲ,
Stay ಆಗಿದೆಯಾ?
Stay ಆಗಿದೆ.
Investigation permit ಮಾಡೋಣ.
My lord, subsequently,
that's where I have filed another writ petition.
Not to permit investigation.
What happened? I have filed a complaint. The inspector not taking my complaint.
That also will be investigated into.
Please, my lord. Then, my lord,
Joseph Chacko's 3 ಕೇಸ್ ಇದೆ. ಅವರು ಏನೋ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಇವ್ರ ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ, ಇವ್ರದ್ದು ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ.
ನಂದು ಒಂದು FIR
ಎಲ್ಲ ನಿಮ್ದು ಆಗತ್ತೆ.
ತನಿಖೆ ಮಾಡ್ಲಿ. Let them not precipitate. Let them investigate.
ತನಿಖೆ ಆಗ್ಲಿ
ಸ್ವಾಮಿ. Let them not precipitate. ತನಿಖೆ ಅನ್ನೋದ್ರಲ್ಲ ಕೇರಳಕ್ಕೆ ನನ್ನನ್ನು ಹುಡ್ಕೊಂಡ್ ಬರ್ತಾರೆ, ನನ್ನ ಪ್ರಾಪರ್ಟಿ.
ನೀವು ಕೇರಳಲ್ಲಿದ್ದೀರಾ?
ಹೌದು ಸ್ವಾಮಿ. Regularly I stay in Kerala. For my business purpose, I come and go. I invested in lot of properties in Bangalore. Not only this property, several acres of land I purchased about 3 decades back.
Correct. ಗೊತ್ತು. ಅಷ್ಟೇ.
And ಈಗ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಈಗ I have filed a civil suit.
Civil suit ಮಾಡಕ್ಕೆ civil suit ನಡೆಯುತ್ತೆ.
50 lakhs rupees arrears of rent. I have filed a commercial.
That is you
contest. ಈಗ ನಾನು ಹಾಕಿರೋದು FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ. Through the court referred to the police.
ಎಲ್ಲ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ತಾರೆ.
Investigate ಮಾಡ್ಲಿ without precipitating the issue. I have taken anticipatory bail in 1
ತೊಂದ್ರೆ. ನೀವು ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಲ್ಲ?
I was not aware of the complaint.
ಈಗ you become aware ಅಲ್ಲ ಈಗ?
Now I'll approach whatever legal remedies are available.
ಅವರು ಬೇಲ್ ತಗೊಳ್ಳಿ ಸ್ವಾಮಿ, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
The petitioner.
Wrong submission is made that CCTV footage, no CCTV footage.
Court investigation ಮಾಡ್ತಾರೆ ಬಿಡಿ.
ಅದನ್ನು ಇನ್ನು CCTV footage ತನಿಖೆ ಮಾಡ್ಲಿ.
CCTV ಇಲ್ವಾ?
Entire property has been under CCTV.
Let
them investigate, truth come out ಅಂತ ಹೇಳ್ತೀನಿ. ಈಗ ಕೊಟ್ಟಿದ್ದೀನಿ ಅಂತ ಹೇಳ್ತಾರೆ, ಸುಳ್ಳು ಹೇಳ್ತಾರೆ ಅಂತ ಹೇಳ್ತೀನಿ.
ಹಾಗೆ ನೋಡುವ.
Tenant, it happened in the lobby. Whatever is required on my end.
Yes. Petitioner has preferred these 3 petitions. 2, calling in question a crime registered against him. 1, seeking a direction to investigate into the complaint registered by him. The learned counsel, learned SPP, on looking into the records would submit that the complaint registered by the petitioner also will be investigated into. If investigation is permitted, into the complaints registered by the complainants. A perusal at the complaint or the perusal of the contents of the complaint in each of these cases would clearly indicate that it is a case to be investigated into, where it is a case where investigation must be permitted in the least. In that light, I deem it appropriate to permit investigation into the cases at hand, both the complaints registered by the complainant against the petitioner and the complaint that the petitioner has registered against the complainants. The investigation shall ensue in all these cases. Liberty is reserved to the petitioners to approach this court in the event the final report would be filed and the final report would go against them. All other contentions will remain open to be urged at a later point in time. The respondent, it's needless to observe that the petitioner shall cooperate with the investigation, and in the event of cooperation, no precipitative action. Then better. In the event of cooperation,
ಇರ್ಲಿ ಸ್ವಾಮಿ perspective.
ಅದು dispose ಮಾಡಬೇಕಾದ್ರೆ ಬರೆಯುತ್ತೆ. In the event, a petitioner is at liberty to approach this court in the interregnum in the event of need. ಅದು ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ ಅರೆಸ್ಟ್ ಮಾಡಿಬಿಡಿ ಅಂದಂಗೆ ಆಗುತ್ತೆ. Yes.
12.2, I have served copy on that.
ಆಯ್ತು 12.2 all matters.
Please, madam.
I'm not.
ಜೋಸೆಫ್ ಚಾಕು ಮ್ಯಾಟರ್ಸ್ ನ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿದ್ ಇನ್ಯಾರು?
Hardly, ಸ್ವಾಮಿ.
I'm not a party in the other matter. 12.
No problem, sir. You are a party in the complaint.
Great to know.
Oblige, madam.
ಕೊಡಿ ನಂಬರ್ ಕಂಪ್ಲೇಂಟ್
ಕೊಡ್ತೀನಿ ಸರ್.
ಕೊಡಿ, ಕಾಪಿ ಕೊಡಿ ಅವ್ರಿಗೆ.
ಕೊಡ್ತೀನಿ.
SPP ಅವ್ರು ಕಾಪಿ ಕೊಟ್ರೆ,
make one more copy and give.
ಕಾಪಿ ಕೊಟ್ರೆ ಅವ್ರು ಇನ್ವೆಸ್ಟಿಗೇಷನ್.
ಕೊಡ್ತೀನಿ ಸರ್.
Yes.
13, 14, 15 milots, yesterday's matter, condition imposed.
Huh?
Condition imposed milots to deposit 24% milots.
20%, correct. Yes, sir. ಅದೇ 4 ವಾರ ಟೈಮ್ ಕೊಡ್ತೀನಿ.
ನಂದು 8 ವಾರ 10% ಈಗ ಇಮಿಡಿಯೇಟ್ ಕಟ್ತೇನೆ ಒಂದು 6 ವಾರದಲ್ಲಿ, ಮತ್ತೆ ಇನ್ನೊಂದು 6 ವಾರ.
ಹೆಗಡೆ ಸರ್, 3 ವಾರ 10%ಗೆ 3 ವಾರ ಇನ್ನು 10% ಕೊಡುವ, ನಿಮ್ಗೆ ಅದಾರು ಬರ್ತದೆ ಡೆಫಿನೆಟ್.
Please, my lord. As my lord,
ಬರಲಿ at least. ಮತ್ತೆ ಇನ್ನೊಂದು ಎಕ್ಸ್ಟೆನ್ಷನ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋತಾ
ನಾ ಕೊಡೋದೇ ಇಲ್ಲ. ಈಗಲೇ 4 ವಾರಕ್ಕೆ ಮಾಡ್ತೀನಿ, ಆಮೇಲೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಹಾಕಿವೆ.
Judgment is 5th January 26 and you obtain the order. Anyhow, I leave it.
The petitioner.
And if he doesn't deposit, then
that is there. Yes. The petitioner is before the court.
Make one more request. Also liberty to approach Sessions Court, my lord, seeking modification of this order.
No, sir. None order, all modification.
20% ಇದ್ದು ಮಾಡಿ.
12 ವರ್ಷ
ಇಲ್ಲ, ಅದು ಆ ಲಿಬರ್ಟಿಯೇ ಇಲ್ಲ. ನಾನು ಆರ್ಡರ್ ಮಾಡಿದ್ಮೇಲೆ ಅದೇನು ಲಿಬರ್ಟಿ ಅಲ್ಲಿ? ಎಸ್,
ಇಬ್ರು ರೆಡಿ ಆಗ್ತೀವಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಗೆ, ಅಲ್ಲೂ ಕೂಡ ಅದು ಕೂಡ ಬೇಗ ಹೋಗಿ
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಬಿಡಿ. The petitioner is before the court.
Three cases are there.
Same petitioner alva?
ಹೌದು, same.
The parties to the list in these 3 cases are one and the same. The issue is one and the same. The instruments are different. 3 checks. The petitioner gets convicted for the offense punishable under section 138 of the Negotiable Instruments Act. In all, for an amount of rupees 13 crores. The petitioner files an appeal before the appellate court. The appellate court suspends the sentence subject to the condition that the petitioner should deposit 20% of the amount as obtaining under section 148 of the Negotiable Instruments Act. The deposit having not been made, the magistrate warrant issue madidra? Challenging the said order, the petitioner is before this court. The learned counsel for the petitioner submits that there is no reason rendered in the order for the order to be sustained, as it runs foul of the judgment of the apex court. The learned counsel would further submit that if in the alternative, if reasonable time is granted, a deposit could be made before the concerned court. The counsel P.P. Hegde would submit that the petitioner, the mandate of the statute cannot be stifled by the request of the learned counsel appearing for the petitioner in directing amount to be paid in a staggered manner. Be that as it may, in the peculiar circumstances, I deem it appropriate to permit the petitioner to deposit the said amount in 2 installments. One, in 3 weeks, 10%, and no, in the next 3 weeks, 10 weeks from the expiry of said 3 weeks from today. In the event the petitioner would not comply with the said deposit, it is open to the concerned court to pass necessary orders, unleashing the coercive arm of law, ordered accordingly.
Great.
The amount is deposited, my lord, that may permitted to be.
ಅಲ್ಲಿ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ
ಇಲ್ಲ ಅದು ಆಲ್ರೆಡಿ ಇದ್ರಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
ಅದು ಗೊತ್ತಿಲ್ಲ, ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ ಕೇಳ್ಕೊಳ್ಳಿ.
As per us. Yes. Great.
Yes. ಯಾವ್ದಿದು?
This is that election petition.
That election.
Supreme
Yes.
Court has, Supreme Court has.
The Honorable
Yesterday.
Supreme Court says.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗಿದ್ದೆ ಯಾಕೆ?
No,
ನಾನು ಕೇಳ್ತಾ ಇದ್ದೆ ತಾನೆ. ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಯಾವ್ದ್ರಲ್ಲೂ ಹೋಗಲ್ಲ, ಇದ್ರಲ್ಲೂ ಅರ್ಜೆಂಟ್.
ಅದು ಸ್ವಲ್ಪ ಅಲ್ಲ ಎನಿವೇ ಅವ್ರ ಕಡೆ ಒಂದು MLA ಕಡಿಮೆ ಆಗ್ತಾರೆ ಅಂತ ಅಷ್ಟೇ, ಇನ್ನೇನಿಲ್ಲ. To be very honest, that's a fact.
ಯಾರ ಕಡೆ?
I don't know that.
ಅದು ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
Ruling government.
No. State government is a
Ruling government.
State government consists of all MLAs and MPs.
ಸೊ ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ ಅದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ?
Government is formed by the ruling.
ಅಲ್ಲ, ಬಟ್ ಏನಾರಾಗ್ಲಿ ನೀವು ಹೋಗಿದ್ದೆ ಯಾಕೆ? ಒಂದ್ ಯಾವ್ದೋ ಇಂಟ್ರಿ ಮಾಡ್ರ ಮೇಲೆ ಅದು 17th ಆರ್ಡರ್ ಬರ್ಸ್ಕೊಂಡ್ಬರಕ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
This discrimination should go. In all the matters, they should go otherwise. Pick and choose, will not travel all the way to Delhi.
ನೀವ್ ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದರಲ್ಲೇ ಇದೆ.
ಮೂರು ಸರಿ ಸರಿ.
3 petitions.
ಅದು ಬೇರೆ.
Your lordships, my lord, have already taken a view, my lord, who has to file this complaint.
Get the entire records of this thing. I will record that on 17th matter was listed, the state short time ಅಂತ ಹೇಳ್ತೀನಿ.
It is my mistake, Lord. I should have brought it to your lordship knowledge about the Supreme Court order. I have not.
I didn't know at all. ನೆನ್ನೆ ಕೊಟ್ರಿ ಇವರು ಅಷ್ಟೇ.
I can't see. It's an order of Supreme Court. I can't place it.
ನೆನ್ನೆ ಇದೆಯಾ ಮೇಡಮ್? ಫೈಲ್ ಇದೆಯಾ? ಇಲ್ಲ ಇದೆ, ಸಾರಿ. The matter was listed on 17/7/2026. The state sought time to file objections or produce the records as the case would be. The matter is adjourned. ಯಾವತ್ತಿಗೆ ಹೋಗಿದೆ? Adjourned to 31/7/2026. The learned counsel for the petition, learned senior counsel M.S. Shamsundar places on record the order of the apex court in an SLP filed by the state itself, that the state has approached the apex court seeking expeditious disposal of the case or challenging an interim order granted on 5/5/2026 in the vacation bench. The apex court passes the following order. The order of the apex court was to dispose the matter on 17/7/2026. But the matter, the order,
it says listed on 17th.
The order of the apex court is that the matter would be listed on 17/7/2026, making it clear that it would be heard and disposed.
Yes.
Making it clear that they heard and disposed of. But the order of the apex court is brought to the notice of this court only on 20th. Therefore, the matter was listed today, notwithstanding it being directed to be listed on 31/7/2026. In the light of the state itself seeking an adjournment in the matter, and the state itself, which was the petitioner before the apex court seeking an adjournment in the matter, I only adjourn the matter on to 31/7/2026 with a direction that no further adjournment would be granted to any of the parties on any ground whatsoever. The state shall place the entire records that has led to the registration of the crime before this court on the next date.
Great.
This
Is
petition, the assembly was heard on 15/7. Passed on.
But ಏನ್ ಮಾಡೋದು?
It has to be.
ಅಲ್ಲ, ಅದಕ್ಕೆ ಅವರೇ 17/7 ಅವರೇ ಟೈಮ್ ತಗೊಂಡಿದ್ದು. ಸರ್ ಬೇಡ ಸರ್, ಸುಮ್ಮನೆ ಇರಿ. ಸರ್ ಯಾಕೆ ಕಳಿಸ್ಬಿಡ್ತೀರಾ ಇಲ್ಲಿ ಅಂತ?
That we are otherwise well served, my lord. We have no issues, my lord, the matter being disposed of.
Correct. I had no issues. Avare
Yes.
time ಕೇಳಿದ್ದು.
In fact, we said that it could be, my lord, there is a very small point involved, my lord. Who could have filed this complaint? That's all, my lord, the question.
That we will answer.
That's,
Don't
your
worry.
lordships have already
Who
taken
can,
your
who
previous
can
judgment.
set the criminal law into
That's
motion
all,
in
my
such
lord.
cases?
Yes.
We will
yes,
answer.
Yes.
No problem. We'll see. Because if it is election, I think any voter can set into motion.
This is result. This is
Result.
result. They say is tampering of ballots.
Tampering of ballot boxes. Postal ballot.
Postal ballots.
Well, it is in the custody of the- ಅದನ್ನೇ ಕೇಳಿದ್ದು ನಾನು.
My lord, it's an unsolved riddle that how this
ನಿಮ್ಮ ಹತ್ರ ತಾನೇ ಎಲ್ಲ ಇದೆ. ಆಮೇಲೆ it is in the custody of the state. ಅವಾಗ ಓಪನ್ ಮಾಡಿರೋದು ಅದು.
Same day comes this complaint. And I don't know, instead of probably going against the returning officer of 2026, they've gone against me who had declared it as successful candidate.
ಅವ್ರ ಮೇಲೆ
ಅವ್ರದ್ದು ಕಷ್ಟ ಇದೆ. ಪರವಾಗಿಲ್ಲ. We'll answer. It is not. Issue is, my lords,
ರಿಟರ್ನಿಂಗ್
when the
ಆಫೀಸರ್
criminal,
ನಿಮ್ಮನ್ನ ಡಿಕ್ಲೇರ್
Allah, lords, no.
ಆಫ್ಟರ್ ಡಿಕ್ಲರೇಷನ್.
Lords, that is the precise case of us.
ಒಂದು ನಿಮಿಷ ಸರ್. After declaration, it is sent to the strong room or whatever it is,
Lords, the
custody
DO,
of the
district,
state.
that is the deputy commissioner.
ಒಳ್ಳೆ ಸರ್ ಯಾರಿಗೆ?
One of, my lords, he is also for the one of the issue is only this. The court never said re-verify the accepted votes. What has
The
happened?
election petition ಅಲ್ಲಿ.
Yes, accepted votes was not the issue. Issue was regarding re-verification of the rejected postal ballots.
Now,
No.
1 minute, let me complete.
ಆಯ್ತು.
You have had your turn, let me complete.
Wait, Shamsundar sir, wait, yes.
Now, my lords, what is accepted, the entire issue was the postal ballots which were rejected, the winning margin was less than that. So the court
Less
said
than?
the rejected ballot votes was the margin, my lords, were more than the margin of winning. So, my lords, the court said no that.
Wait.
Now
I'll
what
get back.
happens is when they take up that, they take up the accepted ballot papers, postal ballots, and then find in one bundle, one full bundle, which, my lord, suddenly appears that which was accepted, which was not to be touched, that it is marked double marking in that.
Tempered.
That is where, and the Mahajar shows some of the boxes are, seal is broken, all that is broken. Somebody has to answer. So we'll meet that on 30th. It's not as simple as it's been. They draw the proceeding.
Who?
The election commission draw the election commission does not draw, it is the returning officer and the
Right.
DO. In the proceedings, they find that everything is intact. There is no tampering. Lords, Mahajar is put before the Honorable Supreme Court. I am not the one. They have filed it before the Honorable Supreme Court.
the election the postal ballots has to be verified. That's what, my lord, is the rule. That's what, my lord, is the judgment. All the postal ballots. Now, my lord,
Lot of issues to be decided here. We'll do it.
in fact, my lord, these are all in the periphery. Only the fulcrum of the complaint is somebody opened their strong room ballot boxes. The penetration was such that they could
So
not
you mean to
tamper.
say that only that forms the kernel of this conundrum?
That's all, my lord. That's all. That's all. If that is possible, my lord, physically or logically, then your lordship should take the lead. That's all. That this is a hallucination. Nobody knows. Nobody knows. And your lordship sees who is contesting the matter, not state.
Let us not play to the
Testing.
thing.
Not state.
You election commission ga?
No, my lord, my
ಮತ್ತೆ ಯಾರು
learned friend
contest-
is for the returned candidate.
So what? He has every right.
Complainant.
Complainant ಯಾರು?
Returned candidates, my lord, person of the returned candidate.
ಆಯ್ತಾಯ್ತು ಅಂದ್ರೆ, yes.
Everything is quite clear, my lord. I am not going.
He
to
was
say.
present, so he is going to represent. So what?
greatly of
ಒಳ್ಳೆ
that.
31st ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಮತ್ತೆ ಇದ್ರ ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ಗೆ ಹೋಗ್ಬೇಡಿ.
No, at this stage, my lords, I think the next stage, let them not make any allegations. I think the petitioner before the Honorable Supreme Court has already filed one IA
ಏನಂತ?
seeking for, there is a report by the election observer. My lord, the Honorable Supreme Court had directed the Election Commission to place all materials on record. They filed certain things in a sealed cover, then it was taken back. And certain documents are given to parties. Now an IA is filed that the election observer's report has to be filed before. That's all. I'm only bringing it. I'm not, tomorrow they should not come and say they were aware, they have filed an IA there.
No, that anyway doesn't matter with this.
No, I am only saying.
No, all of you tell me, we taking this matter has nothing to do with the pending
Nothing to do
proceedings
with-
there?
Absolutely.
And
no
we have
subsidies.
also
No
in that IA, we have also set out that a criminal complaint was filed.
That is being considered here.
That is being considered. There is a stay we have set
That's
out.
the reason
Tomorrow
the
I
Supreme
should
Court
not-
has
No, no, that's why,
directed.
my lords, tomorrow you should not say we filed an IA on this date. I
No,
did
the
not
court
bring it.
should not have taken the
And
matter.
in any case, the Honorable Supreme Court
Itself has directed.
has requested this Honorable Court to dispose the matter. They should not be
They,
held back.
they never requested. It is only because state went against an interim order. They said it's being.
And we are not on the elections
31st,
here.
sir.
Elections,
Yes.
the Honorable Supreme Court is dealing with, we are not going. to
Whatever
start
it is,
looking at
31st, no adjournment, will close this.
Greatly.
31st at 2:30 PM.
Please.
We'll take it off at 2, interim order will continue. ಅದ್ರ ಮೇಲೆ ಹೋಗ್ ಬಂದಿದ್ದಾರೆ ಅವರು.
The vengeance is at a different level in this.
Interim order will continue. We'll take it at 2:30 PM, sir.
Meanwhile, I'll get the counter file. It's ready.
Whatever you want to file, please file it and get the records also, SPPR. Yes.
Order still number 17,
Withdrawal.
18.
Petition, my lord.
Post immediately after service of notice upon the respondent, interim order. 18 ಏನು?
Lords 18.
ನೀವಿದ್ದೀರಾ?
Yes, my lords.
Lords
18, the.
Before commencing, my lord.
You are appearing for the complainant?
Yes, my lord, in one criminal petition number 10772 of 24.
ಎಷ್ಟು ಮ್ಯಾಟರ್ ಇದೆ?
3 matters, my lord. In the last matter, my lord,
ಕಾಶಿನಾಥ್,
107.
ಇದ್ರಲ್ಲೂ ನೀವೇ ತಗೊಂತೀರಾ ಹಂಗಾರೆ ನೋಟಿಸ್?
I'm not aware of, my lord, who is the party, but in this, my lord, notice is directed and copy is not served.
One moment, sir, one moment.
In 1077.
ರವಿಶಂಕರ್ ಸರ್, ಒಂದ್ ನಿಮಿಷ. Complainant is Chandrappa.
I'm only a representative. my lord,
Niranjan,
permission
Niranjan, son of Chandrappa.
But I'll verify, my lord, the court is directed in criminal petition number 10772 of 24.
Lords, Niranjan, son of Chandrappa,
I'm not served with.
is a charge sheet witness in a case registered by the CBI in relation to the very same offence. Allegation is.
What's the matter here?
Lords, the allegation is
Elsa Kodu
that
senior,
for the purpose of securing jobs in railways,
Stay ಇದೆಯಲ್ಲ?
there is a stay operating. But the only question is this, my lords, the trial is already on. Almost about 22 witnesses have been examined in the criminal trial conducted by where the CBI is the investigating agency. In that, the complainant is CW 25. Lordships are granted on the ground of that.
ಈಗ ಸ್ಟೇ ನಿಮ್ ಪರವಾಗಿ
ಇದೆ, stay ಇದೆ.
ಡಿಸ್ಪೋಸ್ ಮಾಡ್ಬೇಕು.
It could be disposed of, my lords, because there he is already.
ಕೊಟ್ರೆ ನಾನು ನೋಡ್ಬಿಟ್ಟು ಹೇಳ್ತೀನಿ.
ಆಯ್ತು, ಕಾಪಿ ಕೊಡಕ್ಕೆ ಹೇಳಿ. We'll take this on Wednesday.
Lordships.
Wednesday in the same stage.
Lordships.
We'll dispose it because if there is a proceeding pending, where is the question of? No, Wednesday. ಈ Wednesday, next Wednesday.
Next Wednesday.
Yes. ಈ Wednesday ಅಂದ್ರೆ tomorrow ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೆ. Yes.
Great.
Heard the Leonard Senior Counsel D.R. Ravishankar appearing for the petitioner. Advocate and record shall serve set of papers upon Kashinath JD. Represent the complaint ನೀವೇ ತಗೊಳ್ಳಿ.
But I'm not aware of.
Father and son, sir. ಒಂದ್ರಲ್ಲಿ ನಿರಂಜನ್, ಒಂದ್ರಲ್ಲಿ ಚಂದ್ರಪ್ಪ. Yes. The Leonard Counsel JD Kashinath accepts notice for the second respondent as well. Registered to print the name of so and so as appearing for the second respondent in all these cases. ಒಂದ್ರಲ್ಲಿ father, ಒಂದ್ರಲ್ಲಿ son. Yes.
Interim order, my lords.
Interim orders will continue to the next date, next witness. Under the caption, hearing on interlocutory applications. Yes,
19, withdrawal.
in terms of
20,
Impleading applicant to lordship.
ಏನ್ ಶಂಕರ್ ಇದು?
Dinner to offense lordship, this armor code evidence.
302 ಸ್ಟೇ ಆಗಿದೆಯಾ?
17 ಜನ.
Charges,
ಒಂದ್ ನಿಮಿಷ ಸರ್, ನಾನ್ ಕೊಟ್ಟಿದ್ದೀನ?
ಇಲ್ಲ ಇಲ್ಲ. 17 ಜನ ಅಕ್ಯೂಸ್ ಇದ್ದಾರೆ ಸರ್.
ಮರ್ಡರ್ ಕೇಸಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ. ಕೊಡಿ ಕೊಡಿ.
ಟ್ರಯಲ್ ಕಮೆನ್ಸ್ ಆಗಿದೆ. They have not made the complaint as
ಒಂದ್
party.
ನಿಮಿಷ ಕೊಡಿ ಸರ್.
ಚಾರ್ಜಸ್ ಫ್ರೇಮ್ ಆಗಿರೋದು ಅದ್ರ
ಫ್ರೇಮ್ ಆಗಿದೆ ಅಲ್ವಾ?
ಫ್ರೇಮ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ವಾ?
ಸರಿ ಆಗಿದೆ.
ಆಗಿದೆಯಾ ಆಗಿಲ್ವಾ? ಎರಡು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
In presence of accused, it has not been framed. Accused were absent. EP were filed and accused counsel also not represented. At page number 86, your lordship may kindly. ಅದನ್ನ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ. ಸೊ ಚಾರ್ಜ್ ಶೀಟ್ ನ ಕ್ವಾಶ್ ಮಾಡಿದ್ ಕೇಳಿಲ್ಲ ನಾವು.
ಕೇಳಿದೀರಾ?
ಕೇಳಿಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್ ನ ಕ್ವಾಶ್ ಮಾಡಿದ್ ಕೇಳಿಲ್ಲ. ಚಾರ್ಜಸ್ ಫ್ರೇಮ್ ಆಗುವಾಗ accused
Why charges were not framed in presence of the accused?
Case number at page number 86, your lordship may kindly.
No, my lord. The offense is my year 2021, my lord. They are one other reason, my lord. They are absent, my lord.
ಅಲ್ಲ, they are absconding.
Absconding, they are not absent, they are not presenting, my lord. They are filing, kept on filing EP exemption. Even the trial court, my lord.
Where is the order? 19/9/24.
Page number 86, my lord. Page
19/9. Page.
Page 86. In criminal petition 1165 of 24. Page number 86.
86. Charge frame ಆಗಿರೋ order ಇಲ್ಲಿ sir.
Charge frame ಆಗಿರೋದು
2/14 to 17/13 are not produced from JC bail applications extended. ಎಲ್ಲ JC ಲಿ ಇದ್ದೀರಾ?
JC.
ಮತ್ತೇನು?
ಅಲ್ಲ, ಅವತ್ತು ಪ್ರೊಡ್ಯೂಸ್ ಆಗಿಲ್ಲ JC.
ಎಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿರೋ ಎಲ್ಲಿದೆ ಸರ್ ಡೇಟು? Madam, ask the SPP to appear. Please, pass over. Pass over, not Jan. Yes. Murder case ಅಲ್ಲಿ ಸ್ಟೇ ಮಾಡ್ತಕ್ಕೂ 2 ವರ್ಷದಿಂದ.
Charges frame time
whatever. ಇಷ್ಟು ಟ್ರಯಲ್ ಆಗೋಗ್ತಾ ಇತ್ತು.
Please, offense is here 21, lord.
Please.
Yes.
21.
Appearing for the petitioner, my lords. Withdrawal filed.
Yes, madam.
22.
Same memo ಏನ್ ಕೇಳಿದಿರಾ ಅದು?
Please, my lords.
22.
Office objections overruled.
That's proxy counsel, man. 1 week time.
ಅಯ್ಯೋ ಬೇಡ. 2 weeks IO. Next.
23.
The needful has been done, my lords.
Land council submits needful has been done. Office to verify.
List, date may be given.
Lord, I'll find my objection.
17 sorry 13 or 7
13(1)A, but release
13(1)A.
Release application I reject again.
ಏನ್ ರಿಲೀಸ್?
Amount release. My lord, during search.
ಅಲ್ಲ, ಎಷ್ಟು?
10 lakh rupees.
ಎಷ್ಟು?
10 lakh rupees.
ಅದು ಸಬ್ಜೆಕ್ಟ್ ಟು ದಿ ಔಟ್ಕಮ್. ಇನ್ ದಿ ಇಂಟರಿಗ್ನಮ್ ಆಗಲ್ಲ. ಅದೇ ಆದ್ರೆ ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್.
That order is in question, my lord. Please release application.
ಕನ್ವಿಕ್ಷನ್ ಇಲ್ವಾ ಈಗ?
ಅಲ್ಲ, matter is pending, my lord. For the trial court. But they filed application for release of the amount which was seized during, my lord, the search. That application came to be rejected. Against which, my lord, they preferred this.
ಅದೇ ಕರೆಕ್ಟ್. ನಾನು ಅದು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತೀನಿ. ಆನ್ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಓವರ್ರೂಲ್ಡ್. ಆಲ್ ಸಾರಿ ಫರ್ನಿಶಿಂಗ್ PF ಯಾರಿಗೆ ಬೇಕಾಗಿಲ್ಲ ಮೇಡಮ್. The notice to second respondent need not be there need not be a notice issued to the second respondent in the teeth of the prayer that is sought in the petition. List the matter on tomorrow na 27th 22nd. ಅದು ಬೇಡ, ಇದು ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಇದು ಲಿಸ್ಟ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಟ್ಯೂಸ್ಡೇ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ನೆಕ್ಸ್ಟ್ ಟ್ಯೂಸ್ಡೇ 28th.
24.
In terms of
25.
I undertake to file wakalat
Learned
for all
counsel
two,
so
my
and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent. Enter ಮಾಡಿದ್ಯಾ?
Petitioner may be directed to serve a copy of
Petitioner to serve set of papers upon complete set of papers upon the counsel representing the respondent.
Only 2 weeks, my lords.
2 weeks to file statement of objections. Interim order subsisting will continue to the next date.
Please, 24 memo for withdrawal.
Huh?
24 sir, memo for
Withdrawn, sir. Yes. Mohan Chandra.
26.
Post immediately after service if notice upon the respondent number 2.
27.
Yes. Axis Bank. ಏನು?
My lords, in this case, there are multiple defreeze orders and lien marks marked by various statutory bodies
across India, my lords. My lords, in this case, the three.
Office objections, accepting the submission of the council office objections overruled list on Monday in the fresh matters list.
My lords,
Next.
there may be an interim stay.
No, sir. Avattu. Next. Hmm.
And in fact, on the previous occasion, there was dispensation so far as R2 is concerned, my lords. My lords, could I point out the dates, my lords?
Furnishing of PF ಏನಕ್ಕೆದು?
Question of? In fact, my lords said for R2 dispense it, but I think the order read otherwise.
The cancellation of bail.
They have cancelled it. Challenging the cancellation of bail, this petition has been filed.
Bail is cancelled.
Oh, the bail is cancelled. Challenging it. My lords, this is second round. Once it was cancelled earlier, my lords, the Madras High Court.
Okay, dates and events.
Well, I've got prepared it. Can I just pass this on?
Let
About
me pass it
25
over. I'll let the SPP come.
Please, my lords.
We'll hear it with the.
25 dates of importance, my lords, in sequence.
25
25 dates, because my lords, earlier it was cancelled, restored back. Now another FIR gets filed, my lords. On that basis, you again cancel it.
We'll see. Yes. Pass over.
Please.
29.
ಅದು ಕೇಳಂಗೆ ಇಲ್ಲ.
30. Withdrawal.
In terms of 31 chamber.
32.
Letter of extension.
Please, my lords.
You have nothing to do. Court has sent it. We'll see. Yes. ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್? Letter of extension ಕಳ್ಸಿರೋದು ಯಾರು ಸರ್? Court ತಾನೆ. Whether it should be given or not is between me and the.
I'll just file a memo.
ಏನ್ ಹೇಳಿ?
Thereafter, the matter is posted on 18th of ensuing month. For my lord, the contempt action was initiated and it is being posted on 18th. And now, my lord, only the record of the proceedings, if my lords were to see, if I may be permitted to.
Contempt ಯಾರು ಹಾಕಿದ್ದಾರೆ?
The contempt, the petitioners here.
Why?
Because my lord, the orders were not, that's why I'm.
ಕೊಡಿ ಇಲ್ಲಿ, ನಾನೇ ಮಾಡ್ತೀನಿ ಆರ್ಡರ್. 3 ತಿಂಗಳು ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ ಮತ್ತೆ. Don't intimidate the judges like this.
If this record of proceedings may be seen, not thrice, my lord.
Right, we will finally now fix it. Yes. This court, another date?
The order is dated, my lord.
Surface proceedings.
Section
ನೀವು ಯಾರಿಗೆ?
You are the my lord, the authorized officer.
Bank ga contempt initiate ಮಾಡಿದೀರಾ?
The section 14 order, my lord, was not at all to be assailed before the, my lord, revisional court. This court, my lord, has categorically held that under section 14, no proceedings can be initiated before the civil court. My lord, there they take ex parte order.
ಅದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರ ನೀವು?
Vacating application.
ಒಂದು ನಿಮಿಷ ಸರ್, 14 ಆರ್ಡರ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
Yes, my lord, they challenged before the sessions court.
ಅದನ್ನ ನೀವು ಇಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ರಾ?
Challenge, we made an application for, my lord, the dismissal.
ಅಷ್ಟೇ ಹೇಳಿ. This court.
If I am to.
1 minute. This court, in writ petition 10587 of 2026 passed the following order. Since the prayer of the present petitioner was innocuous, it was directed that the court decide the matter within a fortnight. The order was passed on April the 8th, 2026. On the score that the order is not passed within a fortnight, contempt proceedings are initiated by the petitioner. It is then the letter of extension is made by the concerned court. In the light of the reasons rendered by the concerned court, the consideration that was directed within a fortnight is further extended for a period of 4 weeks from today, making it clear that no further 6 weeks from today, making it clear that further communication of this kind would be viewed seriously. Why do you intimidate by filing contempt?
No, my lord, what had happened?
ಇನ್ನೊಂದು 6 ವಾರ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. ಇದೆಲ್ಲ ಮಾಡ್ತಿರೋದು ಸರ್ಫೇಸಿ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಯಾರಿಗೋ ಯಾರ ಮನೆ ಮುಗಿಸ್ತಾ ಇದ್ದೀರಾ?
It's not, my lord, the section 14 order, my lord, was,
ತೊಂದ್ರೆ
could not have been assailed before the session.
ಆಗೋಗಿದೆ ಅದೆಲ್ಲ. You should have challenged it if could not have been assailed ಅಂದ್ರೆ.
The very jurisdiction.
You should have challenged it, sir.
He's
Why
not
did you
entertaining
accept it? Why did you accept it?
No, we made an application for
Why did you accept it? You should have challenged it.
Vacating ಹಾಕೊಂತ ಇಲ್ಲಿ ಬಂದ್ರೆ ಏನು?
ಹಾಕೊಳ್ಳಿ.
ಅಲ್ಲ ಅದನ್ನೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇಲ್ಲ ಅಂತ.
ಪರ್ವ ನೋಡೋಣ, ಕೊಟ್ಟಿದ್ದೀವಲ್ಲ ಆಯ್ತು.
That is why, my lord, otherwise why?
ಆಯ್ತು, ನೋ ಪ್ರಾಬ್ಲಮ್. Yes.
Under section 14, it was totally quorum
You
non-judicial.
should challenge it here, sir. As simple as
So let
that.
it be for 4 weeks, my lord. There is
No,
15,
sir. 6
15
weeks.
crores is the due, my lord.
6 weeks, yes. Contempt ಎಲ್ಲ ಆಗ್ತಾ ಇದ್ದಿದ್ರೆ I would not have granted a day's time also. Don't intimidate. Yes.
32,
For the petitioner, please. Complaints petition, madam.
ಮೇಡಮ್, ನೆನ್ನೆ ವೈಫ್ ಒಂದು ಕಸ್ಟಡಿಗೆ ತಗೊಂಡ್ರಲ್ಲ, ಅದು ಯಾವ ಮ್ಯಾಟ್ರ್? ನೆನ್ನೆ ಸಾಯಂಕಾಲ ಮೂವ್ ಮಾಡಿ 2:30 ಮೂವ್ ಮಾಡಿದ್ದು ನಿಮ್ದ್ರಲ್ಲ, ಎಷ್ಟನೇ ಮ್ಯಾಟ್ರ್ ಅದು?
That's 230 matters, serial number 114.
I'll take it at 2:30 sharp. Ask the SPP to come in there.
Complaints petition, madam. That despite even lapse of 1 year, there is no progress in investigation.
Yes, madam. I had asked to secure instructions.
In this matter, SPP will appear, my lord.
Pass over. They ask SPP to come in the afternoon, the many cases. Yes.
33,
PF ಕಾಸ್ಟ್ ಲಿಸ್ಟ್ ಇಲ್ವಾ? ಇದು ಅಷ್ಟೇ, ಲರ್ನೆಡ್ SPP, ಪಾಸ್ ಓವರ್. No, sir. Yes.
admission 34,
Please, my lord.
ಏನ್ ಸುನಿಲ್ ಕುಮಾರ್ ಇದು?
Lord, sir, this is the matter, my lord, sir, where the chief executive officer, engineer, he has filed complaint against the 49 persons, my lords. Against the 49 persons, wherein, my lords, he includes the Grama Panchayati president, vice president, secretary, and the PDO, my lords. Plus, I am representing for PDO, my lords. The allegation is that, my lords, the town, the conversion of the land.
Against the town planning.
ಅಲ್ಲ, but coordinate bench has already permitted investigation.
Permission, coordinate bench is permitted the investigation insofar as the other accused are concerned, my lords. I am the accused number 13, is a PDO, my lords. Is nothing to do with the entire the issue of the layout plan, my
No,
lords.
let the investigation go. ಹೆಂಗು permit ಮಾಡಿದ್ದಾರೆ?
No, my lord.
As against me, my lords, there is no permission, my lord, there is a stay, my lords.
My lord, against me.
Who is Mailarappa?
Mailarappa is the PDO, my lords, then PDO.
ಅವ್ರ ಮೇಲೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪರ್ಮಿಟ್ ಮಾಡಿದಾರಲ್ಲ?
Initially, my lords, stay was granted. Then, my lords, the
Now
investigation was
on
permitted.
11/4/23 it is permitted.
It is permitted, my lords. Now, till today, my lords, the investigation is not completed.
That we will direct what is the stage.
Yes. Let them, my lords, let them. But apart from that, my lords, the Panchayati has issued a certificate, my lords. In the entire scenario, there is no role of this PDO, my lords.
ಆಯ್ತು, ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗಿ when coordinate bench has directed investigation, where is the question of continuing it?
No, my
You
lord.
approach the court if final report is filed.
My lord, that is a elected body. So as per the elected body rules and regulations, the PDO was.
Sir, whatever, when the coordinate bench has directed investigation, where is the question of holding this petition? Final report ಹಾಕಿದ್ರೆ ಬನ್ನಿ.
My lord, concerned authority is not conducting any inquiry on that
Will direct the criminal petition 5429 ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. The petitioner is before the court seeking the following prayer. The coordinate bench on 11/4/2023 had passed the following order. The first respondent was directed to conduct investigation into the offences and submit a report of such investigation within a period of 8 weeks from today. Despite the said order of the year 2023, it transpires that no report of investigation is placed before the court, or before the concerned court rather. The learned HCGP to secure instructions as to what has become of the order dated 11/4/2023, and if no investigation is completed within 8 weeks as directed, appropriate orders would be passed mulcting the investigating officer of exemplary costs. List the matter on Tuesday in the fresh matters, in the same stage. Next Tuesday.
Yes. That's okay. Even after lapse of, my lord, so that
3 ವರ್ಷ ಆದ್ರೂ ಏನು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆ ರೀಸನ್ ಇಟ್ಕೊಂಡು ಕ್ವಾಶ್ ಮಾಡ್ತೀನಿ.
even we verified before the trial court also, my lords. They have not completed the investigation, and all are the government officials, my lord.
We'll see. Yes. Tuesday. Yes,
Much.
next.
35,
Petitioners, madam, in this case, the offences are under section 420, 323, 504 and 506, madam. Idರಲ್ಲಿ, the petitioners are husband, wife and son, my lord. The respondent number 2 is the son of the brother of the Annan Magas.
Brother of the Annan Maga?
So, the brother of the first petitioners. The son of the brother of the first petitioner. ಫ್ಯಾಕ್ಟ್ ಏನಂದ್ರೆ ಅವ್ರಿಗೂ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ಪಿಟಿಷನರ್ಸ್ ಅವ್ರಿಗೆ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾಗಿತ್ತು, ಅದಕ್ಕೋಸ್ಕರ ಮನೆ ಹತ್ರ ಹೋಗಿ ಕೇಳಿದ್ವಿ, ಅದಕ್ಕೆ ಜಗಳ ಮಾಡಿದ್ರು, ಬೈದ್ರು ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿ. As per their complaint, the date of offense is 3/11/2020.
3/11?
2020. But before that, on 17/10/2020, a memorandum of understanding was entered between the petitioners and the respondent number 2 along with family members. At page number 19. Page number 22 ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ. It is agreed by the first parties that all the amounts they had to receive from the second parties and their business establishments, namely so and so, has been settled, and the first parties have agreed that there is no amount to due.
ಎಲ್ಲಿದೆ ಅದು?
Page 22 ಅಲ್ಲಿ sir.
When was that?
That was on 17/10/2020.
Page 22 ಅಲ್ಲಿ ಎಲ್ಲಿದೆ?
Last paragraph sir.
It is agreed.
Also,
There is no amount due.
second parties and the business establishment and so and so.
ಇದು ಯಾವತ್ತಾಗಿದ್ದು?
17/10/2020.
ಅದಾದ್ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಆಗಿರೋದಾ?
ಹೌದು ಸರ್. ಅದಾದ್ಮೇಲೆ on the same day, the sale deed was executed in favor of the ancestral property.
The petitioner's husband, wife and the son are before the court calling in question. ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಇದಾರಾ?
Just now, yes, page 22.
ಲಕ್ಷ್ಮೀಕಾಂತ್.
I'm for the respondent number 2.
Yes, sir.
My lord, my senior is not in station.
ಅದೆಲ್ಲ ಬಿಟ್ಬಿಡಿ. Yes, next. ಏನಿದೆ ಇದರಲ್ಲಿ?
And even on the same day, the ancestral property was sold to some other person, including the petitioners and the respondent and the other family members. Even in that sale deed, clear allegation is there that the amount which should be received by the petitioners has been given to the respondent.
Yes, sir.
and his
Anything
family
else?
members.
ಸುಮ್ನೆ ಕ್ರೈಮ್ ನೋಡಿಲ್ವಾ?
ನೋಡಿಲ್ಲ ma'am.
ನೋಡ್ಕೊಂಡು ಲಂಚ್ ಅವರಲ್ಲಿ ನೋಡಿ 2:30 ತಗೊಂತೀನಿ.
Please ma'am.
Yes, pass over. Next.
36,
SPP.
Malad, so this is Malad, so by the
ಏನ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ
by
ಸರ್?
the state Malad, the deputy commissioner and district magistrate, Malad, so passes an order, Malad, sir.
PFI ದಾ?
Yes, Malad. Malad, we are banning the Malad's respondent organization.
ಅದು ಆಮೇಲೆ ಆಗಿದ್ದು.
Against which Malad, the respondent Malad's prefer an appeal before the district and.
ನೋಟಿಸ್ ಆಗಿಲ್ವಾ?
Page 14.
ನೋಟಿಸ್. ಕೌನ್ಸಿಲ್ ಇದಾರೆ, ಎಲ್ಲಿದ್ದಾರೆ? ಇದಾರಲ್ಲ.
Either.
No representation. List next Tuesday as a last chance. Heard the learned HCGP representing the state. No representation on behalf of the respondent. List the matter on the next Tuesday, same stage. In the event there would be no representation, appropriate orders would be passed on hearing the counsel for the petition. Next.
37,
Hearing for petition, my lord. Kindly in this matter next Tuesday.
No, sir.
Because of today senior counsel.
Because of?
My senior
So?
out of station. in
Out of
Dharwad.
station?
Dharwad.
Yes. We'll send the case also out of the court.
Please, Kudil. Held up in Dharwad.
23ರಿಂದ ಸುಮ್ಮನೆ ಪೆಂಡಿಂಗ್ ಇದೆ. ಎಂಟ್ರಿ ಮಾಡ್ರಿ ತಗೊಂಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Yes, my lord.
Yes, sir. No warrant of continuing the interim order at all.
My lord, kindly date.
The
may
matter to be investigated.
My lord,
as you have
request
tried.
for this unbuckle, kindly date may be fixed.
Nothing, sir.
Next,
Date ivatte. No fixing.
next.
No, sir.
Mangalwaram, sir.
ಇದರಲ್ಲಿ ಸ್ಟೇ ಮಾಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ. ಪಾಸ್ ಓವರ್ ಓದ್ಕೊಂಬನಿ. ಎಸ್ ಮಧ್ಯಾಹ್ನ ತಗೊಂತೀನಿ. ನೋ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಎಸ್ ನೆಕ್ಸ್ಟ್.
38 for the petitioner. That petitioner is husband challenging the interim maintenance order passed by the trial court. Please.
ಎಷ್ಟಿದೆ ಸರ್ ಮೇಂಟೆನೆನ್ಸ್?
That what was happened before I have secured divorce decree. 2016 ಆಗಿದೆ ಹಾಕಿದೀನಿ.
ಅದಾದ್ಮೇಲೆ ಆಗಿರೋದ?
ಹೌದು, 2018 ಮೇಂಟೆನೆನ್ಸ್ ಹಾಕಿದ್ದಾರೆ. 2024 ನನಗೆ ಡಿಗ್ರಿ ಕೊಟ್ಟಿರೋದು ಡಿವೋರ್ಸ್ ಡಿಗ್ರಿ.
ನೋಟಿಸ್ ಆಗಿದೆ?
ಅವ್ರು ಸರ್ವಾಗಿ ವಾಟ್ ಹ್ಯಾಪನ್ ಅಂದ್ರೆ 2022 ಅಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ, ಅಲ್ಲಿ ಎವಿಡೆನ್ಸ್ ಗೆ ಅಂತಿದೆ. ಆಸ್ ಆನ್ ಟುಡೇ ಎವಿಡೆನ್ಸ್ ಕಮೆನ್ಸ್ ಆಗಿಲ್ಲ, ಅಲ್ಲಿ ಬರೀ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರೆ ಅಷ್ಟೇ.
ಏನ್ ಮಾಡೋಣ? ಸ್ಟೇ ಮಾಡೋಣ?
ಸ್ಟೇ ಮಾಡಿ ಒಂದು ಡೇಟ್ ಕೊಟ್ರಲ್ಲ.
For the proceedings where the petitioner shall remain state till the next date, list the matter on 19th August. ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯಾ ಇಲ್ವಾ? ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್
ಇದೆ.
ಇಲ್ಲ ಅಂದ್ರೆ ಸ್ಟೇ ಇಲ್ಲ.
ಐಎ ನಂಬರ್
ಬರೀ ಡೇಟ್ ಮಾತ್ರ.
ಇಲ್ಲ, ಐಎ ನಂಬರ್ 1 ಫೈಲ್ ಮಾಡಿ
ನೋಡೋಣ.
ಪ್ಲೀಸ್.
59.
Permitted to file NOC ವಕಾಲತ್.
ಇದು ಲಾಸ್ಟ್ ಟೈಮೇ ಹೇಳಿದ್ದೀನಿ, ಕೇಸ್ ಇಲ್ಲ ವಜಾ ಮಾಡ್ತೀನಿ ಅಂತ. ಹೌದು, ಲಾಯರ್ ಚೇಂಜ್ ಮಾಡ್ಬಿಟ್ರಾ? ನೀವು ಬಂದ ತಕ್ಷಣ ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ ಕೇಸು.
I understand.
Straight away, to be dismissed, it will be dismissed.
Yes.
Monica Patil was there, I've indicated.
Yes.
Yes. It had come up on 13/7. ಕೇಳ್ಬಿಟ್ಟೆ ನಾನು ಹಾಕಿದ್ದು.
Respond number 2. Counter complaint ಇದೆ.
ಆಯ್ತು, ಒಂದ್ ನಿಮಿಷ. ಕೇಸ್ ಅಂಡ್ ಕೌಂಟರ್ ಕೇಸ್.
But
ಏನ್ ಅಸಾಲ್ಟ್ ತಾನೆ?
Assault.
ಕರೆಕ್ಟ್ ಸರ್.
permitted to file the ವಕಾಲತ್.
You file the ವಕಾಲತ್.
Yes.
Discharge ಹಾಕೊಳ್ಳಿ. Let both the cases be tried and come back after discharge.
Yes.
All right?
The only point is, my complaint was first in time.
No problem.
They are the neighbors.
Sir, whatever, ಒಂದ್ ನಿಜ ಆಗ್ಬೇಕಾ?
ಹೌದು.
ನಿಜ ಆಗ್ಬೇಕಾದ್ರೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಬೇಕಾ? ಲಾಸ್ಟ್ ಟೈಮ್ ಇದನ್ನೇ ಹೇಳಿದ್ದೀನಿ ನಾನು.
ಯಾಕಂದ್ರೆ ಅರ್ಲಿಯರ್ ನಾನೊಂದು FIR ಹಾಕಿದ್ದೆ. ನಮ್ದೊಂದು ಸ್ಟೋನ್ ಕ್ರಷರ್ ಬಿಸ್ನೆಸ್ ಇದೆ, ಅದ್ರ ಮೇಲೆ ಅವರು ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಡ್ತಾ ಇದ್ರು ಅಂತ ಹೇಳಿ ಅನ್ನೆಸೆಸರಿ ಇಂಟರ್ಫಿಯರೆನ್ಸ್ ಅಂತೇಳಿ Annexure F was the FIR that I filed. And on this, the date of the incident, what happens is previous day there is some domestic abuse happening in his house.
Whatever, sir. Case and a counter case.
Yes, sir.
Let it be investigated into.
Yes.
Discharge application ಹಾಕೊಳ್ಳಿ. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಈಗ FIR ಸ್ಟೇ ಆಗಿದೆಯಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ, ಸ್ಟೇ ಇಲ್ಲ. ಚಾರ್ಜ್ ಶೀಟ್
ಸ್ಟೇ ಇಲ್ಲ ತಾನೆ? So let discharge ಹಾಕೊಳ್ಳಿ, come back. Last time I have told. ಈ ಸರ್ even change ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಂತ change ಆಗಲ್ಲ.
I know I don't have a much scope, my lord. Once I was told that the matter was argued.
It was argued at length.
Yes.
I told it, no, nothing doing.
Yes.
Discharge ಹಾಕೊಳ್ಳಿ, let it come back. ಆಮೇಲೆ ಹೆಂಗೂ ಇಲ್ಲೇ ಬರುತ್ತೆ. Both the petition ಎರಡಿದೆಯಾ ಇಲ್ಲಿ ಒಂದೇನಾ?
ಒಂದು ಅವರು
The issue is case and a counter case. I'll first separate order sheet. Registry to print the name of Anandaram Bhatt as appearing for the petitioner in place of Monica Patil. The issue is case and a counter case. A perusal at the complaint, perusal at summary of the charge sheet in the subject petition would clearly indicate that it is a matter that is to be, matters to be tried bada. The learned counsel Anandaram Bhatt would submit that he would prefer an application seeking discharge before the concerned court, seek discharge from the concerned court, and then approach this court in the event the discharge application comes to be rejected. The discharge, in the light of the said submission, the petitioner is permitted to file the discharge application, and in the event the discharge application would go against him, is at liberty to approach this court at a later point in time.
It can be by order. As an order of court.
ನಾನೇ ಮಾಡ್ತೀನಿ ತಾಳಿ. ಇದೆಲ್ಲ ಬಿಟ್ಟು ಹಾಗಾದ್ರೆ ಈಗ ಮಾಡಿ ಮೇಡಮ್. The learned counsel heard the learned counsel appearing for the petitioner and the respondent. The complaint, the summary of the charge sheet is as follows, page 42. In the light of the said summary of the charge sheet, it is I deem it appropriate to direct the petitioners to avail the remedy of filing a discharge before the concerned court, seeking dropping their names from the array of accused from the charge sheet and reserving liberty to the petitioner to approach this court in the event the application does not result in a favorable consideration in the hands of the concerned court. Reserving such liberty, the petition stands disposed.
40.
In this case, my lord, that we have sought, my lord, the quashing of, my lord, the PCR which is filed. Subsequent to, my lord, that
Stay illala?
Intermorder
ಇಲ್ಲ
Intermorder ಆಗಿಲ್ಲ.
ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಮತ್ತೆ ಅಲ್ಲಿ?
This is in same stage, that is not, my
Same
lord,
stage ಅಂದ್ರೆ?
evidenced.
So pollution control board.
Pollution control board.
NBW has been issued
Yes.
as of today against the petitioners and it's not recalled.
Appear sir.
I'll appear.
ಯಾವತ್ತು? Next date ಏನು?
Next date, I'll
Next date
August
ಗೊತ್ತಾ?
ಇದೆ.
August.
7th
You
August.
appear on the next date, then I will consider this.
Please.
The petitioner is said to have been, the sword of a non-bailable warrant is said to be hanging on the head of the petitioner on the score that he has not appeared before the concerned court. Therefore, the petitioner shall appear before the concerned court on the next ensuing date on
7th of August.
on 7th August 2026. In the event the petitioner would not appear on the said date, the subject petition would be dismissed without consideration. List the matter on 12th August.
Please. Yes.
41.
My lord, in 41, I appear for the petitioner. My lord. The offences are 420 and 406 of the IPC. Your lordship will see the complaint, my lord. Interim order was drafted in 23.
Yes.
ಒಂದು ನಿಮಿಷ. ಸೆಕೆಂಡ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ಯಾರು?
Suresh.
ಕೌನ್ಸಿಲ್ ಇದ್ದಾರೆ ಯಾರು?
Yes, my lords. One Suresh for R2.
ಎಸ್ ಮೇಡಮ್.
My lord, the alleged transactions, my lord, between the petitioners and the respondent, my lord, happens in the year 2019 and 22, between those years. On the pretext that, my lord, the petitioners have initially borrowed some amount of 2 lakhs, my lord, from the respondent, number 2. And, my lord, thereafter, my lord, if your lordship will see page 19, the complaint, the unnumbered paragraph, second paragraph, my lord, multiple amounts have been taken and all the amounts that have been collected from the petitioner to the respondent, my lord, are all in cash. That's the allegation. But be that as it may, my lord, the entire allegation is about 35 lakhs. I, my lord, have repaid the respondent number 2, my lord, which I've produced at annexure D.
41 lakhs, that's the interim order.
Yes. I'll also place on record a better copy of the entire transaction, my lord, where
Kodi.
I've... So,
Give that Lakshman.
initially, when the money was borrowed, my lord, despite the money being returned, it's a chit business, my lord. Initially, I taken money for educational purposes that I've returned. Then they continued a chit business. In that, my lord, they've exchanged certain transactions have happened and the amount is up to 35 lakhs that I've returned. Despite that, there was a harassment by the respondent number 2 using the local police's influence. And I have attempted suicide, the petitioner number 1. I filed a complaint of harassment that comes to be registered as an NCR. That, my lord, I've produced at page 21, annexure C. Now, after this, my lord, after 2022, when I file a complaint, this complaint is filed, my lord, against me.
Anyway, let the respondent come. Pass over, Mats.
Great.
If doesn't come, we'll see.
Please.
There is a council, right?
There is, my lord.
ಯಾರಿದ್? TK ಸುರೇಶ. ಇಲ್ದರೆ ನಾಳೆ ಹಾಕ್ತೀನಿ.
Please.
Heard the learned counsel Srimati Kirti Reddy appearing for the petitioner. ನಾಳೆ ಬೇಡ, Tuesday ಹಾಕ್ತೀನಿ.
Please.
Kirti Reddy appearing for the petitioner. There is no representation on behalf of the respondent. In the event the respondent would not be present on the next date, the counsel for the petition would be heard and appropriate orders would be passed. List on Tuesday in the same stage, next Tuesday.
And
Interim order
Lord, and notwithstanding me returning the entire amount back, they've also simultaneously 138 proceedings are also going on. So that also.
We'll see, we'll record this. Yes. List on Tuesday next in the same stage.
Grateful.
interim order subsisting would continue to the next date of hearing.
42.
The respondent number 2 in this case, my lords.
No stay.
No, my lords.
What's the stage? ಈ ನೋ ಸ್ಟೇ ಕೇಸಸ್ ಅಲ್ಲಿ HCGP ಅವ್ರು ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು ನೀವು ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ. ಅಲ್ಲಿ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರೆ ಆ ಟ್ರಯಲ್ ಮುಗಿದೋಗಿರುತ್ತೆ ಒಂದ್ ಸರಿ. Heard the learned counsel appearing for the respondent. There is no representation on behalf of the petitioner. In the event there would be no representation on the next date, appropriate orders would be passed. Next Tuesday, same stage.
43.
Yes, sir. This is 451, 457 application, my lords. Release of gold ornaments, my lords, that was rejected.
By 68. We'll continue at 2:30.
Lords, one mentioning, my lords, serial number 116 is actually extremely important, urgent, my lord.
Extremely urgent.
Tomorrow it's
number
listed.
What is? Please wait. VCL ಹೇಳಲೇಬೇಡಿ wait.
Tomorrow it is listed for charges, my lords. So it may be taken up at
116.
116.
What's the offense?
VAT ಕಟ್ಟಿಲ್ಲ ಅಂತ forgery charges ಹಾಕ್ಬಿಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ. And one of the accused is already caused, my lords. It would not take more than a minute.
Will take. Will take. Yes. ಇನ್ನೊಂದು ಮೇಡಮ್ ಇದು 116 plus wife.
Morning, my lord, I had moved a matter. Your lordship has given a date.
Tomorrow.
ಅಲ್ಲಿ ಹೋಗಿ ಕಂಪ್ಲೈಂಟ್ಸ್ ಮಾಡಿದ್ರೆ ಇದು ಇಲ್ಲ ಸಾಹೇಬರ ಮುಂದೆ ಬರೋದಿಲ್ಲ ಬೇರೆ ಕಡೆ ಹಾಕ್ತೀವಿ ಅಂತ.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಬರಲ್ಲ ಅಂದ್ರೆ no, my lord. Same matters have been taken up by this honorable court, my lord.
ಯಾವ್ದದು? ಧಾರವಾಡದ?
ಅಲ್ಲ Bangalore matters have.
ಮತ್ತೆ?
ಅಲ್ಲ ಅದರಲ್ಲಿ my lord, insofar as some petitioners, my lord, your lordship has already granted interim protection.
Correct.
And these are the different petitioners now I have filing, my lord. So ನಾಳೆ
if it is coming before another bench, let it come.
ಅಲ್ಲ ತಮ್ಮ ಮುಂದೆ ನಾಳೆ ಲಿಸ್ಟ್ ಆಗಿದ್ದೇ ಇದೆ ಸರ್, ಸೇಮ್ ಕ್ರೈಮ್ ನಂಬರ್. ಇದು ನನ್ ಮಾತ್ರ ನಂದು ಸೇಮ್ ಕ್ರೈಮ್ ನಂಬರ್ ಇದೆ.
ಏನ್ ನೋಡಿ ಮೇಡಮ್ ಇದ್ರೆ ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಹೋದ್ರೆ ಅಲ್ಲಿ ಹೋಗ್ಲಿ.
ಅಲ್ಲ ಸರ್, ಸೇಮ್ ಕ್ರೈಮ್ ನಂಬರ್ ಡಿಫರೆಂಟ್
ನಂಬರ್ 45.
ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರ್ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ರಲ್ಲ, ವೈ ಥ್ರೆಟ್ ಆಫ್ ಅರೆಸ್ಟ್? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
But the respondent police, before even the registration of the FIR, they have taken one of the employees and made him sit for overnight in the police station. How there is threat for the bank managers as well. They have been arrested and accused.
Right. Kodi.
Will be taken up tomorrow.
The serial number 45, lordships. For a 4 weeks time, because your lordships, we have filed a revision petition before the Anekal court, your lordships. The matter has been stayed there.
2023 3 ವರ್ಷದಿಂದ ಇದೆ ಸರ್. Wait, we'll see.
ಹಳೆದು ಇಟ್ಟು ಸಿಕ್ಕುಡಿ. ಸರಿ.
Court officer.
Fresh matters, Allah? Yeah. Wife arrested, why?
Placing on record, my lords, the FIR and remand applications, my lords. Certified copies of the FIR and remand application. The complaint was not given, my lords, stating that it is in a sealed cover.
Civil?
Sealed cover ಅಲ್ಲಿ complaint ಇದೆ ಅಂದ್ಬಿಟ್ಟು. We were only given.
ಏನು FIR ಕೊಡ್ಲಿಲ್ವಾ?
FIR ಕೊಟ್ಟಿದ್ದಾರೆ, ರಿಮಾಂಡ್ ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ, ನಿಮಗೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕಾದ್ರೆ ಕೊಡ್ಲಿಲ್ವಾ?
Only, my lords, FIR I had that I have produced.
Grounds of arrest ಎಲ್ಲ ಕೊಟ್ಟಿಲ್ವಾ?
Grounds of arrest ಕೊಟ್ಟಿದ್ದಾರೆ.
Reason for her arrest. The respondent number 2's engagement was fixed. Engagement was cancelled. And your lordship may see some of the messages sent by wife of the accused number 1, who is the present petitioner. And your lordship may see.
But you tell me, how do you justify arrest?
No, but your lordship may see a kind of messages. She takes the data from husband and sends it to the respondent number 2's relatives and blackmails her. And she forces her to, unless you marry my husband, I will not let you.
Unless you marry my husband.
That exactly the case. And in fact, my Mazarali, we have taken the photographs of the.
Yen samachara sir. You want your husband to marry the paramour. Karana?
Engagement was fixed. Engagement was cancelled. In fact, my Mazar, your lordship, you see Mazar. In the Mazar kind of photograph.
As soon as possible, hope your consequences. I wish to should you end up there.
And she, that respondent number 2 has been arrested.
ಯಾವ offense-ಗೆ? ಯಾವ offense-ಗೆ arrest ಮಾಡ್ತಾ
No, the
ಇದ್ದೀರಾ?
fact that she transmitted the explicit images to
whom?
To the respondent number 2's relative.
Where is that?
That my lord in the Mazar we have taken.
Where is that? Where complaint ಎಲ್ಲ ಇಲ್ಲ ಅದು?
ಇದೆ.
ಏನಂತ ಇದೆ?
Complaint ಅಲ್ಲೂ ಇದೆ.
Kindly see the remand application for a moment. First page.
The magistrate ಏನು ಸುಮ್ಮನೆ blindly.
They seek, my lords, 3 days of police custody of accused number 1. The police themselves says, my lords, to remand me to judicial custody for 14 days. According to my lords,
police custody ಕೊಟ್ಟಿದ್ದಾರಾ?
ನಾನು judicial custody. Directly judicial custody.
So ಹಂಗಾರೆ ಏನು custodial interrogation ಬೇಕಾಗಿಲ್ಲ?
ಅವಶ್ಯಕತೆ ಇಲ್ಲ. According to them, according to the remand application.
Your lordship please, ಅಲ್ಲ, your lordship please see the.
Sir, maybe what are the offences now alleged? Tell me.
Against her, my lord, as of now, it's 66 and 120B.
ಅದಕ್ಕೆ arrest ಮಾಡಬಹುದಾ?
No, but that.
ಮಾಡಬಹುದಾ? Plain and simple.
No, she is.
Your arrest should occasion the crime that is alleged to have been committed by an accused. Now the paramour registers a complaint against the legally wedded wife. Correct?
Both husband and wife.
Husband was all right. Husband and wife. Husband arrest ಮಾಡಿದ್ದೀರಾ?
ಅವ್ರನ್ನ arrest.
He is in custody.
He is in custody.
Husband and wife both are in custody.
Both are in custody. He was taken initially for police custody for 3 days. I was directly sent to judicial custody for 14 days.
Mazar, my lord, the lordship.
And what is the offense against the husband?
69.
No, not just 69, extortion. There is extortion also, because your lordship may see.
Extortion against the husband.
Both, against both husband and wife, both.
There's no
yen
specific
extortion,
allegation against me.
Money has
for
been
extortion.
extorted.
Yen money, sir.
Your lordship may see the messages, my lord, and the Mazars, my lord, which discloses.
ಈಗ offense ಏನ್ register ಮಾಡಿದ್ದೀರಾ?
Offense, my lord,
308(2).
308(2). Yes, my lord.
308(2) ಏನು?
Extortion. Punishable below 7 years, my lord.
Yes, sir. Arrest ಹೇಗ್ ಮಾಡಿದ್ರಿ ಅಷ್ಟೇ.
That is the reason, my lord, that.
No, sir.
We need to
You
recover.
can't, reason cannot be according to the whim of the police.
We wanted to recover.
The offense wanted to recover what?
Digital material.
ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಮಾಡ್ಬೇಕೇನು? ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ.
Recover ಮಾಡ್ಲಿಕ್ಕೆ why they have sent me to judicial custody instead of police custody? They themselves sought for judicial custody.
No,
that's all right.
The remand application.
First of all, arrest ಮಾಡಿದ್ದೆ ಯಾಕೆ?
No, to recover the digital data.
No, all this
Recover
will not
digital
work.
data.
ಮತ್ತೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ಬೇಕಾಗುತ್ತೆ 5 ಲಕ್ಷ 10 ಲಕ್ಷ ಸುಮ್ನೆ
No, this is not the case.
ಸಿಕ್ಕವ್ರನ್ನೆಲ್ಲ
No, this is
ಅರೆಸ್ಟ್
not the
ಮಾಡ್ತಾ
case.
ಇದ್ದಾರೆ.
This is not the
Please
case.
see, my lords, page 7 of my pleadings.
This is not
I have
the case.
extracted, my lords, with comparison table.
Just because the lady says ಎಲ್ಲಿದೆ, where is the WhatsApp messages or whatever?
And the engagement.
Who is Pratibha now?
Lords, that is the petitioner.
Petitioner.
That Pratibha. Suchitra is the paramour.
Please.
Today she will talk to her parents about marriage. Which marriage?
Lords,
She wants
what
to.
happened?
She
I
wants.
will narrate the background of the case.
ಹೇಳಿ sir.
2011, my lords, I got married to my lords accused number 1. It was a love marriage, my lords, out of which, my lords, there is a son who is born, my lords, who is aged about 13 years.
From the wedlock.
From the wedlock.
Out of the wedlock.
From the
Yes.
wedlock. Thereafter, my lords, my husband was doing, my lords, sporting store business.
Sporting school.
Sporting store, my lords.
Store.
Store it. In that, my lord's shop, the paramour, my lords, was working.
Working.
Thereafter, my lords, they developed a relationship.
Ah.
According to the complainant herself, she felt that, my lords, there was a dispute between me and my husband, and she has a chance, my lords, to develop a relationship. According to the complaint, my
ಆಯ್ತು
lords,
ಸರಿ.
then, my lords, she develops a relationship. And
Why
now,
are you asking her to get married to your husband?
my lords, what happened, my lords, when the marriage got fixed, my lords, to the paramour, my husband started, my lords, fighting with me. So out of anger, my lords, only it was said, you go and marry her. ಅಷ್ಟೇ.
ಅದು ಗೋವಿಂದ ಈ ತರ.
No, but
ಅವ್ರನ್ನ ಮದುವೆ ಆಗಿಂತ ಆ ಉದ್ದೇಶದಿಂದ ಹೇಳಿದಷ್ಟೇ ಬಿಟ್ಟು.
she takes the
There is no
mobile phone.
intention, my lords, to. There is no divorce.
I will wait
proceedings
till Friday morning before you talk to your parents and inform me with the arrangements of marriage.
But Lordship, what the takes the digital data from her husband, sends it to people.
ಯಾರು
people
ಕಳಿಸಿದ್ದಾರೆ?
ಅಲ್ಲ, ಅವ್ರ ಅಪ್ಪ ಅಮ್ಮನಿಗೆ ಮಾತ್ರ ಕಳಿಸಿದ್ದು ಅಂತ ಎಲಿಗೇಷನ್.
No,
ಯಾರಿಗೆ?
ಹುಡುಗಿಯ ಪರಾಮರ್ದ ಅಪ್ಪ
Husband
ಅಮ್ಮನಿಗೆ
but who's
ಕಳಿಸಿದ್ದೀವಿ.
related?
ಕರೆಕ್ಟ್ ಆಗಿ ಕಳಿಸಿದಾರೆ ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಯಾಕೆ ಮಾಡಿದ್ರಿ?
No, but the recovery of the data, man.
ರಿಕವರಿ ಆಗಿ ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ ಸರ್. ಪೊಲೀಸ್ ಕಸ್ಟಡಿ ತಗೊಂಡಿದ್ದೀರಾ?
From morning
Actually,
7 to
number
5
one,
I
you
was
taken
in
to
police
police
custody.
ಪೊಲೀಸ್ ಕಸ್ಟಡಿ
In
ತಗೊಂಡಿದ್ದೀರಾ?
number one, you are taken to police custody.
ಈಗ ರಿಕವರ್ ಮಾಡಿ ಅವ್ರ ಹತ್ರ.
She
Why is the
also-
wife inside the prison?
She also, my lord, they are not, they have to recover
This
from her
strange
phone.
case where wife complains against the paramour, paramour is taken inside. Paramour complains against legally wedded wife is inside.
This is a strange case.
What strange case?
There is a money trail, money extracted from her. All these things are there, my lord. It's not that simply that.
ಯಾವುದು offense beyond 7 years ಅಲ್ವೇ ಅಲ್ಲ. ಹೌದಾ?
Let him, no.
Let him watch. How can you arrest someone, sir? It is a badge all the life that once arrested. And arrest has become a plaything to the police in this state. I really don't understand. For everything you arrest. Daily I am passing orders. Section 69, you arrest.
That I understand. This is not a regular section. I would not have even made.
ಅಲ್ಲ ಯಾವ್ದು 69 ಏನಿಲ್ಲ ಇಲ್ಲಿ. This is 69.
Lords, no 35(3) notice, nothing, my lords.
have not
6:45
issued,
morning
they
they
have not
arrest me, they take me to police custody, my lords. And till 5 o'clock.
Wholly illegal act on the part of the police. Wholly illegal. ಯಾರು Mr. IO?
It's there's nothing in this thing, my lordship. It is the data found there, my lord.
ಅಲ್ಲ Mr. IO ನ we will on departmental inquiry ಮಾಡುವ.
Not needed. I think they've genuinely done what.
Genuinely done.
There is no.
Paramour ಮಾತ್ ಕೇಳಿ ಮಾಡಿರೋದೆಲ್ಲ ಇದು.
There's a malicious intention, I understand, but there is no malicious intention. Malicious intention, I understand, madam. There is no malicious intention.
Arrest has become.
No, I understand, madam. In fact, that's what I told him.
It's the system has become a mockery.
That's what I
because
told
of repeated arrests of people who have not committed consensual acts, arrested.
That's what I told
This is a case, arrested.
No, that's what I told them.
Husband and the wife both are in prison.
No, that's what I told them. But the fact, my lord, that the engagement was cancelled by virtue of these people's intervention.
Whatever may have happened, sir, crime register ಮಾಡಿದ್ರೆ investigate ಮಾಡಿ.
Correct.
Where is the question of arrest?
But what I'm saying is it's not there. No malicious intention is not there. It is.
No, maybe malicious intentions or bona fide intentions
to
arrest
recover the
ಮಾಡಿದ್ದಾರೆ.
mobile
No,
phones
sir.
and they did not.
ಯಾರು ಕೊಡ್ಲಿಲ್ವಾ? ಫೋನ್ ಕೊಡ್ಲಿಲ್ವಾ?
ಆಮೇಲೆ
ನೋಟಿಸ್
ಕರ್ಕೊಂಡು
ಕೊಟ್ಟಿದ್ರೆ ನಾನೇ
ಬಂದು
ಹೋಗ್ತೀನಿ.
ಆಮೇಲೆ
ನೋಟಿಸ್ ಯಾವಾಗ ಕೊಟ್ಟಿರಿ 35(3) ಇದು?
ಕೊಟ್ಟಿಲ್ಲ. They are not given 35.
ಮತ್ತೆ ಏನ್ ರಿಕವರ್ ಮಾಡಕ್ ಟ್ರೈ ಮಾಡಿದೆ? ಕೋಆಪರೇಟ್ ಮಾಡದೆ ಹೋದ್ರೆ ಮಾತ್ರ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಸ್ ಇದು ಅರೆಸ್ಟ್ ಸರ್. ಕೋಆಪರೇಟ್ ಮಾಡಿದಾರಲ್ಲ, ಮಾಡಿಲ್ವಾ ಇವರು?
ಇಲ್ಲ ಮಾಡಿ
ಕೊಟ್ಟಿದ್ರಿ ತಾನೇ ನೋಟಿಸ್ ಕೋಆಪರೇಟ್ ಮಾಡಕ್ಕೆ.
ಓಡೋಗಿದ್ರೆ ತಪ್ಸ್ಕೊಂಡು ಹೋಗಿರಲ್ಲ.
ಎಲ್ಲಿಂದ ತಪ್ಸ್ಕೊಂಡು ಹೋದ್ರು? ಓ ಇದೇನು ಫ್ರೀಸಿಂಗ್ ಅಲ್ಲ ಸರ್, ನೀವು ನೋಟಿಸ್ ಕೊಡೋದ್ರೊಳಗೆ ಖಾಲಿ ಆಗತ್ತೆ ಅಂತ ಹೇಳಕ್ಕೆ. ನಾಟ್ ಎಟ್ ಆಲ್. highly incorrect. Why, I don't know why police are behaving like this here. We will have to hold that the state, it is in the state of anarchy and no rule of law here. If this is the way police are behaving. Arrest has become a casual thing. Taking a citizen into custody has become a casual thing. How can it be SPP? What is all this?
I have told them.
It's not correct at all.
I told them. But he has justification. Whatever my lord there is.
We keep on writing, Supreme Court writes, arrest should be the last resort. It has become the first resort to you.
That's what I also told them. That's what I also told. Arrest is the last.
This can't be. The petitioner, accused number 2, Kudi Lakshmana, accused number 2 now stands at the doors of this court calling in question registration of a crime in crime number 185 of 2026. The challenge does not rest with the crime, but seeks release of the petitioner from judicial custody. A backdrop to this is necessary to be noticed. There are three protagonists in the list. One, the petitioner, the other, her husband, and the complainant, the alleged paramour. The petitioner and her husband, petitioner and the accused number one get married in the year 2011. It transpires that the complainant and the husband of the petitioner were the complainant husband of the petitioner runs a particular sporting store in which the complainant was an employee. It transpires that the complainant and the husband of the petitioner develop relationship. The relationship is said to be on the pretext of promise of marriage of an already married person to the petitioner. The relationship lasts for several years. Later, when the relationship turns sour, or when the petitioner wife comes to know of the relationship of the husband and the paramour, is said to have intimidated the complainant, the alleged paramour, with dire consequences of having a relationship with her husband, or even says, if you want to marry, you marry the husband. These are what is discernible from the chats. Based upon this, the legally wedded wife of the accused number one, who is said to have had a relationship with the complainant on the pretext of promise of marriage, is now sent to judicial custody. This is what shocks the conscience of the court. For what reason is to be noticed. The offences alleged are the ones punishable under section 69, having sexual intercourse with a woman on by deceitful means on the promise of marriage. This ostensibly cannot get attracted to the petitioner, the legally wedded wife of the accused number one, the husband. The other offense is section 308 within bracket 2, extortion. The extortion is on the specious plea of certain WhatsApp chats between the complainant and the petitioner. The wife in anguish has hurled certain abuses against the complainant on the score that she has taken away the husband from her. And in that, the tone relates to intimidation. This can at best be the offense under section 351 or 352 of the BNS. The extortion theory is projected on the strength of the aforesaid messages, which this court does not find any ingredient of the said offense, be that as it may. None of the offences alleged against the petitioner are the ones punishable beyond 7 years of imprisonment. It is trite law that the arrest of a person is qua the offences alleged. Notwithstanding the same, for the last 4 days, the legally wedded wife of the accused number one on the complaint of a paramour is behind bars. The arrest of the petitioner is sans countenance by any means, as the state has abused its power of arrest against a person who could not have been arrested by legal means. Therefore, it is on the face of it an illegal arrest. The petitioner being in prison, the petitioner is now in prison. Therefore, the corollary is that the petitioner must be directed to be released forthwith from prison. Whether the state should be mulcted with costs for illegal arrest or otherwise will be considered at a later point in time. Further investigation qua the petitioner shall also remain stayed. You take care of the husband. Shall also remain stayed till the next date. List the matter. The registry is directed to communicate this order to the prison authorities to enable release of the petitioner forthwith. It is made clear that the police authorities shall not, the jail authorities shall not brook any delay in release of the petitioner, which shall happen by the evening of today.
Like that the marriage engagement was cancelled by virtue of this petition.
ಅದು ಹೇಳೋಣ ತೊಂದ್ರೆ ಇಲ್ಲ. ಅದಕ್ಕೆ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ರ?
ಅಲ್ಲಲ್ಲ, your lordship, instead of staying, let the, at least comes out the truth will let
You take care of the husband is still in custody.
he is also responsible. In
No
fact, she is the one who communicated all the messages and forced them to.
Wife in anguish, sir.
No, madam. They're also working.
ಯಾರು?
Wife and the.
ಪರವಾಗಿಲ್ಲ, ಅದಕ್ಕೆ ವೈಫ್ an affair with an employee, wife is definitely in distress, ಬೈತಾರೆ, ಇಲ್ಲ ಇದೆಲ್ಲ ಮಾಡ್ತಾರೆ. ಅದಕ್ಕೆ
If that is the case.
No, that is the case. That's not here. It is not the case. You can't view it as right to privacy is violated. She has to protect herself, her marriage.
No, they were working together and then she made all these things.
ಅಲ್ಲ, ಇವರೇ ಫೆಸಿಲಿಟೇಟ್ ಮಾಡಿದ್ರೆ ಅಫೇರ್ ನ ಬೇರೆ ಮಾತು.
That is the link.
ಅದು ನೋಡೋಣ ಬಿಡಿ ಆಮೇಲೆ.
Therefore,
ಹೌದಾ ಸರ್? You want him to marry her?
No, that is the case.
Out of anger and anguish, my lords, he would have.
No, it is not an anguish. It is not an
my
anguish.
lords, for past 5 years, she did
Or
not.
it is anguish or a ploy?
It is not an anguish.
Not from 5 years, my lords, he would ply with a 13-year-old son. That my lords, her
In fact, my
husband was
bank
married.
statement, my lord, speaks otherwise. It's not an anguish. It is not an anguish. Bank statement speaks otherwise.
No, we'll see.
ಅದಕ್ಕೆ your lordship may.
No, husband ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡಿ ಆಮೇಲೆ ಮಾಡೋಣ ಇದನ್ನ.
ಅಲ್ಲ, ಇವ್ರ ಮೇಲೆ.
ಇವ್ರು ಫಸ್ಟ್ ಬರ್ಲಿ ಆಚೆ.
ಅಲ್ಲ, ಅವ್ರ ಆಚೆ ಬರ್ಲಿ, ಇವ್ರ ಮೇಲೆ
ಇನ್ವೆಸ್ಟಿಗೇಟ್ ಮಾಡ್ಲಿ ಬಿಡಿ. ನಿಮ್ದೇ ಪ್ಲಾಯ್ ಇದ್ರೆ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. I will not permit them to harass your ಹಿಂಗ್ ಮಾಡಿ ಸ್ಟೇ ಬೇಡ. It's made clear the petitioner shall cooperate with the investigation. The police on the pretext of investigation shall neither harass the petitioner nor take any coercive steps. In the event such steps are taken, the petitioner is at liberty to move this court at any time.
Great. If it is just this thing, I would not agree. Because
I think no, investigate ಮಾಡಿ, but arrest not at all.
I told that, I communicated that in loud and clear.
You know, 69 you may have some justification because 10 years imprisonment is there. There is some but that is also illegal. But to hold illegal on the face of it following Arnesh Kumar will not arise because of 10 years.
I communicated that in bold letters. Whatever justification he had, I communicated to him that it is.
The wife complaining and paramour getting arrested, understood. Paramour complaining and wife getting arrested.
No, when I read yesterday, my lord, I also did not understand what is this. That's why
I request for hand delivery.
Hand in glove.
Hand delivery.
Hand delivery. Yes. ನೀವೇ ಹ್ಯಾಂಡ್ ಇನ್ ಗ್ಲೋವ್ ಅಂತ ಒಪ್ಕೊಂಡ್ಬಿಟ್ರೆ ನಾನು. ಮೇಡಮ್ ಅದನ್ನು ಟೈಪ್. ದೇ ಆರ್ ಅರ್ಜೆನ್ಸಿ ಇದನ್ನಲ್ಲಪ್ಪ ಏನು?
My lords, I'm for accused number 18, my lords.
ನೀವು ಅರೆಸ್ಟ್ ಆಗಿದ್ದೀರಾ?
ಇಲ್ಲ, my lords.
ಮತ್ತೆ
tomorrow trial court stage is the for framing of charges, my lords. Case is what that I have not paid VAT.
420.
So they have implicated me for forgery, my lords. My lords, what is the case, my lords? Accused number 1 hatra ನಾನು
VAT ಒಂದೇನಾ ಏನು?
VAT on them, my lords. And I have paid that VAT also, my lords. That is at page number, my lords.
What made you come this late, sir?
My lords, it's still charges are not yet framed, my lord.
2014 CC.
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿಲ್ವಂತೆ.
Yes, my lord.
Correct, my 2014 CC, my lord, is coming today.
ಅಲ್ಲ, the only allegation is VAT.
VAT, and I have paid it also, my lords, at page number 89.
Secure the instructions.
Let the court defer its proceedings.
And also, my lords, accused number 5 has been caused, my
ಅಲ್ಲ,
lords.
ಬೇರೆಯವರು ಕೋಶ ಆಗ್ಬಿಟ್ಟಿದೆ.
Yes, my lords, page number 91.
Identical
Same set of allegations, my lords.
That's why he moved it correct. Page
91, my lords, is the order of this honorable High Court. Caution, accused number 5. Same set of allegations.
Title ನೋಡ್ಬೇಡಿ, but same allegations. Accused number?
I am for accused number 18, my lords. And this is accused number 5, my lords. This order is for.
We'll pass the same order, sir. But upload ಆಗಲ್ಲ.
I'll communicate to trial court, my lords.
The petitioner is before the court on the score that the concerned court is framing charges tomorrow. The petitioner calls in question the proceedings in CC 35173 of 2014. Notwithstanding the petitions filed by the co-accused being quashed at the hands of the coordinate bench, accused number 5 had approached this court against whom the same allegations were made, and the accused number 5, the proceedings against accused number 5 is quashed by the following order. Idu CC 2014, same.
Same case.
So,
Co-accused.
the petitioner being the co-accused is entitled to the benefit of the said order. Therefore, the proceedings against the petitioner as well stands quashed. In the light of the matter being tomorrow before the concerned court, the petitioner is permitted, concerned operative portion will release the operative portion. Operative portion matter. Allowed quashed. Yes. Same. Adರಲ್ಲಿ ಇದೆ ಕೃಷ್ಣ ಕುಮಾರ್ ಸಾಹೇಬ್ರ ಆರ್ಡರ್ ಇದೆ, ಅದನ್ನ ಕಾಪಿ ಪೇಸ್ಟ್ ಮಾಡ್ಬಿಡಿ, ಅಕ್ಯೂಸ್ ನಂಬರ್ಸ್ ಎಸ್ ಸರ್. ನಾವು 230 ಲಿಸ್ಟ್ ಸರ್.
And serial number 20, in past 302 matter, my lord, serial number 20.
ಹೌದು 17 ಜನ.
In fact, my last time also when I made a mention, the petitioner took time saying that they want time. Your lordship may see that 26 times opportunity was given for year before charge. And last time.
ಮರ್ಡರ್ ಕೇಸ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿರೋದು.
ಮಿನಿಟ್ಸ್ ಹೇಳಿ ಪೇಜ್ ನಂಬರ್ 86.
ಅದು ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 to 17 ಎಲ್ರಿಗೂ.
ಚಾರ್ಜ್ ನಮಗೆ ಆಪರ್ಚುನಿಟಿ
ಪರವಾಗಿಲ್ಲ.
I request my lord from page 119 onwards. How many times that matter is posted for?
The petitioners are before the court calling in question an order dated 19/2/2024 which frames the charge against the petitioners for the following offences. The offences vary from 143 to 302 of the IPC. The petitioners are the and POCSO and Juvenile Justice Act. The petitioners are, as observed herein above, accused 1 to 17. They are on a plea that the petitioners were not heard at the time of framing of charges. The learned SPP was directed to appear and secure instructions and make his submissions. The learned SPP submits that not on the day of framing of charge, prior to the date of framing of charges, 19 occasions, the matter was listed only for the purpose of framing of charges. The petitioners were not present. Few of them who were in judicial custody were produced, and few of them who were outside have remained absent throughout. It is right that the court cannot wait for ages for the petitioners to appear for the purpose of framing of charges. The court having waited for 19 occasions, there is no warrant of interference at the hands of this court in a case of murder and several other offences on the plea that the petitioners were not heard while framing of the charge. While it is the law that the petitioners have to be given an opportunity of hearing, it is an opportunity of hearing to the accused prior to the framing of charge. It is the opportunity. It's not that the opportunity was not granted by the court, not once, but 19 times. The petitioners having remained absent, a perusal at the order sheet would clearly indicate that the petitioners have deliberately remained absent on every occasion when the framing of charges when the matter was listed.
No, not absent. Each time they sought for time.
One nimsha. Framing of charges. The plea or ploy is not that they would remain absent. They would seek time or file exemption petitions. It is this ploy that led the concerned court to adjourn it on 19 times for the purpose of framing of charges. And the interim order granted by the coordinate bench is operating for the last 2 years in a case of murder. Therefore, murder inter alia, there is no warrant of interference on the plea of these petitioners that they were not rendered an opportunity of hearing, while opportunity was rendered, and it is not once but on 19 times lost by the act of these petitioners. In that light, there is no warrant of interference. Petition stands dismissed.
Correct, my lord, that let the trial be completed.
ಯಾವ ವರ್ಷದ್ದು?
2021.
In the light of the issue of the year 2021, I deem it appropriate to direct the concerned court to conclude the proceedings within an outer limit of 8 months from the date of receipt of the copy of the order, if not earlier.
My application is pending.
ಯಾವುದಕ್ಕೆ ಸರ್?
Pleading.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಾ ಇಲ್ಲಿ?
ಅಲ್ಲ ಇದು ನಾವು ಅಷ್ಟೇ ಆರ್ಡರ್ ಡೇಟೆಡ್ ಕೇಳಿದ್ರು ಸರ್.
ಆಯ್ತು
ಚಾರ್ಜ್ ಶೀಟ್ ಕೇಳಿಲ್ಲ.
Impleading for the reasons indicated in the affidavit accompanying the application, impleading application allowed, heard, ಎಲ್ಲಾರ್ನೂ ಹಾಕಿ.
Please, yes.
Please.
Please.
ಕಾಸ್ಟ್ ರೇಟ್ ಲೆಮೆಂಡ್ ಮಾಡಿ, ಸೋತ್ ಮೇಲೆ ಮಾಡಲ್ಲ ಅವರು. Both matters, yes. Me kariri madam. Nagaraj.
Investigation is at FAG and your lordship.
Why 5 years, madam?
Because there was some miscommunication that there was a stay and uncontrolled, but the investigation has done, your lordship. Maybe 2 or 3 days is required to file.
The learned HCGP Deepthi Alwa submits that the investigation is complete and the final report would be placed before the concerned court in the next 2-3 weeks. Reserving liberty to the petitioner to call in question the final report if he is so aggrieved, the petition stands disposed. The undertaking of the petition, undertaking of the state is recorded and the petition stands disposed.
The petitioner's counsel in this matter.
Yeah, fresh matter, let it come in admission. Supreme Court in Bandiradalva.
Please, sir.
List the matter for admission next Tuesday. Yes.
Next week. And call after 2 days.
Huh?
Call after 2 daes.
Call after 2 days. ನನ್ನ ಆರ್ಡರ್ ನೀವೇ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಏನ್ ವಿಷಯ ಹೇಳಿ
Sorry, madam.
ಏನ್ ಕಾಲ್ ಆಫ್ಟರ್ 2 days
Sorry, madam. Due to some
ನಾನು ಹೇಳೋದು
inconvenience.
ನೀವ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ
Sorry, I am very sorry. madam.
ಹಾ ಎಸ್ ಹಾ ಕಾರಣ
Due to some inconvenience.
ವಾಟ್ ಈಸ್ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್
The on record.
ನೀವು ಹೇಳಿದ್ದು ಇನ್ಕನ್ವೀನಿಯಂಟ್
On record counsel is not coming. madam.
ಆನ್ ರೆಕಾರ್ಡ್ ಕೌನ್ಸಿಲ್ ಇಸ್
Not well today.
ನಾಟ್ ಅವೈಲೇಬಲ್
Available. It's not well.
ನಾಟ್ ವೆಲ್ ಎಂಟ್ರಿ ಮಾಡ್ರೆ ವೆಕೆಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ
Please, sir. Kindly be
ಮಾಡ್ಲಾ?
extended. Sorry, madam. Kindly extend it.
Next Tuesday, at the request of the council appearing for the petitioner in the same stage, it's made clear no further adjournment will be granted in the matter.
Please, madam.
Appearing for petitioner, my lord. My lord, there is no allegation on me, my lord. I'm accused number 9, my lord.
ಏನು ಕೊರಾಬರೇಷನ್ ಇಲ್ವಾ
Page 96. my lord. Recovery from him.
ಫ್ರಮ್ ಹಿಮ್
Yes.
ಎಸ್ ಸರ್
Fully alleged offences on the other accusers.
ಏನ್
my lord.
ರಿಕವರಿ ಮಾಡಿದ್ರಿ
MDM.
MDMA?
MDMA.
4.880 grams MDMA,
ಅಲ್ಲ 20.2.
20.2
ಹೌದು.
ಆಮೇಲೆ
That is what record from him.
Ah,
40
yes.
tablets.
Anything else, sir? So you are not only on the voluntary statement of someone else.
Yes, my lord.
ಬೇರೆ ಇಲ್ಲಲ್ಲ
Is- There is no independent.
ಇಂಡಿಪೆಂಡೆಂಟ್ ಏನು ರಿಕವರಿ ನಿಮ್ಮಿಂದ ಆದ್ಮೇಲೆ ಇಂಡಿಪೆಂಡೆಂಟ್ ಏನ್ ಬೇಕು
Independent is a statement to the witness of.
ಅಲ್ಲ ಸ್ಟೇಟ್ಮೆಂಟ್
CW4
ರಿಕವರಿ
statement.
ಇವರಿಂದಾನೇ ಆಗಿರೋದು ಕೊರಾಬರೇಷನ್ ಏನ್ ಬೇಕು ಎಸ್ ಸರ್ ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ ನೆಕ್ಸ್ಟ್ ಡಿಸ್ಚಾರ್ಜ್ ಫಾರ್ಮ್ಯಾಟ್ ಮಾಡಿ ಎಸ್
I'm appearing for respondent number 1 in this case, Your Lordship. Senior is not feeling well. Kindly have it after.
ಏನ್ ಮಾಡಿದ್ರಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹಾಕಿದ್ರಾ ಸ್ಟೇ ಆಗಿದ್ಯಾ ಸೊ ನೋ ವೇರ್ ಆರ್ ಯು ಕಮಿಂಗ್ ಹಿಯರ್ ನೋ ವೇರ್ ಆರ್ ಯು ಪಾರ್ಟಿ ಹಿಯರ್ ಅಲ್ಲ ಆರ್ ಯು ಪಾರ್ಟ್ ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ನಲ್ಲ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ ಮತ್ತೆ ಯಾಕೆ ಬಂದಿದ್ದೀರಾ ಕರೆಕ್ಟ್ ಸರ್ ನೋ ನೋ ಸರ್ ಯು ಅಪ್ರೋಚ್ ಐ ಹವ್ ಡಿಸ್ಮಿಸ್ಡ್ ಇಟ್ ಅಂಡ್ ಐ ವಿಲ್ ಹಿಯರ್ ಯು
I'm not asking for hearing.
I'll leave it, sir. Give it.
Pleading application which was dismissed.
No.
On the pleading application we have approached.
No
We
worry.
seek for a week's time.
No, you can't, sir.
Allow- May I just make this submission? Order was uploaded on Saturday evening. Millet.
ನಾನು ಫ್ರೈಡೇ ಮಾಡಿದ್ದು ಸರ್ ಆರ್ಡರ್
Please,
ಸ್ಯಾಟರ್ಡೆ ಅಪ್ಲೋಡ್ ಮಾಡಿದ್ದೀನಿ ಅದಕ್ಕಿಂತ ಜಲ್ದಿ ಅಪ್ಲೋಡ್ ಮಾಡಕ್ಕೇನು ಆಗಲ್ಲ
I mentioned before this code for hand delivery as well. My lord.
ಅದು ಕರೆಕ್ಟ್ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಐ ಆಮ್ ನಾಟ್ ರಿಲೀಸ್ಡ್ ಇಟ್ 1 week later, sir.
I bow down. I'm not at all. I only seek for a week's time.
No, you can't, sir. You have no audience. What are you thinking?
I bow down.
If you bow down, then keep quiet. Yes, come on. I really don't understand. When I've dismissed the application, how can you get audience before this court?
I'm not seeking for audience.
Then why are you seeking time? Is that not audience?
It's my right to appeal.
Right, go and tell it, sir. Then right to appeal ಎಲ್ಲ ಇಲ್ವೇ ಇಲ್ಲ ಇಲ್ಲಿ. You have no right to enter ಅಂದ್ಮೇಲೆ no right to appeal. I have not given you, if I have given you right to appeal to the Supreme Court, then yes, I will stay, I will hear you. No, not that. No, sir, I will not. Plain and simple. You leave it, you may please sit. You file it in the registry, yes.
They can't file it
File
in
it
the
in the
registry
registry.
also,
If you
my lord.
want, let him file anything in the registry, no problem. Yes, sir. Yes, yes.
The
Respond number 1 in this case, Your Lordship. Senior is not feeling well, Krishna. Kindly
Ah,
have
not
it
feeling well early. Yes, bank yaru. Ah, yes, sir. Has he paid everything?
OTS is subject to a condition
Ah,
that all the pending proceeding will go on. Page 52 of the petition.
OTS ಆದ್ಮೇಲೂನು.
ಅಲ್ಲ, OTS
ಮುಂಚೆ ಆಯ್ತು. ಈಗ ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದಾರಾ ಇಲ್ವಾ?
It is a condition precedent that the criminal proceeding shall continue.
ಅಯ್ಯೋ ಸರ್, ಈಗ ನಿಮಗೆ ದುಡ್ಡು ಬೇಕಾ ಕ್ರಿಮಿನಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಬೇಕಾ?
Allah, settlement doesn't have it. Please see the.
Where is the settlement, sir?
I filed it on 25th November. 1 minute, sir. 25th November 25. I filed a memo, my lord, where the entire settlement amount has been paid and the property is released to us.
Already released.
Already released. 3/10/25 not settlement certificate.
Lord, page 53 of the petition, my lord. Annexure B.
The OTS is a prior act. Before that,
The compromise is being considered by the bank as a commercial decision.
ಅಲ್ಲ, where discharge ಇದೆಲ್ಲಿ, where are the documents?
I filed it.
There is
No,
nothing.
it's in the
There
second
is
petition.
nothing
I'm
here,
sorry.
sir.
It's not in the. This
First
is,
petition I'm appearing.
I think it's in the second petition.
First petition.
Ah,
Page 53, annexure B.
Memo filed on 25th November 25.
The OTS sanction letter is dated 29/11.
ಒಂದ್ ನಿಮಿಷ. ಯಾವ ಧ್ಯಾನ್ ಸರ್ ಏನ್ ಹೇಳಿದ್ರಿ, ಒಂದ್ ನಿಮಿಷ.
That is over. So that after that, this is come. Where is it?
ನಿಮ್ಮ ಹತ್ರ ಕಾಪಿ ಕೊಡಿ ಸರ್.
Yes, no. 25th November 25.
OTS is complied.
It's paid off fully.
Paid off fully
This is
and
discharge.
property is discharged.
Property is discharged. Your lordship will sign the scene.
Terms of OTS,
Where is that term, sir? ಎಲ್ಲಿದೆ one term ತೋರಿಸ್ಬಿಡಿ.
criminal petition itself.
ಅಲ್ಲ, ಟರ್ಮ್ ಈಗ OTS ಅಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಎಲ್ಲಿದೆ ತೋರಿಸ್ಬಿಡಿ.
ಇಲ್ಲ, ಅದಲ್ಲ.
ಅದ್ರಲ್ಲಿ
OTS sanction letter ಅಲ್ಲೇ.
ಸೆಟಲ್ಮೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲಿ ಯಾಕಿಲ್ಲ?
ಸರ್,
ಅಂದ್ರೆ ನಿಮಗೆ ದುಡ್ಡು, ಒಂದ್ ನಿಮಿಷ, ಬ್ಯಾಂಕಿಗೆ ದುಡ್ಡು ಬಂತ? ಬ್ಯಾಂಕಿಗೆ ದುಡ್ಡು ಬಂತ?
ದುಡ್ಡೇನಪ್ಪ?
ಮತ್ತೆ ಯಾಕೆ ನೀವು, ವಾಟ್ಸ್ ದ ಪ್ರಾಬ್ಲಮ್? ಆಫ್ಟರ್ ದುಡ್ಡು ಬಂದ್ಮೇಲೆ ಏನ್ ಪ್ರಾಬ್ಲಮ್?
Bank has to sacrifice substantially. No.
ಅದೆಲ್ಲ ಸೇರಿಸಿ ತಗೊಂಡಿದ್ದೀರಲ್ಲ ಈಗ.
40 crores against 20 crores.
OTS ನೀವೇ ಕೊಟ್ಟಿರ್ತಾನೆ ಅದು. OTS ನೀವೇ ಕೊಟ್ಟಿರೋದಲ್ವಾ?
Commercial decision taken.
ವಾಟ್ ಎವರ್ ಸರ್, ಇಟ್ಸ್ ಅ ಡಿಸಿಷನ್ ಟೇಕನ್ ಬೈ ದಿ ಬ್ಯಾಂಕ್.
My submission is that the OTS is a condition precedent.
I'm sorry.
ಆಯ್ತು, ಈಗ ತಗೊಂಡು ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಚಾರ್ಜ್ ಮಾಡಿ ಕೊಟ್ಟಾಗಿದೆ.
I think my learned friend not correct himself. That is that OTS of 2023.
This condition OTS was.
This is not the OTS.
Which is the OTS, sir?
53 of the.
1 minute. Yes, Dhyan.
29/11/23 was the first OTS note which we couldn't satisfy.
Page. Wait.
Page 52 of the petition.
Page 52.
52.
52 and 53.
One ನಿಮಿಷ. Yes.
Operative, the clause 11 and 12.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
29/11/23.
ಆಯ್ತು, ಆಮೇಲೆ
ಇದಾದ್ಮೇಲೆ this malord was for 18 crores 90 lakhs plus another.
ಆಯ್ತು, ಇದೇನಾಯ್ತು OTS?
ಇದಾದ್ಮೇಲೆ we couldn't comply with this.
ಆಮೇಲೆ
Thereafter one more request was made.
One more OTS was there or what?
No. Then we paid the money and they closed it. And this
That
is
is by settlement.
This is by the settlement.
It was extended, we could not comply with the terms of the OTS. It was extended and some.
ಆಯ್ತು, it was extended and as per the terms of the
OTS has been fully received. But the condition precedent for the OTS is that.
Condition precedent ಅಲ್ಲ, one of the conditions. It is not a condition precedent. Lot of difference. One of the conditions go condition precedent go.
The compromise is being considered by the bank as a commercial decision and shall have no bearing whatsoever.
Correct. That is not condition precedent. That is one of the conditions.
And the clause 12.
That you have to write. Illare CBI will hound you. ಅದಕ್ಕೆ ಅದಕ್ಕೆ ನಾನು ಬರ್ದಿರೋದು, ಬೇರೆ ಏನು ಕಾರಣ ಇಲ್ಲ ಅಲ್ಲಿ. ಯಾಕಂದ್ರೆ ಬ್ಯಾಂಕ್ ಆಫೀಷಿಯಲ್ಸ್ ಹೆಂಗ್ ಒಪ್ಪಿದ್ರಿ ಇದನ್ನ ಅಂತ ಅವ್ರು ಕೇಳ್ತಾರೆ ಅನ್ಬಿಟ್ಟು ಮಾಡಿದ್ವಿ.
They investigated and have closed the matter with the bank.
ಬೇರೆ ಇದೊಂದೇ ಪ್ರೊಸೀಡಿಂಗ್ ಇರೋದು?
This, for this loan, only this proceeding.
Only this proceeding?
Only this proceeding.
All right, heard, reserved. Yes. ಈ ಪ್ರಾಪರ್ಟಿ ಎಲ್ಲ ದುಡ್ಡೆಲ್ಲ ಖಾಲಿ ಆಗಿದೆ, ಪ್ರಾಪರ್ಟಿ ವಾಪಸ್ ಕೊಟ್ಟಾಗಿದೆ.
Property is returned.
Other petition is the accused number.
ಇನ್ನೊಂದೇನು?
ಅದೇ ಅವ್ರು 3 and 4.
ಅವ್ರದ್ದೇನು?
Same.
Yes, heard, reserved. Next.
Play.
2 days, your lordship, short adjournment, your lordship. Records are not at.
ಇದರಲ್ಲಿ
ಇದ್ಯಾವುದು? ಅದೇ ಅರುಣ್ ಜಿ ಇದ್ರಲ್ಲ ಅದ?
ಅಲ್ಲ
ಅದಲ್ವಾ?
ಸರಿ. ಬಟ್ ಹಿಂದೆ they tried to initiate contempt against me which failed before this honorable court.
ಇದು ಕ್ರಿಕೆಟ್ ಟೀಮ್ ಇದ್ದಂಗಿದೆ ಇಲ್ಲಿ?
ಇಲ್ಲ.
ಶ್ರೀಲಂಕಾ ಕ್ರಿಕೆಟ್ ಟೀಮ್?
ಇಲ್ಲ.
ಎಸ್.
ಅದಾದ್ಮೇಲೆ now they are trying to set up that same complaint in 2022. Ilide adu 54 may be seen. Order passed by the division.
Heard the learned senior counsel Vivek Reddy appearing for the petitioner. In the meantime.
Please.
Yes.
Oblige.
Concurrence.
PCPNDT?
No, not PCPNDT, my lords. Lords, the petitioner was accused, he was convicted in 2 offenses, my lords. Petitioner was convicted in 2 offenses, my lords, arising out of the same crime, my lords. Lords,
Oh, ಇದು 427.
Please, my lords.
ಓ, ಇದು ನಾನು ಯಾಕೆ ಬರೆಯೋಕೆ ಅಂತಲ್ಲ. ನಂದೇ ಜಡ್ಮೆಂಟ್ ಇದೆ, ಕೊಡಿ ಒಂದು 427. ಏನು ತಪ್ಪು ಹೇಳದ್ನಾ? ಮತ್ತೆ ಸೈಲೆಂಟ್ ಆಗ್ಬಿಟ್ರಿ? ಎಸ್, ಟುಮಾರೋ. ಇದು ಎಲ್ಲಿವರು?
Let's this is for release of gold articles, my lord. I am the petitioner. During traveling from Jodhpur to Bangalore, the accused number 1, 2, 3 have taken the gold ornaments from me. And same were required at the instance of the accused persons, my lord, at Kolkata.
ಈಗ application rejected?
Please, my lord.
Page 17, your lordship. Jewelry, there is no identification. They have bar ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನ ಕರಗಿಸ್ಬಿಟ್ಟು.
ಏನ್ ಬಾರ್ ಮಾಡಿದ್ದಾರೆ?
Gold bar.
ಮೆಲ್ಟ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರಾ?
ಹೌದು, ಮೆಲ್ಟ್ ಮಾಡಿ.
ನಿಮ್ದೆ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ಸರ್?
My lord, it is as per their statement, my lord, they have admitted that, saying that it is they have stolen the gold from the.
Correct, they may have stolen gold, but
by imposing any conditions, it may be.
ಏನ್ ಗೋಲ್ಡ್ ಬಾರ್ ತಗೊಂಡ್ ಹೋಗ್ತೀರಾ?
My lord, one more submission, my lord. Since 2024, my lord, the accused are in, they are absconding and not appearing before the court also, my lord.
We'll direct conclusion of the trial.
Please.
That's better. The petitioner is before the court seeking the following prayer. The petitioner claims to be the victim whose gold to the tune of ಎಷ್ಟು kg?
120 gram.
120 grams was allegedly stolen by 3 persons. ಎಲ್ ಮಲ್ಕೊಂಡ್ರೆ?
Train ಅಲ್ಲಿ.
When he was fast asleep in the train.
ಅವರು ಟ್ಯಾಬ್ಲೆಟ್ ಬಾದಾಮ್ ಮಿಲ್ಕ್ ಅಲ್ಲಿ ಟ್ಯಾಬ್ಲೆಟ್ ಹಾಕ್ಬಿಟ್ಟು ನಮ್ಮನ್ನ ಇದು ಮಾಡಿರೋದು.
ಬೇರೆಯವ್ರು ಕೊಟ್ಟಿದ್ ಬಾದಾಮ್ ಮಿಲ್ಕ್ ಯಾಕೆ ಕೊಡಿದ್ರಿ?
ಡ್ಯೂರಿಂಗ್ ದ ಟ್ರಾವೆಲಿಂಗ್.
ಬಾದಾಮ್ ಹಾಲ್ ಅಂತ ಕುಡಿದ್ಬಿಟ್ರಾ?
ಅವರ ಹತ್ರ ಕೊಟ್ಟು ಕುಡಿಸಿದಾರೆ, that is the statement.
The petitioner is before the court seeking the following prayer, madam. On 3/4/2024, the petitioner registers a crime for offense punishable under section 328 and 379 of the IPC on a particular circumstance. While he was traveling in the train, it transpires 3 people offered him badam milk. He drinks it and falls asleep, waking up only to know that all his gold had vanished, totally to the tune of 120 grams. The 3 accused they are not appearing atana. The three accused appear to have converted the gold into gold ingots and now is in the form of a bar. The petitioner files an application under section 451 and 457 of the CRPC seeking release of the gold. The gold was not in the form that it was stolen. Therefore, its identification became difficult and the application was rejected. In that light, the petitioner is before the court. The learned counsel would now submit that the accused are not appearing before the concerned court and a direction be issued to the concerned court to dispose the subject proceedings itself within a time frame. In the light of the issue being in a narrow compass, I deem it appropriate to direct the concerned court to dispose CC 1624 of 2024 with an outer limit of 4 months from the date of receipt of the copy of the order. ಆಮೇಲೆ ನಿಮ್ಗೆ ಯಾವ ಫಾರ್ಮುಲಾ ಆಗಲಿ ತಗೊಳ್ಳಿ. Ordered accordingly.
For petitioners in this case, my lord. But A1, I am for A1, A2, A3, A4 in session court, my lord. I filed a 311 application before the session court.
ಯಾಕೆ ಹಾಕಿದ್ರಿ ಸರ್?
My lord, further cross examination of CW2, my lord. In this.
CW2
my lord.
ಒಬ್ರೇನಾ?
ಒಬ್ರೇ, my lord.
ಎಷ್ಟು ಸರ್ತಿ ಮಾಡಿದ್ರಿ?
My lord, further ಒಂದ್ಸಲ ಮಾಡಿದ್ವಿ, my lord. ಅದರಲ್ಲಿ previous counsel ಇದ್ರುವಾಗ ನಾವು NOC ಫೈಲ್ ಮಾಡಿದ್ವಿ.
Only once. Will permit. The petitioner is before the court calling in question the order of the concerned court dated 23/12/2025 by which the application filed under section 311 of the CRPC seeking recall of PW2 for further cross-examination comes to be rejected. Heard so and so. The petitioner gets embroiled in a crime for offense punishable under crime number 25 of 2019 for offense punishable under section 302 and 201 of the IPC. The issue in the list does not pertain to the merit of the matter. The matter is pending before the concerned court and the trial is on. In the process of the trial, the petitioner files an application under section 311 of the CRPC seeking recall of PW2 for further cross-examination. That comes to be rejected. The rejection of which has driven the petitioner to this court in the subject petition. The petitioner is facing allegations for offense punishable under section 302 and 201. In such circumstance, it is necessary for the accused to get all opportunity to prove his innocence if he can, for which it is in such circumstances the purport of section 311 is to be excised by the concerned court unless the said application is used as a ruse to drag the proceedings or the applications are filed repeatedly in an abuse of the process of the law. In the subject proceedings, it is an admitted fact that the petitioner has the application filed by the petitioner is second in line. In that light, the concerned court ought to have permitted such cross-examination, further cross-examination of PW1. This is the purport of section 311 as interpreted by the apex court in Varsha Garg, so and so. In that light, the petition, I deem it appropriate to allow the petition, set aside the order of the concerned court, permit further examination, further cross-examination of PW2. The concerned court shall fix for the aforesaid reasons the following order. Allowed, the order quashed, application allowed. The concerned court shall fix a date for further cross-examination. It is made clear that the petitioner shall not seek adjournment and complete the cross-examination on the said date. The concerned court shall regulate its procedure for taking the issue to its logical conclusion thereafter. Ordered accordingly.
Appearing for the petitioner in 83.1.
First petition was being in the PMLA Act. There is no predicate offense. Because I'm accused number T2.
In 83.1, there is a predicate offense against the petitioners herein. The issue is that the petitioners are village women in Uttarakhand.
Are?
Village women in Uttarakhand.
Village women?
ಹೌದು. ಅಂದ್ರೆ ಹಳ್ಳಿ
ಆಯ್ತು ಗೊತ್ತಾಯ್ತು, ನೀವು ಟ್ರಾನ್ಸ್ಲೇಟ್ ಮಾಡ್ಬೇಕು.
Yes. So the main accused appearing as NGO workers came forward to the village stating that promising employment to the villagers for payment of 5,000 rupees as salary.
Each?
ಹಾ ಹೌದು.
Village ಗೆಲ್ಲ?
ಮಂತ್ಲಿ ಕೊಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಪ್ರಾಮಿಸ್ ಮಾಡಿ ದೇ took KYC documents with respect to the petitioners.
All right.
And those KYC documents have been misused. The only allegation in the charge sheet is that the KYC documents of the petitioners have been misused. ಅದಕ್ಕೆ ಅವ್ರನ್ನ ಅಕ್ಯೂಸ್ ಮಾಡಿದೀವಿ ಅಂತ ಮಾತ್ರ ಇರೋದು. The main contention here is that this is a power bank scheme that was established. Power bank app anta. Allinda around 900 accounts were created, wherein around 300 crores of the money of general public has been misused, taken.
That's the allegation.
Yes, that is the our proceeds of crime has been layered subsequently. So these are just the shell companies.
ನೀವು ಕಂಪ್ಲೇನೆಂಟ್ ಗಾ?
For the petitioners.
ಅಕ್ಯೂಸ್ಡ್ ಗಾ?
Accused. Yes.
ಎಲ್ಲ ಹೇಳಾಯ್ತಲ್ಲ ಮತ್ತೆ.
Yes.
ಇನ್ನೇನಿದೆ?
The only point here is, my lord, section 3 ಮತ್ತೆ section 70 ಅಂತ ನಮ್ಮ ಮೇಲೆ charge sheet file ಆಗಿದೆ. There is a predicate offense indeed, my lord. But under the section 3 there has to be knowledge. There is no knowingly ಮಾಡಿದ್ದು ಅಂತ ಏನು ಇಲ್ಲ.
ಓ ಇದು ಬತ್ತು ತಿಳಿದೇ ಮಾಡ್ಬಿಟ್ರ 300 ಕೋಟಿ
ಮಾಡಿರೋದು, my lord. These are illiterate people who have no knowledge of English language and ಅವರಿಗೆ employment ಕೊಡ್ತೀನಿ ಏನು ಮಾಡಕ್ಕೆ ಪಾಪಡ್ ಪಿಕಲ್ ಸೇಲ್ ಮಾಡೋದಕ್ಕೆ ನಿಮಗೆ ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡ್ತೀನಿ ಅಂತ. She is one of the petitioners is a widow who's living with her young child, my lord. That is the issue. ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿ ಡೈರೆಕ್ಟರ್ ಮಾಡಿ ಆ ಡೈರೆಕ್ಟ್
ಓ ನಿಮ್ನ ಡೈರೆಕ್ಟರ್ ಬೇರೆ ಮಾಡಿದ್ರ?
ಎಸ್ my lord. KYC ಡಾಕ್ಯುಮೆಂಟ್ ಮಿಸ್ಯೂಸ್ ಮಾಡಿ ಡೈರೆಕ್ಟರ್ ಮಾಡಿ ಅದರಿಂದ ಶೆಲ್ ಕಂಪನಿಯಿಂದ ಪ್ರೊಸೀಡ್ಸ್ ಆಫ್ ಕ್ರೈಮ್ ನ ಲೇಯರ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾರು ಮಾಡಿದ್ದದು?
The main accused, that is Anas Ahmed ಮತ್ತೆ and so on.
ಓ ನೀವು 52?
Yes, my lord. 53. He is 52. I am 38 and 53.
Oh, ibride. All right.
My lord may recollect Hu Zualin Chinese national case which my lord had rejected. That is the wife of Anas Ahmed, who is accused number 1. This is that Chinese national power bank scam that happened. Adralli namna scapegoat madidare. Even the ECIR, for a moment it may be looked into, my lord. Page number 33.
ನಿಮ್ಮ ಅಕೌಂಟ್ಗೆ ಎಷ್ಟು ದುಡ್ಡು ಬಂದಿದೆ ಸರ್?
ಅಕೌಂಟಿಗೆ ಕೋಟಿಗಳ ಮೇಲೆನೆ ಬಂದಿದೆ, ಬಟ್ ನಾಟ್ ಇವನ್ ಅ ಸಿಂಗಲ್ ರುಪಿ has come to the present petitioners.
ಅದಕ್ಕೆ ಇಲಿಟರಸಿ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ಎಷ್ಟು ಬಂತು ಏನು ಅಂತ?
ಅಲ್ಲ my lord, ಇಲ್ಲಿ KYC ಡಾಕ್ಯುಮೆಂಟ್ ಮಿಸ್ಯೂಸ್ ಆದ್ಮೇಲೆ ಅವರಿಗೆ ಆ ತರ ಕಂಪನಿ ಫಾರ್ಮ್ ಆಗಿದೆ ಅಂತಾನೂ ಐಡಿಯಾ ಇಲ್ಲ.
ಮತ್ತೆ ಯಾಕೆ ಬರ್ತಾ ಇದೆ ದುಡ್ಡು ಅಂತ ಗೊತ್ತಾಗ್ಲಿಲ್ವಾ ನಿಮ್ಗೆ?
ಅವ್ರ ಅಕೌಂಟಿಗೆ ಏನು ದುಡ್ಡು ಬಂದಿಲ್ಲ my lord.
ಮತ್ತೆ ಕೋಟಿ ಗಟ್ಟಲೆ ಬಂದಿದೆ
ಕಂಪನಿ ಅಕೌಂಟಿಗೆ ದುಡ್ಡು ಬಂದಿರೋದು.
ಓ ಕಂಪನಿ ಅಕೌಂಟ್. ನೀವು ಡೈರೆಕ್ಟರ್ ಆಗಿರೋ ಕಂಪನಿ
ಡೈರೆಕ್ಟರ್ ಮಾಡಿರೋ ಕಂಪನಿ ಅಕೌಂಟಿಗೆ ದುಡ್ಡು ಬಂದಿದೆ. ಅಂಡ್ ದ ಚಾರ್ಜ್ ಶೀಟ್ ಮೇ ಆಲ್ಸೋ ಬಿ ಲುಕ್ಡ್ ಇಂಟು ಫಾರ್ ಅ ಮೂಮೆಂಟ್ my lord. ಅಲ್ಲಿ ಇಷ್ಟೇ ಹೇಳ್ತಾರೆ, KYC ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದರಿಂದ ಅಸಿಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ, ಅದಕ್ಕೆ ನಾವು ಇವ್ರನ್ನ ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಅಂತ ಮಾಡಿದೀವಿ ಅಂತ. ಅಷ್ಟು ಬಿಟ್ರೆ ಬೇರೆ ಏನು ಅಲಿಗೇಷನ್ ಇಲ್ಲ. That is the only contention. Just because they are directors of a company, they cannot be brought into the web of crime wherein shell companies are formed in their
digest ಆಗ್ತಾ ಇಲ್ಲ.
Yes. They are genuinely village women who have been made scapegoat in this entire web of crime, my lord. Our ವಿರುದ್ಧ ಟ್ರಯಲ್ ನಡೆದ್ರೆ it is an
abuse of the process of
the court.
Miscarriage of justice.
Yes. These are the contentions on behalf of the petitioner.
ನಿಮ್ದೇನ್ ಸರ್?
My only contention is I am not an accused in the predicate offense.
ಅಷ್ಟೇ.
Proceeding does not.
ದುಡ್ಡು ಎಷ್ಟು ಬಂದಿದೆ ಸರ್?
10,000 ರೂಪಾಯಿ.
10,000
ಅಂತ ಅವ್ರ ಕೇಸ್.
ಯಾಮದು? ಮೈಕ್
If I may say,
ಆನ್ ಮಾಡಿದೀನಿ.
there is a predicate offense which gets registered on the complaint of the company Razorpay.
Oh, Razorpay.
Razorpay. Total amount of scam in this matter is around 331 crores. In that, my lords, there are certain companies which have been formed, shell companies, and those shell companies register on this app, and they have taken the money in the garb of a particular nature, but then they have told the Razorpay that is for another purpose, and they have swindled that money. That complaint has been filed.
Oh, Razorpay is the complaint.
Razorpay is the complaint, my lords. If my lords were to see the Razorpay
for a change, Razorpay is complaint.
Yes. Razorpay, my lords. Now, my lords, what has happened is these companies are all layered companies, my lords, and all these persons who are before my lords as petitioners, they are all directors who have signed balance sheets, financials. They are part of the company. Now, my lords, for them to come now and after the cognizance.
Papa, ಅವ್ರಿಗೇನು ಗೊತ್ತಿಲ್ಲ ಸರ್, illiterates. ನೀವೇ ಬೇಜಾರ್ ಮಾಡ್ಕೊಂಡ್ರೆ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ.
ಅಲ್ಲ, I can't talk with emotions, but then my lords, on legality, lordship, my only point is, there are statements which are admissible in evidence as of now. My lords, let them stand trial. The last thing which they can do, my lords, is they have to stand trial. My lords, this is a very serious offense. My lords, every time, my lords, what has happened is after the cognizance, these people come and say, no, we are not aware of it. But then they were the very same directors of the companies who they have signed the financials. Everything has happened because of them. And there have been crores of rupees which have been swindled. At least these three companies, Bestcom and Sachin Maple Leaf and one more company, Millards, where these persons are the directors of the companies.
ಇವರಾ
Yes.
ಹೆಸರು ಯಾರು ಇಟ್ರು ಈ ಕಂಪನಿಗೆ?
Sachin Maple Leaf Commercial Private Limited.
ಏನ್ ಅಕ್ಯೂಸ್ಡ್ ಇಟ್ಟಿರೋದು ಇದರಲ್ಲಿ?
ಓಹೋ, ಸಚಿನ್ ಯಾರು?
ಅಲ್ಲ, ಅವ್ರು ತಮ್ಗೆ ಏನ್ ಹೆಸರು ಬೇಕೋ ಇಟ್ಕೊಂಡಿದ್ದಾರೆ. ದಿವ್ಯ ಜ್ಯೋತಿ ಅಂತ ಇಟ್ಟಿದೆ, ಬೇರೆ ಬೇರೆ ಇದೆ, ದಿಯಾ ಬಾತಿ ಅಂತ ಇದೆ. ಸೆವೆರಲ್ ಕಂಪನೀಸ್ ಆರ್ ದೇರ್. ಇಲ್ಲಿ ಪ್ರೊಸೀಡ್ಸ್ ಆಫ್ ಕ್ರೈಮ್ ನ ತುಂಬಾ ಲೇಯರಿಂಗ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಸೊ ಇನಿಷಿಯಲಿ ದೇ ಟೇಕ್ ಇಟ್ ಫ್ರಮ್ ದ ಪಬ್ಲಿಕ್, ದೆನ್
ನೀವು ಹೇಳಿರೋ ಫ್ಯಾಕ್ಟ್ಸ್ ಎಲ್ಲ ಅನಲೈಸ್ ಮಾಡ್ದೇನೆ ಯು ಶುಡ್ ಸ್ಟ್ಯಾಂಡ್ ಟ್ರಯಲ್ ಅನ್ನೋದು ಒಂದೇ ಕನ್ಕ್ಲೂಷನ್.
that is
seriously disputed questions of facts. Where will I interfere?
Indeed, they are all disputed
Then
questions.
how will I interfere, sir? ನೀವು ಅಷ್ಟೇ.
ಅಲ್ಲ, there's no predicate offense.
ಪರವಾಗಿಲ್ಲ, ತೊಂದರೆ ಇಲ್ಲ. ನಾಟ್ ನೆಸರಿ ಮನಿ ಟ್ರಯಲ್ ಇದ್ರೆ ಸಾಕು.
One submission, only one
120B ಇಲ್ವಾ?
120B ಇದೆ.
ಸರಿ,
ಇವ್ರ ಮೇಲೆ ಇಲ್ಲ.
My only thing is the person who's standing as petitioner, he may not be as accused in the, but then my lord, his company is made an accused first initially, and thereafterwards, my lords, we have made an accused.
The entire complaint they filed, there's no material to demonstrate where did the money come from.
It will come. Don't. No. Anything else, sir?
Over the predicate offense, there should be
Anything else?
only
Yes.
count is
Even in annexure J may be taken for a moment, my lord.
ಈ ಟ್ರಯಲ್ ಯಾವ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ ಪ್ರೊಸೀಡಿಂಗ್?
ಇವಾಗ ಸಮನ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಇದೆ.
On this petition, my lords, they are stop the
ಡಿಸ್ಚಾರ್ಜ್ ಹಾಕೊಳ್ಳಿ. ಇಬ್ರು ಹಾಕೊಳ್ಳಿ. ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬನ್ನಿ, ತೊಂದರೆ ಇಲ್ಲ.
3 ಜನ ಇದೆ. 3 petitioners are there.
ಯಾರು 52, 53, 38, 52 and 53.
Please.
All dismissed, disposed, reserving liberty to file discharge.
Five petitions, Lord.
5 petitions?
All arising out of complaints filed by the wife against the husband and the son.
ಯಾವ್ದು 84?
84, Lord. Your Lordships had briefly heard this. Lord, I won't take more than 5 minutes.
ಮೊನ್ನೆಲ್ಲ ಕೇಳಿದ್ನಲ್ಲ.
1 week in there. 5 minutes, just 5 minutes.
Yes.
Lord, marriage happens in 1988. Marriage happens in 1988. In 2020, the wife goes to the sub-registrar's office and executes a registered GPA in favor of the husband. On the same day, there are 3 other gift deeds that are executed in favor of the wife. This is just to show she goes there, she spends the entire day before the sub-registrar. 3 years later, she files a complaint, the wife, against the husband and son, on the premise that, Lord, the husband has coerced her into signing the GPA.
That
the first complaint.
3 years ago.
3 years ago, there's a registered GPA. 2023, 18th February, she goes and lodges a crime against the husband and son under 498A that she was coerced into signing a GPA, therefore it amounts to cruelty. Lord, then comes the second complaint. She does not go before the same police station. She goes, the first one was in Davangere Women's Police Station. Then she comes to Bangalore 3 months later in Baswangudi, Lord, another complaint on the same allegation. But here the only difference and the material improvement is, there it was coerced into signing the
ಎರಡರಲ್ಲೂ complainant is the wife.
All 5 wives. All 5
wives?
All 5, the informant
By
is
the wife.
By the wife. Against the husband and the son. The second complaint is before Baswangudi police. There the material improvement is that the GPA was a case of fabrication. First it was coercion, now it is fabrication.
Why relationship is strained, is it?
The relationship gets strained between 20 and 23. So
ಆಮೇಲೆ ಈ ಕ್ರೈಮ್ ಎಲ್ಲ ಆಗಿರೋದು.
ಎಲ್ಲ crime ಇದೆ, civil suit, a 100-page plaint with 26 prayers, all asking for cancellation of that GPA and then consequential prayers. Then, Lord, the third complaint, after we get a stay in respect of the second complaint lodged in Baswangudi, third complaint in 24, she goes again to Davangere, but a different police station. All lawyer drafted complaints. Now she says GPA is a forged document. And in the middle, Lord, 2 other complaints, one against the son that he has committed trespass in respect of which he lives there. I have the video, Lord. He's not entered the gate. The police have filed a charge sheet. The mother files a complaint against the son.
Police ಹಾಕದ್ ಬಿಡಿ, ಅವ್ರು ಹಾಕ್ತಾರೆ.
And then, Lord, there is one more car theft allegation which the RC stands in their name. One of the other cars.
I said car ಕೊಟ್ಬಿಡಿ ಅಂತ ಹೇಳಿದ್ನಲ್ಲ.
Car ಕೊಡ್ತೀವಿ. We'll give the car, but on one submission, there is a car in which the RC stands in my name in her possession. Let them return this car. I'll return. If some accident happens,
which is a better car?
I don't know. Which is
That's an old car here.
Honda Chas, Honda?
I want give back the
Yes,
car,
yes.
take back the car.
We'll give this car, let them give that.
Give and
Not
take
part of the
cars.
petition itself.
It's not, but I'm only saying.
That's okay. You give and take the cars.
Therefore, Lord, 35 years after the marriage, there is a matrimonial dispute pending.
35 years ಆಗಿದೆ ಮದುವೆ ಆಗಿ.
ಮದುವೆಯಾಗಿ 35 years ಆದ್ಮೇಲೆ. Then there is a matrimonial case pending. There's an original suit. They know that it will be extremely difficult to prove a cancellation of a GPA of which is registered. Now, Lord, there are biometrics. So you go before the sub-registrar, you need to lodge your biometrics. So there's no way you can show that this was biometrics were forced into your doing the biometric. So in respect of the same act, there are 3 complaints before 3 different police stations, everything hit by TT Anthony. And Lord, there's one more recent judgment of not Justice Vipul Pancholi, material improvement in 2026. So in respect of same allegation, 3 years later, delay, 3 different allegations, coercion, fabrication, forgery, all 3 different acts, no, before 3 different, all lawyer drafted. No, therefore, no, my respected submission is one shot, everything should go.
Your Lordship, first of all, it was the wife after 35 years filed this complaint, not as regards the entire violence that happened in 35 years, but which happened a fortnight, a month before the estrangement. It's not that the allegations are remote in nature of.
No, ಇದರಲ್ಲಿ ಏನು ಬರೀ ಫೋರ್ಜರಿ ತಾನೆ.
No, Your Lordship.
Forgery 420.
3 different.
498 ಇದೆಯಾ?
498 is the first one. Ali GPA coerced into signing, which means she admits signature.
No, Your
But
Lordship.
she says, as someone held a gun to her head, she says it's coerced. Then it changes, it becomes forgery, which means it's not her signature. Someone has.
Your Lordship, there are multiple power of attorneys. One was unregistered, and at that time, she assumed that these documents which were executed were based on those unregistered documents. Later, there is no denial of the fact that I did not go to the sub-registrar office. I went. There were 5 documents executed on the same day. 3 of them were gift deeds. Your Lordship had sought for a small synopsis.
Small ಅಂತ ಏನು 100 page
I have a
ಇದ್ದಂಗೆ?
synopsis, not 1 page synopsis. Your Lordship may just refer to that. No, give that 1 page list of pages. Just keep it. Not, there's one more thing, not very reluctantly I have to submit. Not the GPA, the advocate will advise the present petitioners in respect of the GPA. Not the same advocate is now running the litigation on behalf of the wife. I believe there is a bar council complaint filed pending because not it's a breach of conflict, Rule 19.
As well, it will see. Yes.
Synopsis.
All right, tell me.
No, Your Lordship, 498A concerns the cruelty. Your Lordship, I have a synopsis there with the pictures.
498 this is.
Ratings. Madam?
Pictures ಯಾಕೆ pictures ಯಾಕೆ?
The pictures of violence.
Not part of the charge sheet, no wound certificate.
No,
in the charge
no.
sheet.
Your Lordship, it is part of the charge sheet.
No wound certificate.
Madam,
ಕೊಡಿ.
we have filed objections also, Your Lordship.
Where is that?
Now, Your Lordship, these acts of violence have just preceded the filing of the complaint. Now, I filed a complaint for all the events that happened. One, aspects of forgery, aspects of fraudulent transactions, and also violence, which is all part of 498A. I agree to that. Subsequently, I filed 2 complaints. One as regards one fraudulent transaction that happened in Bangalore. At that time, I did not realize that all these transactions have also taken place in Davangere. Then I filed a consolidated complaint. I agree that one aspect of the complaint is similar to what happened in Bangalore and Davangere. So I'm willing to concede to the fact that the complaint filed in Baswangudi, Bangalore can go because it has similarity to offences in Davangere. Now, Your Lordship, I have filed the synopsis there. Now, 5 documents get executed on the same day, 3 executed by my parents, and 2 of them got executed by the petitioners. Now, at 4:45, Your Lordship, the documents are there, which these documents were presented at 4:45 when my parents left after the registration, and I have no idea what I'm signing. I assume that these are documents of gift deed and executed by my parents. Now, therefore, Your Lordship, I execute these documents and much later, about 1 year later, I realized that based on this power of attorney, all my assets, all my properties are taken away and sold it to my son. Now, if a mother has to give properties to the son, why would I sell it, Your Lordship? I would gift it. Now, this is gives a strong suspicion, Your Lordship. These are factors which need to be tried. I am only pressing on those two aspects, Your Lordship. One is 498A and the other is as regards fraudulent registration of the documents. I'm not talking about forgery. I'm not saying that I did not go to the sub-registrar office. I went to the sub-registrar office, but I signed those documents not realizing the fact that these were power of attorney and a gift deed which was additionally executed by me.
Ashana?
Yes, Your Lordship.
In all the three complaints, no reference to the prior, suppression everywhere. You go before one, you don't reveal that before the other. Not. And now what they say now, admittedly they say now, 1 year after they executed the registered GPA, they got to know. But the complaint for the first one, 498, is filed 2 years after their knowledge.
Lordship, over a period of time, I did not know these factors till about 2023-24 that these events have happened. Over a period of time, the moment I get to know, I file a complaint. Merely because I filed a suit for seeking for cancellation does not escape the criminality there, Your Lordship.
We'll see. We'll post it on 31st, we'll dictate.
Grateful.
Heard, so and so. Post for dictating orders on 31st. $85.
The offences are 306.
Abatement.
Abatement to suicide. my lord.
The respondent, my lord. My lord, it is a matter where, my lord, prior to the incident, complainant, my lord, the deceased had filed a complaint against the accused, wherein, my lord, he had undertaken, my lord, not to pester her. This has been happening for quite some time, my lord. There were pictures, my lord, of the deceased in the phone of the accused, my lord. There was an alliance, my lord, which came to meet the deceased, my lord, on the day of which
Who's deceased and you were in relation?
we were not in relation.
Then why is this?
My lord, the deceased, accused, my lord, was pestering the deceased to marry her and love her, my lord.
Marry her.
There were certain pictures, my lord, in his phone where they had gone to one temple. Prior to which, on 5/7, she had attempted to commit suicide and NCR was registered, my lord. I'll pass on this document, in which, my lord, he undertakes, my lord, not to, my lord, contact
Stay and
her.
Madilwala.
Say madilla.
Matte.
There are, my lord, 23
Investigation
witnesses.
agli.
My lord, after
All the
undertaking,
After?
after undertaking that NCR, what they are saying, ಅದಾದ್ಮೇಲೆ ಅದು before prayer, one year prayer, my lord ಆಗಿರೋದು.
Incidenಟ್ ಯಾವಾಗ sir?
21 days, my lord.
Incidenಟ್ ಯಾವಾಗ?
Incident
29/7/2025.
Complaint is 37.
My
NCR
lord.
is on 7/7.
My lord,
21 ದಿನ
Oh,
ಆದ್ಮೇಲೆ
so what? NCR ಆದ್ರೆ?
No, my lord. ಒಂದು humble submission, my lord. ಅವರು ಅಲ್ಲಿ suicide ಮಾಡ್ಕೊಂಡ್ಮೇಲೆ they have not informed to the local jurisdictional police. ಅವರೇನೆ ಡೆಡ್ ಬಾಡಿನ ಇಳಿಸಿ ಅವರು ಅವ್ರ ತಂದೆಯವರು ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಸ್ವಾಮಿ. Kindly come to the page number, in page number 11, my lord.
You are the sole accused, huh?
I am the sole accused, my lord. My lord, the allegations are, every allegations are false, my lord. I have already married to the one Chaitra in the year 2019 and I have a daughter in the year 2020, my lord. My lord, the only connection between the petitioner and the deceased is the deceased father, who is the acquaintance in the native. He supposed to give the money to transfer through the phone pay to her daughter.
Objections ಹಾಕಿದ್ದೀರಾ?
NCR, I'll just pass on this.
ಅಲ್ಲ
NCR.
objections ಎಲ್ಲಿ?
ಅಲ್ಲ, but there's no stay, my lord. I thought it
ಅದಕ್ಕೆ
was-
ಬೇಕಾಗಿಲ್ಲ ಅಂತ.
ಅಲ್ಲ, I'll argue. NCR ಮೇಲೆ, if my lordship looks at the
NCR, don't worry about that argument at all.
please, I'll find my objections. my lord.
File your objections.
Detailed objections.
File objections, whatever conversation is between the two, you file. Anyway, there is no stay.
Please, my lord.
We'll post it on 12th August.
Obliged.
Objections, if any, by the complainant by then.
My lord, the petitioner is having a small child, child and wife, my lord. He is facing humiliation in the society.
Oh, seriously?
Please,
Why
my
did
lord.
you converse, sir?
There are about 8
Sir,
witnesses.
as you so you reap. ಏನು ಮಾಡಿದ್ರೆ ಏನು ಆಗ್ತಾ ಇರಲಿಲ್ಲ.
My lord, the only relation, only connection between the deceased and the petitioner is the payment which was done by the petitioner to the deceased on the instruction by the deceased father, my lord. ಅದ್ ಬಿಟ್ಟು ಬೇರೆ ಏನು ಇಲ್ಲ, ಪರಿಚಯ ಇರೋದಷ್ಟೇ ಅವರು.
ಹಾಕ್ಲಿ ಬಿಡಿ,
NCR
ಅವ್ರು ಏನಿದೆ ಎಲ್ಲ
allow-
ಹಾಕ್ತಾರೆ.
take ಮಾಡಿದ್ದಾರೆ, my lord. They have said-
File objections, madam.
Obliged.
Yes, 12th August.
Grateful.
Next.
Physics, my lord.
ಏನಿದು?
The petitioner, my lord, where GST officials, my lord, enter the premises, my lord.
Oh,
And
GST intelligence.
GST intelligence, my
Yes.
lord. ಆದ್ರೆ ಇದರಲ್ಲಿ ಸ್ಟೇಟ್
ಅದು objections ಹಾಕಿ.
ಸ್ಟೇಟ್ ಇದೆ, my lord.
I will not stay this.
ಅಲ್ಲ, my lord, they are only assaulted, ಅಷ್ಟೇ allegation, they are not even involved in this case, my lord. My lord, in the connected matter, my lord, there is already interim protection has been given.
ಯಾವ್ದು protection?
4631 of 2026.
ಏನ್ interim protection?
Not to take coercive step, my lord, but they are.
Are you appearing before them? Investigation ಆಗ್ತಾ ಇದೆಯಾ?
My lord,
We are the
ಕೂರ್ದಲ್ವಾ?
complainant.
But they are already in bail, my lord.
No problem, yes.
Just an allegation, my lord, they have assaulted, my lord, but there is, even in the CCTV footage, it has been
ಆಯ್ತು,
recorded,
let
there is
the-
no any allegation, my lord.
Investigation papers produce ಮಾಡಿ ಕೊಡಿಲಿ. Placed on 6th August, yes.
It's a clear case, my lord, for
Oh,
interim
no,
protection.
yes.
My lord.
Next.
Even connected matter is there, my lordship, 463.
Tag the petition along with 4631
of 26.
Yes, tag next.
In the CCTV footage, my lord, it clearly says.
ಕೊಡ್ಲಿ tag.
Investigation.
80. Binu.
NDPS offense, my lord.
NDPS matter where
Corroboration.
postal idrinda bandirodu. Parcel.
Postal.
A1 is
Recovery
the
from the-
accused and money trails are there, your lordship. They may
Recoveries from
charge it.
foreign post office, my lord. Recoveries from foreign post office.
ಇಲ್ಲ, recovery is only in the post office, not with you.
Not my, first FIR, my lord, is registered on
And control delivery case.
25, my lord. Yes, my lord. First FIR is registered on
Again,
24/9.
charge sheet ಆಗಿದೆಯಲ್ಲ?
ಆಗಿದೆ.
ಟ್ರಯಲ್ ನಡೀತಾ ಇದೆಯಾ?
Appearance of
ಸ್ಟಾರ್ಟ್
accused.
ಆಗಿಲ್ಲ ಸರ್.
ಸ್ಟಾರ್ಟ್ ಆಗಿಲ್ವಾ? ಯಾವ ವರ್ಷದ ಇದು?
2025.
25.
Second case, my lord, that
We'll take it on
ಒಂದ್ರಲ್ಲಿ ವಾರಂಟ್ ಇದೆ ಸರ್ ಮಿಸ್ಟೇಕ್.
warrant will. They list the matter on 11th August. The petitioners shall, the warrant hanging on the head of these petitioners shall remain state till the next date.
Petitioner. But the decree of divorce has been granted, my lords. At that time, my lord, the permanent elimination was granted to the petitioner to an amount of rupees 5 lakhs. And to an amount of rupees 2,500 to the temporary maintenance was granted to the second respondent. Suppressing that part, my lord, under section 125 CRPC, again she filed maintenance petition before.
ಡಬಲ್ ಜಿಯೋಪಾರ್ಡಿ ಅಂದ್ರೆ ಏನು? ಕನ್ವಿಕ್ಟ್ ಆಗಿದೆ. ಎಲ್ಲದಕ್ಕೂ ಡ್ಯೂಯಲ್ ಪೇಮೆಂಟ್ ಅಂತ ಹೇಳಿ ಸಾಕು. Yes. There shall be an emergent notice, there shall be an interim order of stay of the payment of maintenance of.
No, I'm not sought for any maintenance, my lord. Already 5 lakhs as amount has been paid, my lords. And the continuously paying the maintenance. Suppressing that fact, my lord, under section 125.
ಏನ್ ಆರ್ಡರ್ ಮಾಡಿದ್ದಾರೆ ಸರ್?
My lord, the present petition is filed by the respondents under section 125 CRPC.
ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ?
Not at all.
ಮತ್ತೆ ಯಾಕೆ
Just
ಆರ್ಡರ್
notice-
ಆದ್ಮೇಲೆ ಬನ್ನಿ?
My lord, the only remedy for the respondents, they can seek for alteration or modification of the permanent
ಇಲ್ಲ,
element.
whatever.
In your
If there
judgment.
is, ಅದನ್ನ ಅಲ್ಲೇ contest ಮಾಡಿ ಆರ್ಡರ್ ಆದ್ಮೇಲೆ ಬನ್ನಿ. The petitioner is the husband, is before the court calling in question proceedings in criminal miscellaneous 417 of 2024 on the score that the decree of divorce is granted and the petitioner has paid permanent alimony and is also paying the maintenance that is awarded in terms of the decree. Suppressing all this, the wife has now approached the concerned court in a concerned court invoking section 125 of the CRPC seeking further maintenance. The learned counsel submits that the only remedy that is available to the wife is to seek modification of the decree of divorce, which is on certain terms. It is an admitted fact that the concerned court has not passed any order in the criminal miscellaneous 417 of 2024 even today. Therefore, the petitioner shall, therefore, in the event any order would be passed against the petitioner is at liberty to approach this court. Without any order, there is no warrant of interference today ordered accordingly. With the aforesaid observation, petition stands disposed. Next.
For the petitioner, defreezing.
Eve teasing.
Defreeze, account defreeze.
Defreezing.
Yes, ma'am. And lien lift.
Yes, madam.
Only disputed amount ಮಾತ್ರ ಲೀನ್ ಮಾಡಿದ್ದಾರೆ madam.
ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಿರೋದೇ ಅಷ್ಟೇ?
ಅಷ್ಟೇ madam.
ಎಷ್ಟು ಡಿಸ್ಪ್ಯೂಟೆಡ್ ಅಮೌಂಟ್?
14 lakhs. ma'am.
14 lakhs.
It's
14 lakhs
85,260.
complaint.
Huh.
I was the manager
Hmm.
in the bank, my lords. After my retirement benefit, I utilized the fund and invested in WO company,
Hmm.
where the complainant is invested the same
Hmm.
company.
Hmm.
I am also one of the victim, my lords. There.
Hmm.
And second, third layer ಅಲ್ಲಿ ನಂದು account transaction ಆಗಿದೆ ಅಂತ ಹೇಳಿ they lien the entire amount.
The
32 lakhs.
petitioner is before the court seeking the following prayer. Nimge. Seeking the following prayer. The petitioner is was working as a branch manager in which bank?
Indian.
An Indian bank, and after retirement invest certain amount in ಯಾವ್ದಿದು?
WO.
In
WO
app
traders.
ಅದು ಏನು?
WO traders.
In WO traders. WO traders is now caught in the web of proceedings on the score that the petitioner has also invested into the said trading company and was likely to be involved in the offense. The account of the petitioner comes to be frozen or lien is marked of the amount of 14 lakhs. Huh?
14
No,
lakhs,
my lords. Complaint
85,000.
ನಮ್ಮ ಇದರಲ್ಲಿ 32 lakhs ಮಾಡಿದ್ದಾರೆ ನಂದು amount.
ಇಲ್ಲ,
And
ನಾವು
the
lien
amount of 32 lakhs is marked as lien in the account of the petitioner. Therefore, the petitioner approaches the concerned court seeking defreezing or demarking of the lien. That having been rejected is before the court in the subject petition. The petitioner taking this court, counsel for the petitioner taking this court through the documents appended to the petition would demonstrate that he is also a victim from the hands of the said traders. The amount that he has got into his account is legitimately his, as it is a part of the investment and not the amount that can be claimed to be a fraud. The petitioner, a retired employee or a retired branch manager, has put all his savings or retirement benefits into this trading company in the for a larger gain and is now caught. He has neither money nor the account to be operated with. In the light of the said circumstance, what is necessary to be noticed is whether the account of the petitioner could be frozen on the score that he has invested certain amount in WO traders, which the WO traders for higher returns. Defreeze ಮಾಡಿದಾರಲ್ವಾ?
Defreeze ಮಾಡಿದ್ರೆ lien held.
The concerned court on an application filed by the petitioner passes the following order. The order is marking of lien on 32 lakhs of in the account of the petitioner and defreezement only to an amount of 10,91,000. And defreezement of the account for its normal operation. However, the facts narrated herein above would clearly indicate that the petitioner is also in the shoes of a victim in this on the score that he has invested his retirement benefit in the said account, and therefore marking of a lien would cause grave prejudice to a man who has retired and cannot be seen to be indulging in any of the crime that is said to any of the crime. In that light, the lien that is marked shall be demarked forthwith by the who has marked? Bank.
Bank
The
based on the notice.
investigating officer shall direct the demarking of the lien of a retired person to enjoy his terminal benefits. Yes, ordered accordingly.
My lord, cognizance is taken for offense under 499 500. A complaint was given before the Lokayukta by the petitioner alleging that accused number 2 is obstructing the construction of a house. It also is misusing the Lokayukta name. Based on that, he has initiated a PCR.
ಏನ್ ನೀವು ಲೋಕಾಯುಕ್ತಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತೀರಿ ಅಂತ ಹೇಳಿದ್ರ ಅಥವಾ ನೀವೇ ಲೋಕಾಯುಕ್ತ ಅಂತ ಹೇಳಿದ್ರ?
ಅಲ್ಲ, ಲೋಕಾಯುಕ್ತ ಹೆಸರು ದುರ್ಬಳಕೆ ಮಾಡ್ಕೊಂತ ಇದ್ದಾನೆ ಅಂತ
ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ದುರ್ಬಳಕೆ?
ಅಲ್ಲ, ನೋ ಪಬ್ಲಿಕೇಶನ್.
Publication?
ಅಲ್ಲ, ಪಬ್ಲಿಕೇಶನ್ ಏನು ಮಾಡಿಲ್ಲ. ಕಂಪ್ಲೇಂಟ್ ವಾಸ್ ಗಿವನ್.
ಏನು ಉಸ್ಮಾನ್?
A PCR has been filed by me, alleging the sections 499 500 because of the scathing attack made on me by him before the Lokayukta in a letter, my lord, and sworn statement was recorded And
Why,
the
again, what's
magistrate
wrong with
has
this?
followed, yes,
My lord,
magistrate
with
has
respect
followed
to
the,
same subject matter, my lord, a 1 lakh rupees cost was imposed by this honorable court, my lord.
Parval, that doesn't stop defamation.
My lord, there is no publication and it aptly fall under the exception under 7, my lord. May I read out?
Publication ellide?
ಎಲ್ಲೂ ಇಲ್ಲ.
my lord, no, he has filed the letter, my lord.
Where is the letter?
Letter
That
is in,
letter-
my lord,
Page.
page number 43, my lord. It is
Letter ಯಾರಿಗೆ ಬರೆದ್ರು?
ಲೋಕಾಯುಕ್ತ.
Anything else, sir?
My lord, it falls under the exception in 7, my lord, of 499.
Anything else?
My lord, and there is delay of 1 year, my lord,
So,
in filing the complaint.
My lord, the
3 years
defamatory
limitation.
content,
Yes, ma'am.
the defamatory content has been culled out, my lord, by the learned magistrate in the order. That is at page number 26.
There is
my
no
lord.
warrant, sir, of interference.
My lord,
Trial.
one submission, my lord. Kindly see the order of this honorable court, my lord. Page
Does
number.
not stop him from filing defamation at all.
My
If
lord-
this court had directed don't file, then it's a different.
My lord, kindly see the conduct of the respondent, my lord, before the high court, my lord. It has been
Stay
recorded.
ಇದೆಯಾ ಇಲ್ಲಿ?
Stay ಇಲ್ಲ.
ನಡೀಲಿ ಬಿಡಿ
My
trial.
lord, and also, my lord, one submission. The petitioner was acting on as a director of the company, my lord. Subsequently, he has resigned from the company. my lord.
Parval, defamation, resignation does not wash out defamation. Person to person, not post to
My lord,
post.
there is no publication, my lord. It was complaint given to lawful authority, my lord.
List after 4 weeks, yes.
Regarding vehicle, my lord.
Vehicle,
Vehicle, 451, 457.
ಏನ್
petition
vehicle,
is
sir?
filed.
Lorry?
Lorry,
EC ನಾ?
TC, man.
ಏನ್ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾ ಇದ್ರಿ? ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದ್ರಿ?
ಇಲ್ಲ, yeah.
Huh?
I am not a owner, my lord.
ಅಲ್ಲಿ ಏನಿತ್ತು ಲಾರಿಲಿ, sir?
I am purchased the lorry from the
lorry
refund number 2, my lord.
Hmm.
Thereafter, entire loan amount to be cleared
Hmm.
before the
Hmm.
finance, Tata Finance, my lord.
Now, what's the problem?
Vehicle is custody of the respondent number 2, my lord.
Why is it seized, madam?
My-
Proceedings under 406, 420, why have you seized?
ಅವ್ರು ಅದ್ನ
ಮತ್ತೆ ನೀವು ಲಾರಿ ಇನ್ಸ್ಪೆಕ್ಟ್ ಮಾಡ್ಬಿಡಿ ಈಗ. ಯಾಕೆ ಸೀಸ್ ಮಾಡಿದ್ರೆ ಹೇಳಿ?
this one I'll take instruction.
What is this, Vaida madam? Why seized and whose custody will release it tomorrow? Offense is 406, 420.
There
Huh?
in this my lord.
ಏನ್ ಆಕ್ಟಿವಿಟಿ?
ಅಲ್ಲ ಅದ್ ಲೋನ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ.
ಲೋನ್
ಅದೇನು
ತಗೊಂಡಿದ್ದಾರೆ, ಅದನ್ನ
Right.
ಅಲ್ಲಿ ನೀವ್ ಯಾಕೆ ಸೀಸ್ ಮಾಡಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ ಅದೇ ಹೇಳಿ ಫಸ್ಟ್. ಲೋನ್ ತಗೊಂಡಿದ್ದೀರಾ ಬೇರೆ ಮಾತು.
This one I'll pay.
Secure instructions, Tuesday, same stage. ಅವತ್ತು ಕೊಡುವ. Yes. Learned HCGP Wahida seeks a week's time to secure instructions and make submissions. Yes, next.
92 for the petitioner, my lord. Offense of forgery and cheating. Complainant is husband, accused his wife, my lord. Both are Australian citizens.
ಎಲ್ಲಿ ಫೋರ್ಜ್ ಮಾಡಿದ್ರಿ ಸರ್?
Forge in, he claims there was a valuation report, my lord, as per the direction of the magistrate court in Australia.
Yes, yes.
Actually, A2 has already been quashed and A3 has been stayed, my lord. There was a
page. ಸ್ಟೇ ಆಗಿರೋದು ಪೇಜ್ ಯಾವುದು ಸರ್?
ಸ್ಟೇ ಆಗಿರೋದು ಅದು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ,
ಯಾವ ಪೆಟಿಷನ್ ಅಲ್ಲಿ ಸ್ಟೇ ಆಗಿದೆ ಸರ್?
ರಿಪೋರ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ.
ಅಲ್ಲಿ A3 ಸ್ಟೇ ಆಗಿದೆ ಅಂದ್ರಲ್ಲ ಸರ್?
A3 ದು ಸ್ಟೇ got to know.
You got to know. You don't know the number.
My lord, it's there in the certified copy of the order sheet. First page, please, my lord.
ಅದು ಯಾವ ಪೇಜ್ ಅಲ್ಲಿ ಇದೆ?
It is at annexure A, page 21. It's written.
ಇದರಲ್ಲಿ ಯಾವ್ದು ಸರ್?
A2 case is quashed on 14.
A2 case is quashed.
A3 Lakshmi Narayan stay at High Court.
ತಗೊಂಬನ್ನಿ ಅದು ಯಾವ್ದು?
My lord,
Get that.
my lord, one
I will not
grievance.
stay it unless you get this.
My lord, tomorrow, please, my lord.
Get it.
Get a digital copy, please.
Whichever copy you want, sir, but a copy.
please.
Yes, you should have produced it when you have seen this homework.
My lord, more than that, I am.
More than that, what?
My lord, forgery, if anything, was done by A3, please, my lord. I am only the wife in this particular circumstance.
The only wife.
Only wife.
Only the wife.
Only the
Alright,
wife.
Yes, yes.
Tomorrow, please, my lord.
No, day after tomorrow.
Much obliged.
Yes.
First, the complainant has filed 5 separate cases against this petitioner, my lords. And petitioner and the family members of the petitioners. The offences are with respect to 331, 351.
Atrocities Act ilva?
Atrocity alla.
Ilva.
Atrocity alla. This is with respect to there is a civil dispute between the parties. The complainant is the adjacent owner of this complaint, the petitioners.
The main time, next. First time ಬರ್ತಾ ಇದ್ದೀರಾ? ಕೋರ್ಟ್ಗೆ ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದ್ದೀರಾ ಅಂದೆ.
ಇಲ್ಲ.
ಮತ್ತೆ? Yes.
Case and
Next.
For this case, my account was freezed even though when I was not accused, now the complainant, my lord, your lordship.
1,72,000. ಹೋಯ್ತಾ ಮೇಡಮ್?
Yes, ma'am.
ಹಾ.
ಇದರಲ್ಲಿ 1,72,000 ಅಷ್ಟೇ
ನಾನೇ ಹೇಳ್ದೆ ಈಗ.
freeze ಮಾಡಿದ್ದಾರೆ my lord.
ಹಾ.
The other amount has not been freezed from this crime my lord.
ಅದ್ಯಾಕೆ ಫ್ರೀಸ್ ಮಾಡಿದ್ದೀರಾ?
ನಾವು ಮಾಡ್ಲಿಲ್ಲ my lord.
ಯಾರು ಮಾಡಿದ್ದಾರೆ?
The report is we are only freeze the 1,72,000 my lord.
ಅದೇ ಕೇಳ್ತಿರೋದು ಅವರು. ಆ 1,72,000
As per
ಯಾಕೆ?
report
I am
we have not
nowhere
freezed
related
this
to the
one.
crime, my lord. I'm neither the accused nor the complainant.
No, that's all right. Money trial ಇದ್ರೆ ಆಯ್ತು ಅಷ್ಟೇ. You need not be.
ಕೇಸಿನ ಅಡಿಯಲ್ಲಿ ಡೆಬಿಟ್ ಫ್ರೀಸ್ ಮಾಡಿಸಿರೋದಿಲ್ಲ.
ಅಲ್ಲ, why frozen? Why ಅಂತ ನೋಡ್ಬೇಕು ಮೇಡಮ್.
It has been
Same next Tuesday, why ಅಂತ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ.
My lord, one submission.
ಏನು?
I request your lordship to come to page number 30.
ತೊಂದ್ರೆ ಇಲ್ಲ, wait. ಡಿಫ್ರೀಸ್ ಆಗ್ಬೇಕು ತಾನೆ? ಡಿಫ್ರೀಸ್ ಅಲ್ಲ, ಡಿಮಾರ್ಕ್ ಆಗ್ಬೇಕು.
freeze.
ಅಕೌಂಟ್ ಇಸ್ ದೇರ್. ಡಿಮಾರ್ಕ್ ಅಷ್ಟೇ. 1,72,000, wait, yes.
Fresh matter just.
Yes.
Lordship, I had filed application past. Yesterday I didn't file it.
ಏನ್ ಅಪ್ಲಿಕೇಶನ್? ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್.
Stay application. Yesterday it was listed for hearing. But it was-
ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂತ ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
yes,
ಕೊಡಿ.
application.
ಆರ್ಡರ್ ಆನ್ ಐಎ ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೇನೆ, opposite.
ಆರ್ಡರ್ ಆನ್ ಐಎ ಇನ್ ದ ಮೇನ್ ಟೈಮ್ ಕೊಡಿ. Yes, next.
Waiting for respondent, madam.
Post immediately after service of notice upon the respondent. Next. Appear ಆಗಿದ್ದೀರಾ? Learned counsel so and so undertakes to enter appearance for the respondent registry to print the name of so and so as appearing for the respondent.
R3.
List after 4 weeks. Objections if any, but then interim order subsisting will continue to next. Next. Huh?
Consumption.
27B, NDPS.
Yes.
Consumption.
And your lordship.
ಕೊಡಿ.
I was filed also in the counter. There is no forensic analysis, my lord, or proper medical documents, my lord.
ಅದೇ that ಸಂತೋಷ್ ಹಾಸ್ಪಿಟಲ್.
Yes, my lord. Iman Abbas
ಯಾವುದು?
Iman Abbas Topiwala. Reported judgment, my lord, that is squarely applies.
ಅದೇನೆ.
Yes. And
Consumption.
Judgment is my learned friend is relying on. Should may say,
ಅದು 51 BNSS. ಅದಕ್ಕೆ ಇದಕ್ಕೂ ಸಂಬಂಧ ಇಲ್ಲ.
in fact, I requested your lordship to consider.
Correct. ಇದ್ರಲ್ಲಿ ಬರೆಯೋಣ.
Yes. But I made a note on that and I can place that.
ಕೊಡಿ.
I'll place it, my lord, next week.
Oh, this is where I wrote the test would become illegal. Only for consumption.
Correct. Problem is that your lordship said in the arrest is not legal. Entire thing has been vitiated is what your lordship held in this. So now in a.
Consumption ಅರೆಸ್ಟ್ ಯಾಕೆ ಮಾಡ್ತೀರಾ?
That's where the issue. Your Lordship has to relook this statement.
We'll see. Kodi, note Kodi. We'll take it next week. We'll grant an order, but take it next week. List the matter on 13th August at 4 p.m. Adu Kodi, separate hakirtini. There shall be an interim order of stay of further proceedings with the petitioner till the next date of hearing.
For 65, 471 and 420 minutes. Accused number 1 before this on court. Accused number 3 leased out the residential apartment, falsely projecting that apartment owned by accused number 1 and 2 here in my lord, saying that
You are the purchaser.
ಇಲ್ಲ
Then
ಕಂಪ್ಲೇನೆಂಟ್ ಗೆ ಯಾರಿಗೂ ಬೇರೆಯವರಿಗೆ ಸೇರಿದ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅನ್ನ ಲೀಸ್ ಅಮೌಂಟ್ ಇಸ್ಕೊಂಡು ಅವರಿಗೆ ರೆಂಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ. Is falsely projected that my lords petitioner herein is the wife of the owner of the
accused number 1, sir.
Please my lords.
Yes, sir.
ಇಲ್ಲಿ ಏನು entire lease amount was transferred to the account of accused number 3 my lords. Single rupees has been received by this petitioner.
1 HCGP 2 emergent notice returnable by 13th August. List on 13th.
Please.
183 statement of the victim.
For the petition. My lords had ordered 183 statement.
Kodi.
Doesn't want to continue with the, that is the.
69.
Yes, my lords.
ಇಷ್ಟೇನಾ?
ಅಷ್ಟೇ.
ಕೇಸನ್ನು ಮುಂದುವರಿಸಕ್ಕೆ ಇಷ್ಟ ಇಲ್ಲ. This court on 13/7/2026 had passed the following order. The learned HCGP has placed on record the statement of the victim under section 183 of the BNSS. It reads as follows. The victim herself, there is nothing that would become the ingredients of section 69 as is indicated. In the light of the said statement, further investigation,
Yes,
further investigation quay the petitioner shall remain stayed. List the matter on 18th August. We'll quash it on that day. Yes. Next.
Hundred and nine minute.
109.
Abatement to commit suicide.
ನಾನು 100 ಕರೆದಾಗ 109 ಯಾಕೆ ಹೇಳ್ತಾ
ಅಲ್ಲ,
ಇದ್ದೀನಿ?
sorry, I'm sorry. 109.
Abatement is not 109, 108.
108, sorry.
109 is attempt to murder.
Oh, yes.
Yes, sir.
Not the only allegation, last time your lordship wanted to find out what investigation detail.
Death note also there. It has been sent to FSL. Still FSL.
What's the relation between you and?
Nothing. We are all employees of a company called Nestle. He used to work there as a contract employee.
Who?
The person who committed suicide. He writes sends a WhatsApp message in which he says, and that's what this is a complaint. ಇವರೇ ಕಾರಣ ನನ್ನ ಇದಕ್ಕೆ ತುಂಬಾ ತೊಂದರೆ ಕೊಡ್ತಾ ಇದ್ದಾರೆ, ಅದರಿಂದ ಇವರೇ ಕಾರಣ. ಅಷ್ಟೇ. That's the only sentence. Please see the sentence below. It's there in the.
Before that, the
WhatsApp
deceased has
message.
sent the message to his daughter, my lordship.
ಏನಂತ?
ಅದೇ.
ಈಗ ಅವ್ರು ಟಾರ್ಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ, ಹಾಗಾಗಿ ಸಾಯ್ತೀನಿ ಅಂತ. ದಟ್ ಮೊಬೈಲ್
ಅಲ್ಲ, ಟಾರ್ಚರ್ ಯಾವ ತರ?
ಹರಾಸ್ ಮಾಡ್ತಿದ್ದಾರೆ ಅಂತ.
ಅಯ್ಯೋ, ಎಲ್ಲ ಒಂದೇ, ಯಾವ ತರ?
That has been sent to FSL. Even
ಯಾವ ತರ
death-
ಮಾಡ್ತಾ ಇದ್ದಾರೆ FSL
ಇಲ್ಲ,
ಕಳಿಸಿದ್ದೀರಾ?
ಅದು the message is not there in this file, my lordship.
In the FIR it's recorded. WhatsApp ನಲ್ಲಿ ಮೆಸೇಜ್ ಕಳಿಸಿದ್ದು, ಅದರಲ್ಲಿ ಕಾಫಿ ಲ್ಯಾಬ್ ಆಫೀಸರ್ ಆದ ಶ್ರೀಮತಿ ವಿದ್ಯಾರ್ಥಿ ಮೇಡಮ್ ದಿನೇಶ್ ಹಾಗೂ ರಾಘವೇಂದ್ರ ಅವರುಗಳು ನನಗೆ ತುಂಬಾ ತೊಂದರೆ ಕೊಡುತ್ತಿದ್ದಾರೆ, ಆದ್ದರಿಂದ ನನ್ನ ಸಾವಿಗೆ ಇವರೇ ಕಾರಣ.
ಯಾವ ತರ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದೀರಾ? ಏನ್ ತೊಂದರೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಏನು ತೊಂದರೆ? He has actually been suffering a lot because he's lost his business, and thereafter he came to work in Nestle. Now, after which he commits suicide, we do not know anything. 3 employees of Nestle. It's not even someone who can do anything with. One is a lady who works in a laboratory there.
Even in the death note
With
also
this-
25 ವರ್ಷ ಒಂದು ಕೆಲಸ ನಂಬಿಕೊಂಡು ಜನ ಟಾರ್ಚರ್ ಮಾಡ್ತಿದ್ದಾರೆ
ಏನು
ಅಂತಾನೆ
25 ವರ್ಷ ಏನು?
ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ವಿ, ಆದ್ರೂ ಸಹ
ಅಲ್ಲ,
still FSL report has not been received, my lord.
even if
Still
Even if that
investigation is
statement
going
is
on.
correct,
It
it's.
has not been filed.
Correct. But where's the question? Ellide, madam, not instigation. Generally, ಅದಕ್ಕೆ first time stay ಮಾಡಲಿಲ್ಲ ನಾನು. Let me see.
Lordship's asked to find out what there is, but this is the
That's
only
all.
statement.
The petitioners are employees of Nestle.
Nestle.
The second respondent is the wife of a person who was earlier an employee at Nestle, who died,
Contract labor.
a contract laborer at Nestle who commits suicide. The leaving behind a death note. Though in the normal circumstance, at the stage of investigation, there would be no interdiction in cases where the offense is the abetment of suicide. The case at hand is that there is nothing even in the complaint nor in the death note. As the employees of Nestle, with whom the husband of the complainant was a contract laborer, alleges harassment and dies. What kind of harassment, how the harassment, and when was the harassment is neither stated in the death note nor in the complaint. A bald statement of harassment would not become the ingredients of section 45 of the BNS to become an offense under section 108. The section 45 defines what abetment would mean, which is 107 of the earlier regime, the IPC. The nothing of the traits of an abetment which would be proximity, goading, or instigation by these petitioners is present in the case at hand. In that light, permitting investigation even to march forward would become an abuse of the process of the law, albeit prima facie. In the light of the judgment of the apex court in the case of 2025 SSC online SC page 2332, Yadavinder Singh Yadav, there shall be an interim order of stay of further proceedings, further investigation qua this petition till the next date of it. Heard learned senior counsel. Mele. Yen Rajesh Kotradi?
That school. I told you.
Oh,
We have some conversation between the complainant.
Kodi.
Copy.
Yes, Diti madam. Ibru idira?
She sought on 28th for the refund of the amount. First page alli this. As you asked for refund of the yesterday, it can be done. Now I forwarded it. Second page, Milo. Bank transaction has to be done. I can't wait till because of the, I want to make them join today. Yes, Purnima, by 12 I can send off. You send me same number, please. And after that, my lord, on the same day by 12 o'clock, she transferred the amount, which 15,750 rupees. And the next day she filed a complaint. The alleged incident happened on 19th. The conversation between the respondent number 2 and the petitioner number 1 on 28th. And she filed complaint on the 21st.
First page banni sir.
Yes, my lord. Yes, my lord. I gone through my lord. But categorically saying, my lord, I never raised, she never raised any hand. Lord, that too in the first floor, she never kept that.
Ground floor idra ಮಾಡ್ತಾ ಇದ್ರಾ?
ಅಲ್ಲ, never kept the child in the sunlight, my lord. Last time.
ಅಲ್ಲಿ ಯಾವ ಸನ್ಲೈಟ್ ಇದೆ ಮೇಲ್ಗಡೆ?
ಅಲ್ಲ, ಇಲ್ಲ, ಅದನ್ನೇ ಸ್ವಾಮಿ ಹೇಳ್ತಾ ಇರೋದು. My lord, kindly, she is saying that, my lord, everything. And 28th, she refunded the amount. As for her request, only amount has been refunded. Nothing incident happened and like that, my lord. I have the video footages also.
Let the complainant come.
But in the meantime,
Wait, they list the matter on 31st. Emergent notice to the second respondent complainant returnable by the 31st of July. List the matter on 31st. Investigation further investigation shall remain state till the next date.
Great.
Yes.
Trespassing case registered, my lord.
Lords, I appear for
Against the
respondent number
petitioners.
3. I request for a short accommodation to file my objections, my lord.
An offense.
Not 126 2, 324 suppose 5, 324, 329, 351.
Yes, 1 minute. List the matter on 4th August. Objections, if any, by then. In the event no objections are filed, this court would grant an interim order as prayed for.
So
Yes.
wait.
103 and
Respondent number 2, my
105 are to be taken together.
Yavudu 103 and
105. One is for summoning the witness and another one is for summoning the documents.
file your
Here petition,
objections. Balakrishna. Objections haki. ಬೇಡವಾ?
ಅಲ್ಲಿ objection
ಹಾಕಿದ್ದೀರಾ?
ಅಲ್ಲಿ objection ಹಾಕಿಲ್ಲ.
ಹಾಕಿ. ಒಂದು ವಾರ ಕೊಡುವ? 10 ದಿನ?
3-4 days.
ಆಯ್ತು. List next Friday. That is 24th ಅಲ್ಲ 31st.
Lordship
31st ಬೇಡ. 29th.
Early date may be given. There is a
29th.
direction by this court to dispose the matter within
Correct.
6 months.
Yeah,
And, that order has been asked in the month of.
That is my directions.
Yes, my lord. And here in the case, only 5 witnesses are there. 4 witnesses already been, the evidence of 4 witnesses
Oh,
already been
correct.
completed.
Nanday direction, then I can't adjourn it that way.
And CW1,
Your
he was
Lordship
cross-examined by the accused, record
had
19
brought
times.
direction much before he has brought
19 times,
direction
my
to
lord.
conclude the trial fast. I have placed that document. Before he
All
has,
frivolous applications has been filed.
before he has brought direction, I
Allowing
have
the
brought
trial court to
direction.
dispose the matter.
Nandu direction ಇದೆ.
Let it be direction versus direction. Wait, we'll go in some direction now. Yes, list the day after tomorrow, day after tomorrow, fresh matters. We'll close it.
Meantime, let the trial court not pronounce the.
Order ಆಗ್ಲೇ ಮಾಡಿದೀನಿ sir. Yes. Day after tomorrow, we'll close it. Objection in ಬೇಡ.
Machal.
Lordship, I have filed application that may be also, it is not shown on record.
What application, sir?
I produced the entire evidence and cross-examination where he has admitted to examine this witness. And earlier complaint was filed and it was
Record
withdrawn
19
and
times he was cross-examined.
earlier complaint was filed, PCR, and withdrawn as settled out of court. After that withdrawal of complaint, from 2013, I have been deprived of my salary benefits. So that is the reason I have to examine. Already a complaint is been filed and withdrawn.
ಈಗ application ಹಾಕಿದ್ದೀರಾ?
Other documents ಹಾಕಿದ್ದೀನಿ.
ಇಲ್ಲ ಹಾಕಿದ್ದೀರಾ? The registry is directed not to put up the application so filed by the petitioner. List day after tomorrow in the fresh matters list. Don't use the trick of dragging here. I will pass an order now. Yes.
ಇಲ್ಲ, this is already placed in the petition.
Not to put up, not to put up.
ಅಲ್ಲಲ್ಲ, ಅದರಲ್ಲಿ I have already placed this in the petition itself, this document.
I have told, ಅದು put up ಮಾಡಿದ್ರು ಡಿಲಿಂಕ್ ಮಾಡ್ಬಿಟ್ಟು ಅಲ್ಲೇ ಇಟ್ಕೋಬೇಕು.
ಈಗ ಬರೀ ಎವಿಡೆನ್ಸ್ ಮಾತ್ರ
And
ಮಾಡಿದ್ದೀನಿ.
2 more application has been filed before the trial court.
No
Again,
problem. Yes, day after tomorrow, fresh matters. Yes. ಇದು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಚೇಂಬರ್.
Chambers.
Yes, sir.
But at 10:30, that I have served the copy to the prosecutor, and he has internally has informed the same to the IO. So what has happened? Your Lordship may kindly see the order sheet at page number 25. 25. 19/6/2026. Your Lordship may
ಏನ್
kindly-
ಮೆರಿಟ್ಸ್ ಮೇಲೆ ಬನ್ನಿ. ಚಾರ್ಜ್ ಶೀಟ್ ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ 1045 ರಿಸೀವ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದೀರಾ, ಅದು ಕರೆಕ್ಟಾ ಜಗದೀಶ್ ಸರ್?
ಇಲ್ಲ, that's not right, my lord.
ನಾಟ್ ರೈಟಾ?
Yes, my lord.
ಮತ್ತೆ ಏನು?
Because if at all he had received the charge sheet, that would have been entered in the order sheet. Your Lordship may kindly see.
ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ ಸರ್?
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ, ಆರ್ಡರ್ ಶೀಟ್ 25, ಪೇಜ್ ನಂಬರ್ 25.
Come to page 15, sir. It a matter of court record.
Ah, 15 is order, my lord.
15 order, sir.
Oh, my lord.
Para 10 ಗೆ ಬನ್ನಿ ಸರ್.
The investigation officer presented the charge sheet in the morning at 10:45.
Ah.
But your Lordship may kindly see
Accused moved the bail application at 11 AM. The open court. Charge sheet is filed first in time. Reason ಬಿಡಿ. ಏನಾರು ಆಗ್ಲಿ.
Endorsement says with no time. It's only received at so and so time.
Yes, sir.
If at all, if he has received, it must be reflected in the order sheet, my lord.
seek regular bail, sir.
ಅಲ್ಲ ರೂಲ್ 10 ಆಫ್ ದ ಕರ್ನಾಟಕ ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಪ್ರಾಕ್ಟೀಸ್ ಅದ ಎಂಟ್ರಿ ಆದ್ರೂ ಹಾಕ್ಬೇಕಿತ್ತು ಅವ್ರು. ಎಲ್ಲೂ 19th ಇಲ್ಲ 20th ಇಲ್ಲ 22nd ಇಲ್ಲ 3 ದಿನ ಬರುತ್ತೆ. 3 ದಿನ ಬಂದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಎಂಟ್ರಿನೇ ಹಾಕಲ್ಲ.
Entry ಇದೆಯಾ?
Even assuming, my lord, that there is no entry, admits that when he filed an advance application, he was informed that the charge sheet has already been filed. We'll take it that as a ground. For a moment.
Seek regular bail, sir. Statutory biಟ್ಬಿಡಿ.
ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ
ಅದು ರೆಗ್ಯುಲರ್ ಸಿಗಲ್ಲ ಅಂತ ಇದೆಲ್ಲ ಗಲಾಟೆ. ಮರ್ಡರ್ ಅಲ್ವಾ?
ಮರ್ಡರ್ ಕೇಸ್.
Yes.
ಅಲ್ಲ
ಜಡ್ಮೆಂಟಾ? ಕೊಡಿ ಸರ್.
when incomplete charge sheet is there.
Incomplete charge sheet will not amount to grant of statutory bail. Anything else?
ಅದು incomplete charge sheet ಅಂತಂದ್ರೆ your lordship may kindly see 19th 22nd 20th ಮೂರು ದಿನ it has not been entered. The charge sheet has been received by the office, and rule 10 of the Karnataka Criminal Rules of Act clearly says that the immediate initial of the magistrate, it must be entered into the register 3.
ಇವರು ಯಾಕೆ ಈ ತರ ಮಾಡ್ತಾರೆ? ಏನಾಗಿದೆ?
If it is entered in the register 3, it must be reflected.
Get the records of the.
In fact, my lord, that coordinate bench of this court has considered this very aspect, my lord. Though it went one step ahead, which said that it doesn't matter who filed such a charge sheet or application. The
Division bench.
Division bench. Lordship may see at page.
UAPA offenses.
Howದು? Para 12. So the issue was whether the application for bail and extension of time should be considered. So their contention was that since we filed a bail application first and extension time was filed.
ಅದಲ್ಲ ಇವ್ರದ್ದು ಅಲ್ಲಿ ಬಂದಿರೋದು ಇದಕ್ಕೆ ಅಂತ ಅಷ್ಟೇ.
Correct. Time. This court said it doesn't matter who filed an application, who filed.
The application, forget it. But the practice of receiving is normal practice.
The practice of receiving before check and put up before the magistrate itself is sufficient, is what.
ಹೇಮಂತ್ ಕುಮಾರ್, ರೆಗ್ಯುಲರ್ ಬೇಲ್ ತಗೊಂಡ್ಬಿಡಿ.
Regular bail.
Statutory.
ಅಲ್ಲ para 27 of the this one apex court judgment.
That's a.
ಆಮೇಲೆ ಇಲ್ಲಿ 74 ಆಫ್ ದ ಇಂಪೇಜ್ 74 ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲಿ ಸ್ವಾಮಿ ಕೊನೆಯಲ್ಲಿ ಈ ಪ್ರಕರಣದಲ್ಲಿ ತನಿಖೆ ಮುಂದುವರೆದಿದ್ದು ಸೋರ್ ಅವರ ನಂಬರ್ಗಳ CDR ಸಂಬಂಧಪಟ್ಟ ಮೊಬೈಲ್ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡರ್ ಅವರುಗಳಿಂದ ಬರಬೇಕಾಗಿರುತ್ತದೆ. ಮಾನ್ಯ ನ್ಯಾಯಾಲಯಕ್ಕೆ ಗುರುತು ಕವಾಯತು ನಡೆಸಲು ಅನುಮತಿ ಕೋರಿ 90 days ದೇರ್ ಇನ್ ಕಸ್ಟಡಿ. ಗುರುತು ಕವಾಯತು ಈಗ ಮಾಡಬೇಕು ಅಂತ ಹೇಳಿ ಈಗ ಹಾಕೊಂಡು. ಸೊ ದಟ್ ಈಸ್ ದ ರೀಸನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ದೇರ್ ಫಾರ್ in light of the above mentioned discussions, judgments 27.
Today, judgments will see. We'll consider it. Thursday. Thursday for admission. Next. ಇದು ಸೇಮ್ Ramanand, ಅದು same madam ಅವ್ರದೇ.
The appeal for the petitioner in this matter. This matter pertains to a complaint under section 138 of the Negotiable Instruments Act. As I'm filing a brief synopsis and a few citations, my lords.
Why, sir?
No,
Even before issuance of notice.
My lords, it's a very straightforward issue, my lords. The synopsis will explain the same. My lords, my grouse remains that, my lords, that without sufficient reasons being assigned or being examined, my lords, the delay has been condoned. My lords, there are two material.
Petitioner to serve on the counsel who represents the respondent in the trial proceedings. How many days delay?
My lords, there's 33 days of delay.
The learned counsel submits that without adequate explanation for the delay of 33 days, it stands condoned and cognizance is taken. The issue stands, there are judgments to that effect.
Indeed.
Yes.
Those judgments are the ones I have furnished, my lords.
All right.
My lords, my humble submission remains, my lords, there are two material admissions that the complainant makes. First admission made, my lords, is that there is gross.
Yes, you serve on him. The so and so further proceedings before the concerned court shall remain state till the next date, lest the matter on 5th August.
Great.
In this case, I appear for the petitioner, my lords. My lords, I seek for a week accommodation to file the entire charge sheet in the registry, my lords.
11th August. Fresh matters. The counsel for the petitioner seeks time to place on record the entire charge sheet material. Yes, next.
Much obliged, my lords.
Venkatesh.
My lord, I am requesting for early disposal of the trial, my lords. 2021 is the charge sheet. 420 is the. Yes.
Is before the court seeking the following prayer, heard so and so. The petitioner is accused number 4, gets embroiled in a crime, in crime number 226 of 2019, which is pending as CC 8031 of 2021 for offenses, ಏನು offense?
No, it's 420 and 34.
420 ಇನ್ನೂ ಮುಗ್ದಿಲ್ವಾ?
ಇಲ್ಲ.
For offense punishable under section 420 of the IPC. A perusal at the order sheet appended to the petition would indicate no progress in the trial, even for an offense under section 420 of the IPC. In the light of the offense being the one punishable under 420 and the matter being of the year 2019, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier ordered accordingly.
Grateful.
Next.
Serial number 106, may I make a short summary? Manoj, may I request hand delivery of the order, matters listed on 23rd in the trial court.
23rd, you will get it tomorrow, don't worry, sir. Yes. ಅದೊಂದು ಅಪ್ಲೋಡ್ ಮಾಡ್ಬಿಡಿ ಮೇಡಮ್.
For the petitioner, my lord, offense is under section 74, 78 and 79 of the BNS and also 352 of the BNS, my lord. This is a sexual harassment case, my lord. The petitioner and the complainant both are in the extramarital relationship, my lord.
Extramarital relationship?
Yes, my lord.
Both of you are married?
Yes, no, my lord. She is separate family. I have also separate family, my lord. Both are.
ಅಯ್ಯೋ ಅದನ್ನೇ ಕೇಳಿದ್, ಇಬ್ರು ಸಪರೇಟ್ ಆಗಿ ಮದುವೆ ಆಗಿದ್ದೀರಾ ಬೇರೆಯವ್ರಿಗೆ ಅಂತ?
ಹೌದು ಸರ್. Both are in since 5 years. Both are in relationship, my lord. When I denied
after marriage.
Yes, my lord. After marriage, when I denied to continue the relationship, she has filed a sexual harassment case, my lord. And also she has extorted more than 50 lakhs from the petitioner, my lord. And I denied to give the money. And
who
and
is
also,
the interior designer?
Interior designer is the complaint, my lord. She is claiming a interior designer and also a doctor, and also she is a company, a private company CEO, my lord. And she is also given PRP treatment to me, my lord.
PRP treatment?
Yes, my lord.
ಹಂಗಂದ್ರೆ
platelets rich plasma treatment.
ನಿಮ್ಗ?
Yes, my lord. For the petitioner.
He is doctor or interior designer?
She doesn't having any medical degree.
But ಏನ್ ಹಾಕಿದ್ರು ನಿಮ್ಗೆ ಪ್ಲಾಸ್ಮಾ ಅಲ್ಲ?
Yes, my lord. She is given treatment like that.
ಹೌದಾ?
Yes, my lord. Yes, my lord. She is running a clinic, my lord. She doesn't have any medical degree, and also she is not a registered doctor.
Petitioner is okay?
Not okay, my lord.
Not okay?
Not okay, my lord.
ಪ್ಲಾಸ್ಮಾ ತಗೊಂಡ್ಮೇಲೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆಯಾ?
Yes, my lord. And he is asking for prescription and also medical records. She is not providing, my lord. And now she is threatening to harm my 6 years old daughter, my lord. And also she police also colluded with the complaint, my lord.
ಅವ್ರಿಗೂ ಪ್ಲಾಸ್ಮಾ ಕೊಟ್ಟಿದ್ದಾರೆ.
Police are harassing me, my lord, by giving notice in NDPS case.
NDPS?
Yes,
ಅದೆಲ್ಲ ಬಂತೀಗ?
you may kindly see the page number 77.
ಅಲ್ಲ, how did NDPS come in?
Police are harassing me. If I file any case before the medical council, they will implicate me in false criminal cases. My lord, you may kindly see the page number 77, my lord. They have issued 41 a notice in the crime number 249, my lord. No FIR is existing in that crime number, my lord, against me. This is harassment given by the police, my lord.
Oh.
And she is accepted. She is admitted, my lord. She is running a clinic in the FIR, my lord. You may kindly see the FIR, my lord.
What clinic?
My lord, normal clinic, my lord.
Normal?
Yes,
ಬೇರೆ abnormal?
Like a doctor, my lord. Like a doctor.
Like a doctor?
Yes, my lord. But she is not a doctor, my lord. And police are every time summoning me repeatedly, my lord, to the police station. They are humiliating me in front of the complainant, also her family, my lord, in the police station.
That's problem.
And they have taken forcefully my mobile phone. They have deleted everything which I have evidence to prove my case, my lord. Yes, my lord.
ಕೊಡಿ, ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್.
And she 5 years relationship she has suppressed, my lord, in the FIR, my lord. She is suppressed, my lord. My lord,
ಇದ್ಯಾರು ಹೇಳಿರೋದು? ಲೆಟ್ಸ್ ಬಿ ಫ್ರೆಂಡ್ಸ್ ಅಂಡ್ ವಿ ವಿಲ್ ಸಿ ಲೇಟರ್ ಅಂತ?
her only, my lord.
ನೀವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅವರೇ ಹೇಳಿರೋದು ಸ್ವಾಮಿ.
ಅವರೇ ಹೇಳಿದ್ರು?
ಹೌದು ಸ್ವಾಮಿ. She has given the suicide threats, and also if I deny to continue the relationship, she given suicide threats. And also she given threat to kill my daughter, 6 years old daughter, my lord.
Plasma problem.
And also, my lord, whatever she was extorted money for 50 lakhs from me, she using my credit card, she has extorted, my lord.
ಯಾಕೆ ಕೊಟ್ರಿ?
My lord, when I during the relationship I have given.
ಓ, ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ.
Yes. And more than 30 luxury items she has purchased using the
ಕ್ರೆಡಿಟ್ ಕಾರ್ಡ್ ಕೊಟ್ರಿ ಮತ್ತೆ ಫ್ರೀ ಆಗಿ ಇಟ್ಕೊಂತಾರೆ ಸುಮ್ಮನೆ?
MacBook, TVs, all electronic gadgets she has purchased. I have taken some duplicate receipts, my lord.
From your credit card,
Yes, my lord.
obviously, sir. Yes. Who will keep quiet?
And also, both are residing in the single bedroom flat, my lord, since 5 years. She
ಯಾರು
is also
ನೀವಿಬ್ರಾ?
Yes, my lord.
ಸಾಕು, ಮುಂದೆ ಹೋಗ್ಬೇಡಿ. Enough.
Yes, my lord.
Further story need not be narrated. Yes. ಇಲ್ಲಿವರೆಗೆ ಯಾಕೆ ಬಂದ್ರಿ ಗೊತ್ತಿಲ್ಲ. Yes. The petitioner claims to be the victim from the hands of the complainant. The learned counsel for the petitioner submits that the complainant dons 3 roles. One of a doctor, one of an interior designer, one of a company executive. In one of the roles, he has fallen prey to the complainant. The petitioner is said to be married and having a child. So does the respondent. The two have an extramarital affair, is the submission of the learned counsel, and the affair goes on for 5 years. The petitioner has in fact warned the complainant that if you keep harassing me, I will inform your husband with all the screenshots. Then the complainant says, let's be friends and continue together. Then begins the problem. Extortion and all other factors form the fulcrum of the list. Now, the complainant registers a crime for offense under sexual harassment by the petitioner on the complainant for over 5 years of all consensual acts. If this is permitted, albeit prima facie, would be putting a premium on the acts of the complainant and the role of the complainant, acts of the complainant. Therefore, there shall be an interim order of stay of all investigation qua the petitioner till the next date of hearing.
My lord, one more submission, my lord. I got bail from the sessions court, my lord. In the sessions court, the court has imposed on condition to give the attendance every Saturday, my lord.
ಅದು ಚಾಲೆಂಜ್ ಮಾಡಿದಿರಾ ಇಲ್ಲಿ?
Using this, no, my lord, I have not challenged this. Using this as a advantage, the police are summoning me repeatedly. They are calling to the police station. They are.
You don't worry. I have stayed investigation, sir. How can they call you? What is all this?
Obliged, my lord.
ಅವರು ಕಾಫಿ ಕುಡಿಯೋಕ್ಕಲ್ಲ ಕರೆಯೋದು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ಗೆ. ಅದೇ ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ ಮತ್ತಿನ್ನೇನು?
ಅರೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಎದುರಿಸ್ತಾ ಇದ್ದಾರೆ. Given a false notice also, my lord.
False notice.
Yes, that is the 41A notice, my lord. NDPS.
Stay ಮಾಡಾಗಿದೆ.
Much obliged.
Lord, I would seek your intervention in this, my lord.
I will not intervene, sir.
Allah, my lord, it is a classic example where the complainant and the police have gone hand in glove anta. That is the only aspect which I am referring to, my lord. Directly rebutting to the FIR in column number 10, 115 subclause 118 subclause 2, 323, my lord. That is 115 subclause.
In the meantime,
next, Lord, one submission, my lord.
Extra ಬೇಕಾ?
ಇಲ್ಲ, my lord, one submission. ಇದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ ನಾನು ಲೀಗಲ್ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ
ಕರೆಕ್ಟ್ ಸರ್. 138 ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರೆ ವಾಪಸ್ ಕೊಡ್ಬೇಕು, ಲೀಗಲ್ ಆಕ್ಷನ್ ತಗೊಂತೀನಿ ಅಂತ ಈ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ದಾರೆ, ಸ್ಟೇ ಮಾಡಿದ್ರೆ ಇನ್ನೇನು ಬೇಕಾ?
They are threatening me to return the check. That is one thing I just.
ಈಗ ಸ್ಟೇ ಮಾಡಿ ನಾನು ಚೆಕ್ ಕೊಡಬೇಡಿ ಅಂತ ಹೇಳಕ್ಕಾಗುತ್ತೆ.
Agreed.
ಮತ್ತೆ
Great.
Yes. Next. ಇದು ತುಂಬಾ ಇದೆ ಇನ್ನು. ಒಂದು ನಿಮಿಷ 233 ಮುಗಿಸ್ಬಿಟ್ಟು ತಗೊಂತೀನಿ.
Okay, for the petition's case, my lordship. 138 matter, my lordship, NI Act. Trial court convicted, my lordship. After that, I filed.
20%?
Yes, my lordship.
ಯಾವಾಗ ಕಟ್ತೀರಾ?
I'm ready. DD is ready.
DD ready ಇದೆಯಾ? ಜೋಬಲ್ಲೇ ಇದೆಯಾ?
Yes, ma'am.
Yes. The petitioner holds a demand draft in his hand and submits that he would deposit before the concerned court, which is the amount of 20% that had to be deposited in terms of section 148 of the Negotiable Instruments Act. In the light of the said statement, there shall be, in the light of the said statement, the concerned court is directed to accept the said amount. The sentence, the order of suspension of sentence shall continue till the next date before the concerned court.
Judicial custody, that is.
ಅಯ್ಯೋ ಕಸ್ಟಡಿಲಿ ಇದ್ದೀರಾ? ಹಂಗಾರೆ ಕಟ್ಬಿಟ್ಟು ಬನ್ನಿ. ನಾಳೆ ಕಟ್ಬಿಟ್ಟು ಬನ್ನಿ. I'll take it day after tomorrow, will release you.
ಅದು ಎಂಟ್ರಿ ಮಾಡ್ರೆ ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿದ್ದಾರೆ ಸರ್.
ನೀವು ಫಸ್ಟ್ ಕಟ್ಬಿಟ್ಟು ಬನ್ನಿ ಅದನ್ನ. ಇದು ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಹಿಂಗೆ ತಗೊಳ್ಳಿ. The petitioner shall pay the said, the petitioner is holding a demand draft in his hand which is 25%. ಅದೆಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. The petitioner shall deposit the same before the concerned court tomorrow. The concerned court shall accept the said amount, less the matter day after tomorrow. Will release you day after.
By hand.
By hand, yes.
Machablai.
Yes.
My lords, FIR comes to be registered against the petitioner with respect to criminal trespass, my lords. With respect to a property does not
1 minute,
belong to
madam.
the.
1 minute. In trespass against you,
Against me
Ah.
with respect to property which does not belong to the complainant, my lords. The sale deed also.
In the meantime, yes.
Please, ma'am.
Next.
Oblige.
But kindly pass over.
ಅಯ್ಯೋ ಸೀರಿಯಸ್ಲಿ
ರವಿಶಂಕರ್ ಸರ್.
ಪರವಾಗಿಲ್ಲ ಸರ್ ಏನ್ ಹೇಳಿ ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ ಸೀರಿಯಸ್ ಆಗಿ ಮೂವ್ ಮಾಡಿ ಈಗ ಪಾಸ್ ಓವರ್ ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಏನ್ ಸಮಾಚಾರ? What's the offense?
This case is regarding to the Lord, I'm the SDA officer, public servant, my lord. My name is not found in the complaint, either in the complaint or in the FIR.
ಇದು ಯಾವ್ದು ಕನೆಕ್ಟೆಡ್ ಎಲ್ಲಿ SPP ಅವರು? One who has facilitated Arogya Swami.
Lord, in this case, there is no specific allegations against to me, my lord.
Let the SPP go. Tomorrow I'll take list tomorrow.
Yes,
ಇಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ನೋಡಿದ ತಕ್ಷಣ ಗೊತ್ತಾಯ್ತು. ಕುಂಬಲ್ಗೋಡ್ Francis and Arogya Swami both.
Yes, my lord. The petitioner is arraigned as accused number 6 in this matter.
No problems.
Lord, I am the government public servant.
That is Kengeri.
ಇದು ಕುಂಬಲ್ಗೋಡ್ ಇದು.
This is in that entire region, my lord.
Yes, yes, yes. And in what cadre are you in?
SDML.
Second division assistant. Yes, no problem. ಇದು ಆರೋಗ್ಯ ಸ್ವಾಮಿ ಅವ್ರದ್ದು ನಾಳೆ ಬರಲಿ.
Lords, can I only say this, my lords?
Yes, sir.
Lords, may kindly have a look at the complaint itself, my lords. Page number 29.
No, let him go through it. Yes.
No difficulty. The allegation is that there is a direction issued by this honorable court in WP number 3382 of 2025 to enter a particular name in the RTCs. In the entire complaint, there is not a whisper as to what is my role. If there is already a direction issued by this honorable court to enter the entries, to make the entries or the mutation entries, and if a mutation entry is made because while making a mutation entry, second division assistant has absolutely no role. No, he has absolutely no role. Under the scheme of the act.
Let's see, let him see it tomorrow. Tomorrow we'll take
tomorrow,
it. Yes,
please.
Tomorrow we'll take it. Let the SPP go through it.
Very well.
Because it connects two notorious people.
I have no difficulty, my lords, but to connect the notorious people, my lords, a person who is a second division assistant who has nothing to do with this.
That we'll see. If you have nothing to do and simply dragged in, I will stay it. Not a problem. But
that's
let
the only
the
case.
SPP see it. Yes. Nale.
Great.
Day after tomorrow.
Aito, day after tomorrow. Fresh matters.
Please.
Heard the learned senior counsel and Madi. Learned HCGP is directed to accept notice. Learned SPP is directed to appear. Let's day after tomorrow. Fresh matters.
Please.
Yes. In terms of
Serial number 5 and 6, it may be taken up tomorrow, my lords. Medical emergency in serial number 5.
Tomorrow, 4 p.m. to report.
5 and 6.
5 and 6 both.
Great.
Arunachalam.
My lords, to report settlement section 318, my lords. Filing the memo, my lords.
Parties are there?
They are appear to the VC, my lords.
And for the
And
defective
one
complaint,
person is from the Chandigarh and one person from the Kerala. So
Cheating. ಎಲ್ಲಿದೆ ಯಾರು ಇಲ್ಲ?
I told them to log in. There is some technical.
All right. Kudi, yes. Continue the list.
Obligement.
My lords, for the petitioner in this case,
Yes, sir.
Petitioner number 1 to 4 are present before this honorable court, my lords.
Offense ಏನು?
Offense
Complaint.
under section 85 of BNS, my lords.
All right. Settled where?
Settled before the mediation, my lords. They have dissolved the marriage through mutual consent.
Where is the
divorce.
mediation settlement?
My lords, I'm filing no objection certificate of the respondent number 2, my lords. The
ಅಲ್ಲಿ
mediation is
mediation
not-
settle ಆಗಿರೋದು ಎಲ್ಲಿ sir?
That report has not been availed still, my
ಮತ್ತೆ?
lords. The order was passed on 10/6/20.
Complainant is here, is it?
Yes, please, my lords.
All right, ಕೊಡಿ. ಏನ್ no objection, what?
They have agreed on a settlement amount of rupees 22 lakhs, my lords. During the mediation, my lords, we have paid 11 lakhs, my lords. Now we are paying 11 lakhs.
ಒಂದ್
through
ನಿಮಿಷ.
TD.
Yes. Settlement
ಸೆಟ್ಲ್ಮೆಂಟ್ ಆಗಿದೆ sir.
ಆಗಿದೆಯಾ?
11 lakhs ಇವಾಗ ಕೊಡ್ತಾರೆ.
TD of rupees 11 lakh through.
11 lakh is paid to you already?
Awesome.
It's already paid?
Paid.
Now 11 lakhs are,
Is paid.
Through TD.
that concludes the settlement?
Yes, please, my lords.
ಇದು ಇಲ್ಲಿ ಮಾಡಿ ಜಾಯಿಂಟ್ ಮೆಮೊ ಇಂದಾನೆ ಹಾಕಿ parties present. The petitioner, the learned counsel submits that 22 lakhs has been agreed upon to be paid and 11 lakhs is already paid. 11 lakhs is now being paid to the complainant, which is received by the complainant who is present before the court. In that light, and the offense being under section 85 same. So yes.
Please, my lords.
Next.
I appear for the petitioner in this case, my lord. My lord, this matter is arising out of 138, my lord. My lord, kindly come to page number
Yes, Rakshita madam.
71, my lord.
My lord, I am the
ವಕಾಲತ್ ಹಾಕಿದೀರಾ?
Yes, my
I
lord, I
filed
have
it
served the
yesterday.
copy also, my lord. On the last date, your lordship had directed, on 18/7, I have served the copy as well, my lord.
ಆಯ್ತು ಆಯ್ತು.
My lord, kindly come to at page
311
70.
application,
Yes, my lord, what has happened, my lord? I got convicted.
ಒಂದ್ ನಿಮಿಷ. ಎಷ್ಟನೇ application? You got convicted.
Thereafter, I went to a session court and session court given a direction by setting aside the conviction to consider my evidence which was not considered in earlier, my lord. So apart from that, my lord, the court was having, kindly come to page 71, my lord.
71.
Annex
Yes.
G.
Yes, madam.
Running in page 10, running page 71.
Yes,
my
yes, I am
lord.
there.
May I permitted to read, my lord? From the third.
This is
ninth-
in the appeal.
Yes, my lord. There is a direction by the learned session judge. to
Correct.
remand the
Appellant is made out grounds to interfere. What was under challenge?
My lord, under challenge was the conviction
Conviction order.
Yes, ma'am.
Now conviction is set aside.
Yes, please,
The
my
matter is remitted back.
Remitted
Now
with
what
a
is the problem?
Limited grounds, my lord. May I read, my lord? My lord, from the page number 71, from line number 10, my lord. Thereafter, the carefully reading, the judgment is observed that the learned magistrate errant and not appreciated the circumstances under which exhibit D1 was marked. D1 was my document I have marked, my lord, wherein the complaint has not disclosed the amount what I have paid of 96 lakhs. In the complaint, they say that I have not paid a single rupee, whereas
Now what is the problem?
the court here in my lord not appreciated the D1 and has to be passed the judgment accordance with the fresh, my lord. But the court is
Accordance
given-
with the fresh.
by considering the exhibit D1, my lord. But the court has been given a direction to fulfill the lacuna of the complaint.
One ನಿಮಿಷ madam. Yes, madam.
Lord, matter was remanded at the very same page 71. If the last 5 lines are taken note of, my lord, page 71.
ಇಲ್ಲ ಆಯ್ತು ಈ court is considering a fresh.
It is considering what happened, my lord, during course of arguments, the accused have taken up a defense where the invoice and delivery challenge under the letterhead of the company is a fabricated document. So during course of arguments, my lord, the learned trial court considered that during the course of business, there'll be other invoices, so that can also be produced. In terms of this section 311 application was filed. That has been allowed, my lord. Annexure D, if my lord sees page 46 onwards, this fact has been appreciated, my lord, that it is required for just trial and to consider, and page 50, para 11, my lord. According to the complainant, documents ought to be produced are invoices and delivery challenge. In the arguments as well as in the cross-examination, the accused has challenged the aspect of delivery of goods. The accused has also taken up a contention and defense that the invoices already produced.
You are the accused.
Yes, my
Yeah,
lord.
the
I was
accused.
the accused. My lord,
But
may I
not the
permitted
in-
to produce one
Will-
judgment of passed by your lordship, my
ಅಯ್ಯೋ,
lord,
ಏನ್ ಕೊಡಿ?
on 311, my lord.
311.
Yes, my lord.
311 ಗೆ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ ಈಗ?
My lord, wherein the trial court has to be passed the judgment by considering exhibit D1, that is the bank statement of the petitioner here, and pass the order accordance with law, my lord. But the court has been given a liberty to the complaint wherein the respondent here and fulfill the lacuna of their thing, my lord, which cannot go the against of the accused, my lord. Wherein during the trial,
ಹೇಳಿ madam.
accused was very much rebuted the matter,
Rebut.
rebuted the
Rebutted. Sorry.
rebated
Yes, yes.
the liability on the complaint, my lord.
Hmm.
But to fulfill the lacuna, 311 has been, and this document had nowhere been taken into consider during the trial, well, in the year 2020-24, and after the cross examination, even they filed the 311 at that time, my lord, and that is also been rejected. That they did not challenge. Thereafter, conviction order being passed, and that conviction order is being set aside with the specific direction to consider my document, my lord. But the trial court has given them to be a chance to lead a fresh trial to the respondent to lead the fresh evidence to fulfill their lacuna, my lord. The lordship may kindly come to page number 10 of your lordship judgment, my lord.
Yes, madam.
My lord, para 10, my lord. May I read, my lord?
I am there only.
As perused at the order sheet, the observation herein above is inaccurate of the fact that the learned counsel of the petitioner, then the record had extensionally cross-examined by the PW1. There is no new material project by the petitioner even before this court necessitating the further cross-examination of PW1. The petitioner have placed heavily reliance on the judgment of the apex court in the case so and so. There is no column about the principle of laid down by the apex court interpreting the purpose of 311 of CRPC. And in this case also, my lord, the hand-in case, while filing the 311, there is no
Hand-in case.
The
Case
present
on
case,
hand.
the present case, my lord, they have not given any explanation what not prevented them to at that time to take this, because this is the new invoices which never came into the complaint in even entire case of the trial, my lord. The 311 along with the invoices they have given, that invoices nowhere in come with the complaint copy. I have produced the complaint copy at annexure A, my lord, and they only say that the transaction happened on 1 crore 50 lakhs, but the new invoices say that 96 lakh what I have paid, which I have led in my defense, they show that that amount is that
What is what? That is that, Andhra?
amount which they I have proved in the ruling trial, my lord, of 96 lakh 67,000, that is exhibit D1, my lord, which never been taken to the consideration in the court during the trial, my lord, that my amount was being paid. Now they're saying that the invoices which they have produced in 311 along with that, they said that that amount is that. So therefore, my lord, this is where
This amount is this, that amount is that.
my lord, I mean to say that
Hey, bada, saku. Yes, madam.
your lordship judgment is very clear.
Very clear, madam.
311 cannot be given to fulfill the lacuna when at the stage when the already accused has gone to the disadvantage of their
Gone to the disadvantage.
and the clear judgment is there, my lord. So therefore, my lord, the magistrate has what the IA has been allowed on 311 is not justifiable, my lord.
Yes, you have already gone to the disadvantage. You can't come back.
My lord, page 71, the finding of the page 50, my lord, see.
The petitioner accused 1 and 2 call in question an order of the concerned court which allows an application under section 311 in terms of its order dated 10/7/2026 in CC 11 of 2021. The petitioners are accused, the respondent, the complainant, the two have a transaction. The transaction would lead the complainant to the concerned court for offense punishable under section 138 of the Negotiable Instruments Act. The petitioners get convicted of the offense. The conviction is tossed by these petitioners before the appellate court in criminal appeal 1603 of 2023. The appellate court, on hearing both the parties, would come to conclude that the appeal deserved to succeed on the following reasons. Page 69 to 72. The criminal appeal was not allowed in part, it was allowed in its entirety. The impugned judgment of conviction was set aside. The matter was remitted back to the hands of the trial court for fresh disposal in accordance with law, not in accordance with any direction that is given by the court. Both the parties were directed to appear before the court and the records were sent back for disposal. Now, pursuant to the remand, it transpires that the petitioner, the respondent complainant has preferred an application under section 311 of the CRPC seeking to introduce certain documents which is permitted, the permission of which is challenged before this court. The contention of the learned counsel for the petitioner accused is that the concerned court, appellate court, has remitted the matter back for a particular purpose of consideration of a particular document, and therefore the entire issue cannot be argued all over again, which has already met its conviction at an earlier point in time. The learned counsel submits that the complainant cannot now produce documents to fill in the lacunae that was found in the during the trial which led to the conviction. She would seek to place reliance upon a judgment there. The learned counsel Srimati Rakshita DJ, appearing for the respondent, would refute the submission in contending that the very reason on which the appeal was allowed is for production of certain documents. Even otherwise, the concerned appellate court has directed consideration of the issue afresh, and therefore it is axiomatic that the concerned court would now take into account all the factors and pass necessary orders. I have given my zones. In the light, the afore narrated, the order is quoted herein above. The application is filed after the matter being remitted back to the hands of the concerned court. The concerned court allows the application.
Page 47, my lord.
Allows the application by the following order. The concerned court follows what the appellate court had directed, allows the application on the score that the said document was necessary and would be subject to cross-examination. The reason so rendered reads as follows, page 50 to 52. In the light of the order of the appellate court that the entire issue has to be considered afresh and the entire proceedings earlier rendered were effaced, no fault can be found with the concerned court with allowing the application. The petition lacking in merit stands rejected. Next.
The same matter.
Same, 112, same order.
My lord, there was a specific direction to only to consider exhibit D1.
I have quoted it, madam. No problem. Yes, next.
Appearing for petitioner, my lord. Case and counter case, my lord. Different investigation officers, my lord.
Yes.
Correct.
Yes. Let's may be permitted to conduct de novo any
No,
investigation.
sir, result adene.
Yes.
The petitioner is before the court seeking the following prayer. The petitioner is the accused who gets an incident that happens on 28/11/2020 results in 2 crimes being registered. One by the petitioner against the complainant and the other by the complainant against the petitioner. Both are registered. Numbers helinange.
Crime 138 of 2020. Case 139 counter case.
Sir. Both of them result in registration of crimes in 138 of 2020 and 139 of 2020. The investigating officer who investigated into the crimes which arose out of a solitary incident were different. Therefore, there is any amount of the charge sheet being filed or the trial commenced on the strength of the said 2 reports of the investigating.
My lord, charge sheet also filed.
One nimsha, sir. To a charge sheet filed on the 2 reports of 2 different investigating officers in a case and a counter case would run foul of law. In that light, in the light of the judgment rendered by this court and the circular by the state following the said judgment, the act of the state in appointing 2 different investigating officers on a solitary crime, on a solitary incident and 2 crimes registered thereon is requires to be obliterated. for the aforesaid reasons following order allowed case and counter case in 138 of 2020 and counter case in 139 of 2020 stands quashed. The investigation shall now be handed over to a solitary investigating officer who would investigate into the crimes and file its final report within 3 months from the date of receipt of from the date it is entrusted to the said investigating officer. All contentions would remain open.
My lord, corresponding CC number 34 and 37.
ಪರವಾಗಿಲ್ಲ ಆ ಕ್ರೈಮ್ ಇದು ಏನಾಗಿದೆ ಅದು.
And ಒಂದು date incident date 20th November 2020.
28 ಅಲ್ಲಿ 20th.
Please.
De novo investigation.
De novo investigation. ಅದಕ್ಕೆ they shall conduct a de novo investigation and file ಅದಲ್ಲ ಮೊನ್ನೆ ಆವಾಗಲೂ ಬರ್ತಿದ್ದೀನಂತೆ. Yes, next.
Under 15, the petitioner, my lord, she was worked as my lord assistant commissioner. The petitioner, she worked as assistant commissioner, my lord, during the period 2015 and 2016. During that point of time, my lord, she has my lord granted my lord lands to my lord the.
Oh, land grant. Yes, sir.
Please. Lord, therefore, my lord, now my lord, 2000 crime was here 2019. Now they have issued me a notice stating that my lord, that there was a fabrication of the my lord signature of the officials. My lord, that is done by my lord some miscreants, my lord. Therefore, there are about my lord 400 cases my lord have been my lord illegally granted. 400 cases my lord have been illegally
400 cases.
Lord, that is not.
You were the assistant commissioner then?
Assistant commissioner, Lord, I was there only my lord for 1 year. Lord, as far as my lord fabrication is concerned, Lord, that is against my lord other officials.
Bagair Hukum committee da?
Bagair Hukum committee under section 16 and 71 my lord. Lord, now my lord under rule 108K of the my lord land revenue rules. Lord, now the grants have been cancelled because it was obtained fraudulently. So grants have been cancelled. Lord, my apprehension that Lord, there is a issuance of notice against me that to cooperate in investigation, I have cooperated with investigation. Lord, there is a precipitative action should not be taken against me. That's all my request before the court. Lord, I'll cooperate with investigation.
Cooperates.
I'll cooperate, Lord. They have issued me notice. Lord, now, my lord, since my lord, since my lord, threat of arrest not before the court, my lord. Some my lord not to take precipitate action. That's enough for me.
Allah, you will cooperate with the
Let him
investigation.
cooperate, my lord, your lordship, not
The
say that
officer,
because
lady.
It's not one, my lord. There are multiple. What we have unearthed. Multiple.
There is no question of stay of investigation.
Please, Lord, I am not seeking for stay.
ಇದರಲ್ಲಿ ಸ್ಟೇ ಬರೋದೇ ಇಲ್ಲ. Cooperate with the investigation.
Will cooperate, my lord, not to precipitate action.
ಯಾಕೆ ಬೇಲ್ ತಗೊಂಡಿಲ್ಲ?
My lord, since my lord, very recently, my lord, we have been, my lord, police are approaching me to my lord.
Police approached you.
Approach andre they are over the phone, my lord. They saying that that's the reason, my lord, before the court.
Let him take bail, my lord. Let him take.
Lord,
they can't convert this court to a bail court.
Lord, I am not, my lord, seeking, my lord, some protection, my lord, sometime,
I'll give you a week's time to secure bail.
3 weeks time, Lord, will say.
3 weeks.
Lord, since 2019 is the crime. Lord, Lord, kindly appreciate.
6 ವರ್ಷ 7 ವರ್ಷ ಆದ್ಮೇಲೆ ಇವ್ರಿಗೆ ಆಕ್ಸೆಸ್ ಫಾಲನ್ ಬಟ್ ಗೊತ್ತಾಗಿರೋದೇ ಎಲ್ಲ ಈಗ. ಗವರ್ಮೆಂಟ್ ಲ್ಯಾಂಡ್ ನ ಬಾರ್ಟರ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ.
ಇಲ್ಲ ನಾವು ಮಾಡಿಲ್ಲ. My lord, it is a case, my lord, she is the gazetted officer, my lord, she has granted lands, my lord. There are, my lord, cases where my lord, fabrication of records have been taken place by the my lord, subordinate officers. There is no doubt, my lord.
ಎಲ್ಲಿ ಲ್ಯಾಂಡ್?
Please, my lord.
Oh, Hassan.
Same.
Same Bagair Hukum. Yes.
No, it's not Bagair Hukum, my lord. Bagair Hukum, my lord, it's in Belur. My lord, this is my lord Hemavati Reservoir project. My lord, this is different. My lord, where my lord 2015, my lord, incident, my lord, they say, my lord, that 2019, my lord, the complaint came to my lords. My lord, I'll cooperate, my lord. In fact, my lord, notice has been issued, my lord, I have been cooperating with the investigation. My lord, not to, my lord, precipitate, my lord, take any coercive action, my lord. That's all I'm saying.
You're converting this court to a bail court. You secure bail. I'll grant you 2 weeks' time. The petitioner is before the court seeking the following prayer. He would restrict his prayer that he would cooperate with the investigation, but the police should not take any precipitative action. Since the crime is of the year 2018, incident is of the year 2019, and the acts of the crime is now falling upon the petitioner with a notice being issued by the police, I deem it appropriate to grant 2 weeks' time to the petitioner to approach the concerned court seeking bail, anticipatory bail, seeking anticipatory bail before the concerned court. Till 2 weeks' time from today, there will be no precipitative action by coercive, not precipitative. Coercive, there will be no coercive action against the petitioner.
Lordship, 3 weeks, Lord. Since they have to, my lord, they'll seek time before the trial court for objection. That's the reason.
2 weeks ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಹೇಳಿದೆ ತೀರ್ಮಾನ ಮಾಡಬೇಕು ಅಂತ ಈಗ.
ಅಲ್ಲ, ಏನಂತ objection?
In the event the bail application is preferred, They preferred the concerned court within 2 weeks as directed, the concerned court shall expeditiously dispose the said application in bearing in mind the observations of the apex court with timely disposal of the bail applications. ಆಗತ್ತೆ.
20 days sir ಕೊಟ್ರೆ ಕಷ್ಟ.
ಅದಕ್ಕೆ ಒಂದಿನ ಏನು?
ಅಲ್ಲಲ್ಲ.
ಪರವಾಗಿಲ್ಲ. Yes, yes.
The reason that not, even if they file a application before the trial court, not they'll take time to not file.
ನಾಳೆ ಬೆಳಗ್ಗೆನೆ ಹಾಕಿ.
ಅಲ್ಲ, we'll file it tomorrow itself, not. Let's say 3 weeks, not, so that.
ಬೇಡ ಬೇಡ ತೊಂದರೆ ಇಲ್ಲ. Yes. ಕೋರ್ಟ್ ಮಾಡ್ತಾರೆ, ಇಷ್ಟರಲ್ಲಿ ಮಾಡಲ್ಲ, ಮಾಡೇ ಮಾಡ್ತಾರೆ.
Petition is disposed of.
Disposed, yes. With the aforesaid observation, the petition stands disposed. Heard SPP and yes.
This is an NDPS matter 22,
Mayur.
20B2B, my lords.
Huh?
20B2B and 8C of the NDPS Act. Jagdish sir had sought for time on the last date of hearing.
Jagdish sir.
Section 50 violation ಹೇಳ್ತಾರೆ. There is no.
Section 50A violation ಬಗ್ಗೆ ನಾನು ಇಲ್ವೇ ಇಲ್ಲ.
ಅದು ಬಿಟ್ಟಾಯ್ತು ಅವ್ರು.
Just placing a few judgments on record, my lords.
You come up with armory. Yes.
My lords, this is a simple point, my lords.
Beginning ಅಲ್ಲಿ if you come up with armory.
Sir, in fact, given all of these citations to Jagdish sir long back, my lords, these are all standing orders of the NCB. Not 1/88 mandates quantitative and qualitative analysis. Subsequently, 2022 NDPS rules also mandates it. My lord,
what is this THC?
My lord, THC is the content. My lord, it's tetrahydrocannabinol. My lord, it's the content of ganja.
Content of ganja.
That is what it makes. That is what makes ganja.
Psychotropic substance or a natural narcotic drug?
It's a natural substance, my lord, found in hemp, cannabis, or ganja. My lord, above 25% is what originates to ganja. Above 50% is what gives rooms to ashish, my lord. My lord, my simple plea before
Ashisha.
Hash, my lord. Ashish or hash is what it's called. My lord, my simple plea before your lordships is 2 grounds. My lord, a cover is weighed along with the ganja. They say the weight of the contraband is 1 kg, 166 grams. My lord, that is admitted as per the 50A certificate issued by the magistrate. My lord, now they have not complied with the guidelines as under 188 to differentiate the seeds, the roots, the stems, or the flowers. Now
ಎಲ್ಲ ಡಿಫರೆನ್ಶಿಯೇಟ್ ಮಾಡ್ಬಿಟ್ರೆ ಏನು ಉಳಿಯುತ್ತೆ? ಏನು ಉಳಿಯಲ್ಲ.
But that is the mandate of the law as under bar.
Correct, but ಉಳಿಯೋದು 1 ಗ್ರಾಮ್ ಉಳಿಯುತ್ತೆ.
No, that's also, my lord, I think.
My lord, I'm only.
ಇದು ಹೈಡ್ರೋ ಅಲ್ಲ ತಾನೆ?
It's not hydro. And my lords, the other fact, my lord, now if in case a person is caught with contraband, my lord, how do we charge him, my lords? We charge him on the basis of the 2021 amendment, which gives out the entire schedule. Either intermediary, small, or commercial quantity is relied upon that. My lord, without ascertaining the quantity of it, my lords, a charge cannot be levied. My lord, now the contraband is also destroyed. The certificate is filed before the court. But I do not find.
No, the law is that it has to be weighed together.
We'll,
no separation.
We'll consider this and lay down something.
Yes.
Grateful.
ಜೆ ಅಂತೂ ಕೊಟ್ಟಿದ್ದೀನಿ, ತೊಂದರೆ ಇಲ್ಲ.
Lord, I had made a submission before lordships with regard to this specific case. Both of them are students.
Which case? ಇದೇನಾ ಅದು?
Yes, my lord. Both of them are students.
ಎಲ್ಲ ಸ್ಟೂಡೆಂಟ್ಸ್ ಮತ್ತೆ ಮಾಡೋದು.
My lord, there is more to this case than what meets the eye, my lord.
ಹೌದು, ಅಲ್ಲ ಯಾವ್ದು ಇದು?
ಉಡುಪಿ.
ಉಡುಪಿ ಇಲ್ಲ.
ಹೌದು. ಅಲ್ಲಿ highest ಮಾಡೋದೇ ಸ್ಟೂಡೆಂಟ್.
ಅರೇಬಿಯನ್ ಸಿ.
ಹೌದು.
My lords, there in fact students from North India who had come down to study here. But they've gotten embroiled into a crime which, in fact, my lord, their family is not aware of. Neither were they aware of that they were carrying.
Correct. Families won't be aware of.
Illa Swami, they weren't even aware that they were carrying this drug. That's the issue. They were being used as mules without their consent. That is the actual fact.
Let's see. We'll decide it. We'll Friday ತಗೊಂತೀನಿ ನೋಡಿ. This Friday, 24th.
Fresh matter.
List on ಬೇಡ. List on 24th at 4 p.m.
Grateful.
4 p.m. ರೀಚ್ ಆಗಲ್ಲ ಅಂತ ತಗೊಂತೀನಿ.
Will be taken up as further hearing.
We'll take it. Further ಯಾಕೆ? ಏನ್ ಚೇಂಜ್ ಆಗಲ್ಲ. Wait.
Grateful. Obliged. And in fact, even the judgment of Muddera Venkat that your lordships had passed.
What happened to that?
Lord, in that there were 2 tests that were specified.
Correct.
Gas chromatography and the other one.
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ ಅವ್ರು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ. But that test has also not been conducted in this.
So that's become final.
Yes. In fact, that is the first order in the entire country with regard to that.
Yes. Ayappa is also asking one. We'll see.
Obliged.
This matter pertains to that Vikram Investments.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
ಹೌದು, ಸ್ಟೇ ಇದೆ ಇದರಲ್ಲಿ. Stay was granted on 24/4/25 and then it was extended on 14/7/2026.
No, ಇದರಲ್ಲಿ I wanted the SPP to come in this.
Well, it's here petitioner is accused number 8, a depositor.
Correct. He
Now,
was,
for a
he is
depositor, we
himself a
can't have
victim anta
KPID.
ಹೇಳಿದ್ರಿ.
Yes, my lords.
He is himself a victim anta
Yes,
ಹೇಳಿದ್ರಿ.
my lords. He deposited money, returns he
Say,
got.
I have not granted coordinate bench.
Coordinate bench, but extension, I think, my lords.
Correct, I
14,
have extended it. Yes.
Page 372.
Hmm.
Allegation that, my lord, that he has made people to invest 20 crores.
Who? Petitioner alla.
Petitioner. He made people to invest 20 crore rupees.
Can
370.
can I point out, my lords, what's there in the
372,
charge sheet? My lords, in the charge sheet, according to the investigating officer, my lords, total number of investors are about 1,400 investors, my lords. 69 depositors have been cheated in the charge sheet. My lords, A1 to A7 are all pertaining to Vikram investors. A8 is a depositor who has got the highest returns. So they say, since he got the highest returns, we will make him an accused. Can a depositor be made an accused under KPID Act?
That will.
And also, my lords, similarly, in fact, one of the freezing matters, my lords, where the Prakash Padkone's case, where it was frozen, had approached before this honorable court, and this honorable court had defrozen, saying he's a depositor.
Justice Chavan.
Yes, my lords.
All right.
They've
Yes.
received
So here, my lords, in their case itself, they say, I deposited the amount, I have received this much returns. Since I received maximum returns, make him an accused. This is all the case insofar as A8 is concerned.
He invested 20 crores, 80 lakhs, received 56 crores, 69
Well,
lakhs.
it's 5%. Similarly, all have received. Out of 1,400 people, only 69 people have not received. That is what the charge sheet says. How do they bring me under KPID? How do I become a person, my lords, who is a financial establishment? And in fact, to protect my interest, that act is there, my lords. Depositor's interest, you have to protect. Now, merely because I get returns out of it, you make me under section 9 of the KPID Act.
Depositor who invests 24 and takes 56.
Yes, my lords, 2011. My lords, 2011 was the date of deposit. 5% interest is what they have given everyone. That is exactly what they have given me. And in fact, my lords, some amount is due. I should be a person who should be aggrieved, my lords, for what amount is due, but I have not set the law in motion. The complainant who set the law in motion, my lords, he says he invested 11.74 crores. He received back 3 crores odd. Remaining amount I have not received. I stand in that footing. And your investigation reveals that I stand in the footing of a depositor. Now, 1,400 people are this. They all have to be made accused, my lords, if if the same yardstick is applied.
No. Stay court. Jagdish.
Please.
Speak up the next time.
12th. List on heard the land senior counsel Sandesh Chowta appearing for the petitioner to hear the SPP list on 12th. Interim order. Mahadev, ಏನಿದು?
Direct type. Police no record. The same set of facts have already stayed in different crime number. Another petition.
EC Act.
Is essential committee tax. All are owners of the vehicle. FIR name illa owner accused ಅಂತ ಮಾಡ್ಬಿಟ್ಟಿದ್ದಾರೆ ಎಲ್ಲರೂ. This honorable court already stayed. Same different crime number.
Page ಎಲ್ಲಿದೆ ಕೊಡಿ.
Another crime number, another connected petition ಇದೆ.
ಆಗಿದೆಯಲ್ಲ ಇದರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ವಾ?
ಅಲ್ಲ ಅದರಲ್ಲ ಅದು different crime number ಅಲ್ಲಿ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ. Same not.
Urea which was supposed to be distributed for farmers has been.
ಯಾವ್ದನ್ನ?
ಇವರೆಲ್ಲ ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್.
ಅಲ್ಲ ಓನರ್ ಗೊತ್ತಿಲ್ಲದೆ ಏನ್ ಡ್ರೈವರ್ ತಗೊಂಡ್ ಹೋಗ್ತಾರ?
ಡ್ರೈವರ್ ಎಲ್ಲ ಸ್ವಲ್ಪ ಗಾಡಿ ನಡೆಸೋದು. ಓನರ್ ಯೂರಿಯಾನ
ಯೂರಿಯಾನ ಇದು?
ಯೂರಿಯಾ ಗಾಡಿ
1200 bags of urea.
ಅದು ಗೋಡೌನ್ ಇತ್ತು, ಲಾರಿ ನಿಲ್ಸ್ಕೊಂಡಿದ್ರು ತುಂಬಾ.
ಪಕ್ಕಕ್ಕೆ ನಿಲ್ಸ್ಕೊಂಡಿದ್ರಾ?
ಗೋಡೌನ್ ಇತ್ತು ಅಂತ ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ರು.
ಆಯ್ತು, ಈಗ ತಗೊಂಡಿದ್ದಕ್ಕೆ ರಿಸಿಪ್ಟ್ ಕೊಡಿ.
ನಾವ್ ತಗೊಂಡಿಲ್ಲ, ಸೊ ಗಾಡಿ ಬಾಡಿಗೆ ಕರೆದಿದ್ರು, ಹೋಗಿದ್ದು ಅಲ್ಲಿ ನಿಂತ್ಕೊಂಡಿದ್ದು ಅಂತ ಕೇಸ್
ನಿಂತ್ಕೊಂಡಿದ್ರು. ಹಂಗಾರೆ ಎವಿಡೆನ್ಸ್ ನಡೀಲಿ.
ಅಲ್ಲ ಸರ್, ಆಲ್ರೆಡಿ ಸ್ಟೇಟ್ ಬೈ ದಿಸ್
ಫಾರ್ಮರ್ಸ್ ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡೋ ಯೂರಿಯಾ ಎಲ್ಲ ನೀವು ತಗೊಂಡ್ರೆ ಹೆಂಗ?
ನಾವ್ ಹೆಂಗ್ ತಗೊಂಡಿ ಸರ್? ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ FIR ನೇಮು ಇಲ್ಲ ಸರ್. ಆಲ್ರೆಡಿ ಸ್ಟೇಟ್ ಬೈ ದಿಸ್ ಕೋರ್ಟ್ ಇನ್ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್, ಡಿಫರೆಂಟ್ ಕ್ರೈಮ್, ಸೇಮ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮೇಲೆ. In repetition number.
SPP. List on.
Fertilizers have been seized from them.
List on 6th.
ಅಲ್ಲ in meantime.
Yes.
ಅಲ್ಲ ಕನೆಕ್ಟೆಡ್ ಮೆಟಲ್ ಸ್ಟೇ
ಇಲ್ಲ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೇಕದ್ನ.
ಅಲ್ಲ ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಲೇಡೀಸ್ ಇದ್ದಾರೆ ಸರ್. ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಲೇಡೀಸ್
ಎಲ್ಲಿದ್ದಾರೆ ಇಲ್ಲಿ?
ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಲೇಡೀಸ್ ಇದ್ದಾರೆ ಸರ್.
Owner of the vehicle.
ಓನರ್ ಆಫ್ ದ ವೆಹಿಕಲ್ ಸೆಕೆಂಡ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
Their vehicles which have been used.
ವೆಹಿಕಲ್
ಬಿಡ್ಬೇಡಿ.
ವೆಹಿಕಲ್ ಆಲ್ರೆಡಿ ರಿಲೀಸ್ ಬೈ ದ ಸೆಷನ್ ಕೋರ್ಟ್.
ನಾನಲ್ಲ, ಸೆಷನ್ಸ್ ಕೋರ್ಟ್.
ಸೆಷನ್ ಕೋರ್ಟ್ ಆಲ್ರೆಡಿ ರಿಲೀಸ್ ಮಾಡಿ.
ಎಸ್, ಬಿಪಿನ್ ಸರ್.
Swami, second, my lordship, second petition ladies.
Fifth, yes.
ಅಲ್ಲ ಅಲ್ಲಿ ನೆನ್ನೆ ಇತ್ತು ಸ್ವಾಮಿ, ನೆನ್ನೆ ಇದೆ ಇವತ್ತು.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ.
ಅಲ್ಲಿ ಲೇಡೀಸ್ ಅರೆಸ್ಟ್ ಇದ್ ಮಾಡ್ತಾರೆ.
ಪರವಾಗಿಲ್ಲ. Yes, next.
This is a matter of case and
ಇಲ್ಲ,
counter
fresh
case.
matter is fresh matter.
Fresh matter.
My lord, incident is the same, matter of case and counter case, which my learned friend disputes. The complaint, my lord, is that we had, my lord, given a sum of 25 lakhs to the complainant. My lord, he promised us, my lord, to get some contract work from the government. He did not get us any contract work. Thereafter, my lord, we called him up and we, my lord, asked for the money back. Now for that, my lord, he files a complaint under section 506 and 34. After charge sheet, my lord,
506, 34.
charge sheet alli extortion ಆಗ್ತಾರೆ.
Charge sheet 384, 511.
And 511. Now, my lord, for the cheating which he has done of receiving the money, I file, my lord, the complaint in another police station. Now,
ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ವಾ ಅಕ್ಷಯ್?
ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ ಅದು.
ಬಿ ರಿಪೋರ್ಟ್.
ನನ್ನ ಮೇಲೆ ಹಾಕಿರೋದು ನಾನು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆ. Their complaint, my lord.
ಪ್ರೊಟೆಸ್ಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ.
We have filed a protest petition.
Now, my lord, protest petition also rejected, everything is accepted.
That will challenge.
Closed.
Close ಆಗಿದೆ.
Against me, it is closed.
It is not a case and counter case.
Yesterday, my lord, yesterday it has been rejected. My lord, that we will challenge it also. Now, my lord, otherwise also. Now, my lord, first question is, my lord, whether it is a case or counter case. The complaint in both the cases.
You forget about case and counter case.
Yes, my lord.
ಇದರಲ್ಲಿ ಏನಿದೆ ಹೇಳಿ?
Now, my lord, extortion. They say, my lord, there is extortion. The ingredients of extortion is not here. Now, your lordship may kindly see the charge sheet, my lord, which is produced. It page 24. They just say, my lord, the page 29. Your lordship may kindly
14
see.
is the complaint.
Yes, my lord.
All right. 25 ಲಕ್ಷ ಕೇಳಿದೀರಾ ಅಂತ
Yes, my
ಹೇಳಿದ್ರು.
lord. Ingredients ಇಲ್ಲ, there is no, my lord.
ಆಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರು.
Yes, my lord.
ಚಾರ್ಜ್ ಶೀಟ್ ಕ್ರೈಮ್ ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ಇರ್ಲಿಲ್ಲ.
ಇರ್ಲಿಲ್ಲ.
ಈಗ 29 ಅಲ್ಲಿ ಎಕ್ಸ್ಟ್ರಾಕ್ಷನ್ ಹಾಕಿದ್ದಾರೆ.
My lord, there should be a dishonestly, my lord, illegally I should have gained. There, my lord, there is no, my lord, he has not paid us any money. It is not his case, my lord, that we have extorted the money from him.
ಈಗ ಎಷ್ಟು ದುಡ್ಡು ಕೊಟ್ಟಿದ್ದೀರಾ?
My lords, I have not given anything.
then extortion ಎಲ್ಲಿಂದ ಬಂತು
My
ಸರ್?
lords,
He made a phone call.
Maybe
That is-
extortion would get once it transaction is complete. The money should reach the person who has called and asked. Sumne not in the imagination.
but my lords,
Your lordships have also
they have
held
come
that, my lord,
little
Naveen
late,
Kumar
my lords.
Patil case.
Correct. ಅದನ್ನೇ ಬರ್ದಿರೋದು, ಅದನ್ನೇ ಹೇಳಿದ್ದೀಗ ನಾನು.
Yes, my lord.
Now that they have come.
The
my lords,
transaction should get complete. ಸುಮ್ನೆ ಫೋನ್ ಮಾಡಿ ಕೊಡಿ ಅಂದ ತಕ್ಷಣ ಆಗಲ್ಲ. That may be in 504, 506 ಅದೇನಾರು ಆಗ್ಬೋದು.
384 read with 511.
Maybe.
That's attempt.
To preparation to commit a crime.
Attempt.
511 would come into effect, preparation to commit a crime which is punishable with life or any other.
But my lords, they have come little late, my lords. Evidence is commenced.
Little later,
Evidence is
Evidence is
charges have been
Charges
framed.
are framed,
Evidence.
evidence.
before filing the petition.
ಅಲ್ಲ ಇದ್ರೂನು,
I'll
my
file,
lord,
my
now,
lords.
my lord, in the charge sheet itself.
I will direct conclusion of the trial.
My lord, the case and counter case, my lord, it goes to the root of the matter. Now, my
Counter
lord,
case ಬಿ ರಿಪೋರ್ಟ್ ಆಗಿದೆಯಲ್ಲ.
now, my lord, that was rejected yesterday.
ಚಾಲೆಂಜ್
Now, my
ಮಾಡಿ
lord, I will challenge it. Your
ಮಾಡಿ
lordship.
ಅದನ್ನು ಕಳ್ಸೋಣ ಅಲ್ಲಿಗೆ.
Therefore, my lord, let both the matters, my lord, be taken up. Yesterday it was rejected. Last week time ತಗೊಂಡ್ರು, ನಿನ್ನೆ ಅದು ಆರ್ಡರ್ ಆಗಿದೆ ಅಷ್ಟೇ.
ಬಟ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗ
Nothing was rejected, my lords. B report is accepted.
ಅಲ್ಲ, B report is accepted, my protest petition
is rejected. ಅದೇ ಹೇಳಿದ್ದು. ವಿಪಿನ್ ಸರ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದ್ರಾಗಲ್ಲ.
So she will direct, 3 months or 6 months, whatever we can.
I will direct trial to conclude.
Well, let this matter be taken up next week. I will file that petition also, my lord. Both the matters might be taken up.
Both will send.
If I am able to satisfy, my lord, it is one and the same incident, then, my lord, it goes to the root of the matter.
No, it cannot be one and the same because place of incident is different, date of incident is different.
My
I
lord,
don't know how
date
it
is
is.
the
ಅಲ್ಲ
same.
ಇದೇನು ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ ಅಲ್ವಾ?
ಅಲ್ಲ, stay
ನೆಕ್ಸ್ಟ್
ಕೊಟ್ಟಿಲ್ಲ.
ವೀಕ್ ತಗೊಂತೀನಿ, ತೊಂದರೆ ಇಲ್ಲ. ಬಟ್ ಅಲ್ಟಿಮೇಟ್ಲಿ the learned SPP and the counsel for the complainant submit that charges have been framed and the matter is at the stage of evidence. The learned counsel Bipin Hegde would submit that it is a case and a counter complaint. The counter complaint has resulted in a B report. B report is accepted by the concerned court and he would raise a challenge to the said order as well. Though that would not have any bearing on a decision that would be rendered by this court in this petition. Owing to the submission of counsel Bipin Hegde, list this matter on 4th August. ಏನ್ ಸ್ಟೇ ಏನಿಲ್ಲ.
ಅಲ್ಲ, my lord, if there is it's the same incident ಆದ್ರೆ, it goes to the root of the matter.
No root,
Entire investigation has to go. That is what, my lord, I will, my lord, file a synopsis to that effect also.
But ಎಲ್ಲ ಅಲ್ಲೇ ಅರ್ಜ್ ಮಾಡಿ ಬಿಫೋರ್.
ಅಲ್ಲ ಲಾಸ್ಟ್ ವೀಕ್ ಬಂದಾಗ ತಾವೇ ಹೇಳಿದ್ರಿ ರೂಟ್ ಹೋಗುತ್ತೆ ಅಂತ.
ಅಯ್ಯೋ ರೂಟ್ಗೆ ಹೋಗ್ಬಿಟ್ಟ ನಾನೇ ಇಲ್ವಲ್ಲ.
Grateful.
Petitioners, my lord.
130 ಅಷ್ಟೇ.
The respondent was supposed to file.
ಏನ್ ಡೀಟೇಲ್ ಆರ್ಡರ್ ಬರ್ ಸ್ಟೇ ಕೊಟ್ಟಿದ್ದಾನಲ್ಲ ಬಿಡಿ.
ಹೌದು.
17 ವರ್ಷ ತಾನೇ ಇದು.
DVD. 17 ವರ್ಷ, my lord. And I also submitted that there is a gray area of 2F.
List the matter on 31st. Objections if any by ಯಾರು ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
Complainant is a wife, my lord, Manjula.
ಸರ್ವ್ ಆಗಿದೆಯಾ?
Serve agide. Last time, Sarvana was.
In his presence only I passed an order.
Yes, my lord.
List the matter on 31st. We'll close it up.
Great.
Interim order subsisting. File disposal ಕೊಟ್ಟಿದ್ದೀನಿ already.
Disposal.
Next date, huh?
Next date.
Interim order subsisting will continue till the next date of hearing. Next, heard Chiranjeevi and so and so. Yes.
Great. Fresh matters, my lord.
122 my lords. My lords, few persons, my lords, claiming.
ಲೋಕಾಯುಕ್ತ. Latif.
My request, my lord, that I am appearing for BDA. He is a secretary to the BDA.
ಯಾರು?
The accused, the petitioner is presently serving as secretary to the BDA.
BDA?
Yes.
So what?
I am a panel for BDA.
So what? You are appearing for the Lokayukta here. What is this? ಹೇಳಿ.
My lords, my request for some other council maybe.
Lords, few persons, my lords, claiming that there was a grant in the.
ಶರತ್ ಗೌಡ್ರೆ ಇದು ಕೊಡೋ ಪ್ರಶ್ನೆನೇ ಇಲ್ಲ.
No, my lords, I will just explain.
ಕೊಡಿ.
Everything is done on the same day.
No, I will explain, my lords, if your lordship.
You explain to the IO.
My lords, your lordship may kindly bear with me.
Yes, sir. ಹೇಳಿ.
Lords, few persons, my lords, claiming that there was a grant in the year 1962. They prefer an appeal under section 136(2) of the Karnataka Land Revenue Act in the year 2019. In the year 2019, at relevant point of my time, this petitioner was working as AC Dodbalapura. This resulted in an order being passed at Annexure F. 4 grantees, 4 different orders, Annexure F series. Your lordship may kindly take Annexure F for a moment. Lords, kindly.
ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
Lords, I only say by Annexure F orders that they allege that they claim that there is a grant in the year 1962 and in pursuance of the grant there is no mutation of the revenue records in their name. If at all there is this grant is genuine, I direct the Tahsildar to verify records and then take subsequent action. My lords, my role ends there, my lords. I become functus officio. After Annexure F, which is in the year 2019, my role ends there, my lords. Thereafter, my lords, these grantees approach this court by Annexure G, saying non-implementation of the order at Annexure F. This court again says, while they approach this court, my lords, in the meanwhile, this land becomes notified for KIADB. My lords, this court says the assistant commissioner then in the year 2019 had passed an order directing the Tahsildar to verify records, and if the records are found to be genuine, then only to issue Sagavali chit or enter their name in the revenue records, and thereafter they may proceed to take compensation or whatsoever. Your lordship may kindly see Annexure G, my lords. This court's order for a moment.
Page 60, 61.
Lords, page 59 as well.
Right.
Page 59 as well. Lords. In the meanwhile, acquisition notifications were issued for the benefit of the respondent Karnataka Industrial Area Development Board, notifying the lands in question along with other lands for development of an industrial area. However, it is submitted that at the instance of the petitioner who had raised a dispute under section 136 clause 2 of the Karnataka Land Revenue Act before the Assistant Commissioner Dodbalapura subdivision, the Assistant Commissioner issued certain directions to the Tahsildar Devanalli to verify from the records, and if it is found that the grant was indeed made in favor of the petitioner, then to proceed to effect kata in favor of the petitioner. Pursuant to order passed by this honorable court, they have approached the Tahsildar, got their names mutated in the revenue records. Thereafter, they approached the special land acquisition officer who was then the holding KADB. My lords, as I submitted earlier, my lords, my role ended after passing Annexure F. After that, I have never occupied any post in the KADB or elsewhere. Thereafter, I was appointed as AC Ramnagra. Then now I am presently working in the BDA as the secretary. After 2019 order, my lords, now my role is not at all there. What happens, my lords? Thereafter, they once again approach for implementation of the orders Annexure G by filing a contempt, saying that my name is mutated in the revenue records. They are not dispersing the compensation. That, my lords, thereafter the special land acquisition officer who was then working has released the compensation amount. That is not the petitioner. That is, my lords, the special land acquisition officer who released the compensation amount is the accused number 1 in the connected petition. Crime number 3 of 2026 registered by that is stayed by my lords. My lords, now I am saying my role ended in 2019. All I said is directed the Tahsildar, verify the records. If the grant is genuine, then mutate their name. Apart from that, there is nothing. My lords, the entire crime in the FIR, my role is that's all. My lords, that was in the year 2019. My lords, thereafter they approached this court. The grant is alleged. Grant is.
Yes.
Therefore, my lords, to haul me into web of this crime, my lords, it's.
When you consider this application, the age of the applicant, 5 years.
No, that grant is issued in 1962. I only say
Correct.
they
That time
asked
you
the
were only 5
Tahsildar to
years
verify the records. Grant is found genuine, then mutate. Then they
ಅದನ್ನ
approached.
ಹೇಳಿ ತಹಸೀಲ್ದಾರ್ ಅದೇ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದು.
ಅಷ್ಟೇ ಕೊಟ್ಟಿರೋದು ನಾನು. ಅದಾದ್ಮೇಲೆ ಅವ್ರು ಹೈಕೋರ್ಟ್ ಬಂದಿದ್ದಾರೆ. This court also takes note of my
This
order.
court coordinate bench says in accordance with law ಅಂತ.
I also say in accordance with law. Apart from that, I do not say anything. My role is no different from the order passed by this honorable court. They approached this court for non-implementation of my order in 2019.
ಈಗ ಗ್ರಾಂಟ್ ಅವ್ರ ಗ್ರಾಂಟಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಎಷ್ಟು ಕಾಂಪನ್ಸೇಷನ್ ತಗೊಂಡಿದ್ದಾರೆ?
ನಮಗ್ ಗೊತ್ತೇ ಇಲ್ಲ.
ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
ನಾವು ಒಂದು
ನೀವು ತಗೊಂಡ್ರದಲ್ಲ ನಿಮ್ ಕಾಂಪನ್ಸೇಷನ್
ನಮಗೆ ಇಲ್ಲಿ ಬಂದೇ ಇಲ್ಲ. 2019 ಅಲ್ಲಿ AC ದೊಡ್ಡಬಳ್ಳಾಪುರ ಸಬ್ ಡಿವಿಷನ್ ನಾನು ಸ್ಪೆಷಲ್ ಲ್ಯಾಂಡ್ ಅಕ್ವಿಸಿಷನ್ ಆಫ್ KDB
ಈಗ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ. ವೈ ಆರ್ ಯು ಫೈಟಿಂಗ್ ಸೋ
ಐ ಆಮ್ ಸೇಯಿಂಗ್ ಮೈ ಲಾರ್ಡ್ಸ್, ನಾನು KDB ಯಾವತ್ತಿಗೂ ಹೋಗೇ ಇಲ್ಲ. ಕಾಂಪನ್ಸೇಷನ್ ನನ್ನ ಇದ್ದಾಗ ಆನ್ ದಿ ಅದರ್ ಹ್ಯಾಂಡ್ at the instance of special land acquisition of KDB who is arraigned.
ಈಗ ಆರ್ಡರ್ ಬರ್ದಿರೋದು ನೀವೇ. ಸಿ ಮಂಜುನಾಥ್ ನೀವು.
Annexure F ಮಾತ್ರ
ಒಂದು ನಿಮಿಷ. ಪ್ರಕರಣ ಸಂಖ್ಯೆ 51/2019 ಅಲ್ಲಿ
Annexure F ತಗೊಳ್ಳಿ ಮೈ ಲಾರ್ಡ್ಸ್.
ಒಂದ್ ನಿಮಿಷ. Annexure F ಬಿಡಿ. ಒಂದ್ ನಿಮಿಷ. ಅದರಲ್ಲಿ ನೀವೇನ್ ಬರೀತೀರಾ? ಇತ್ತೀಚಿನ ಕ್ರಯದ ವಹಿವಾಟುಗಳ ಬಗ್ಗೆ EC ಅನ್ನು ಒಂದ್ ನಿಮಿಷ EC ಅನ್ನು ಪರಿಶೀಲಿಸಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡುವಂತೆ ಖಾತೆ ದಾಖಲಿಸುವ ಬಗ್ಗೆ ಕ್ರಮ ವಹಿಸಲು ಆದೇಶಿಸಿದೆ. ನಿಮ್ದು ಆರ್ಡರ್.
My lords, my reading, I did not get where my lord.
No, I am reading the investigation papers.
Not
your order.
Lords, your lordship may take my order.
ಅದಕ್ಕೆ ನಿಮ್ಮ ಆರ್ಡರ್ಲೆ ದೇವನಹಳ್ಳಿ ಇದು ದೇವನಹಳ್ಳಿದು ಪ್ರಾಬ್ಲಮ್. ಅದಕ್ಕೆ ದೇವನಹಳ್ಳಿ ತಾಲೂಕು
ನಂದು ಅರಳೂರು ವಿಲೇಜ್, ಅವ್ರ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ನಲ್ಲಿ ಪೂಲ್ನಹಳ್ಳಿ ವಿಲೇಜ್. ನಂದು ಹರಳೂರು ವಿಲೇಜ್.
ಎಲ್ಲಿ ಬರುತ್ತೆ ಎರಡು? ದೇವನಹಳ್ಳಿ ತಾನೆ. ನೀವು ಹಳ್ಳಿ ಈ ಹಳ್ಳಿ ಅಂದ್ರೆ ದೇವನಹಳ್ಳಿ. ನಾವು ದೇವನಹಳ್ಳಿ ತಾಲೂಕು ಚಂದ್ರ, ಇಟ್ ಇಸ್ ನಾಟ್ ದಿಸ್ ದೇವನಹಳ್ಳಿ, ಚಂದ್ರಾಯಪಟ್ಟಣ.
ಈ ದೇವನಹಳ್ಳಿ ಅಲ್ಲೇ ಚಂದ್ರಾಯಪಟ್ಟಣ ಅಂತ ಇದೆ.
ಅದು ಬೇರೆ ಇದೆಯಾ? ಸರಿ ಬಿಡಿ. ದೇವನಹಳ್ಳಿ ತಾಲೂಕ್ ಚಂದ್ರಾಯಪಟ್ಟಣ ಹೋಬಳಿ ಗ್ರಾಮದ ಸೋ ಜಮೀನ್ 22 ಎಕರೆ 14 ಗುಂಟೆ ಪೈಕಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಮಂಜೂರಾಗಿರುವ 1 ಎಕರೆ ಸಂಬಂಧಪಟ್ಟ ಸಾಗುವಳಿ ಚೀಟಿ ವಿಚಾರಣಾ ವಹಿಯ ಹಾಗೂ ಮಂಜೂರಾತಿ ನಕ್ಷೆಯ ದೃಢೀಕೃತ ನಕಲನ್ನು ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಆಯ್ತಾ? ಆದ್ದರಿಂದ ಪ್ರಕರಣವನ್ನು ತಹಸೀಲ್ದಾರ್ ಅವರಿಗೆ ಹಿಂದಿರುಗಿಸಿ ಮಂಜೂರಾತಿ ದಾಖಲೆಗಳ ಬಗ್ಗೆ ತಹಸೀಲ್ದಾರ್ ಅವರು ಖುದ್ದು ಪರಿಶೀಲಿಸಿ ನೈಜತೆ ಬಗ್ಗೆ ಖಾತ್ರಿಪಡಿಸಿಕೊಂಡು ದಾಖಲೆಗಳ ನೈಜವಾದದ್ದಲ್ಲಿ ಮಾತ್ರ ಸ್ವಾಧೀನ ಹಾಗೂ ಇತ್ತೀಚಿನ ಕ್ರಯದ ವಹಿವಾಟುಗಳ ಬಗ್ಗೆ EC ಅನ್ನು ಪರಿಶೀಲಿಸಿ ಮೇಲ್ಮನವಿದಾರರಿಗೆ ಸಾಗುವಳಿ ಸೋಣಿಸೋ ಆಯ್ತು.
136 routine order.
ಆತರ ಇವರೇ.
Your orders, there is no age of the petitioner. If you go back to 1962, some of the petitioners are not even born.
ಒಂದ್ ನಿಮಿಷ. ಈಗ 1962 ಗ್ರಾಂಟ್ ಆಗಿದೆ
ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ನಮಗ್ ಗೊತ್ತಿಲ್ಲ. ಗ್ರಾಂಟ್ ನಿಜ ಇದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದೀವಿ ನಾವು.
ಏನಾರ ಇರ್ಲಿ, ನಿಮ್ ಮುಂದೆ ಬಂದಿದ್ದು ಗ್ರಾಂಟ್ ಆಗಿದೆ. 136(2) ಪ್ರೊಸೀಡಿಂಗ್ 136(2) ಪ್ರೊಸೀಡಿಂಗ್ ಅಲ್ಲಿ ನೀವು ಬಾಲ್ಡ್ ಆಗಿ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಯು ಹ್ಯಾವ್ ಟು ಗೋ ಇಂಟು ದಿ ಮೆರಿಟ್. ಆಲ್ ರೈಟ್.
136 only regarding mutation of the revenue.
ಕರೆಕ್ಟ್ ಸರ್. ಅದಕ್ಕೆ ನೀವು ಬಂದವರಿಗೆಲ್ಲ ಕೊಡ್ತೀರಾ?
ಇಲ್ಲ. ಮತ್ತೆ I only say that if the records are genuine, direct the Tahsildar.
Correct sir. It is mutation proceedings. That doesn't mean you should be mute.
Please.
Now 26/12/1962 is the grant.
ಮಂಜೂರಾತಿ ಅಂದ್ರೆ ಮೇಲ್ಮನಿದಾರರ ತಾಯಮ್ಮ ಕೋಮ್ ಮುನಿನಂಜಪ್ಪರವರಿಗೆ ಹೆಸರಿಗೆ ಸಾಗುವಳಿ ಚೀಟಿ ನೀಡಿದ್ದು. ನಾಟ್ ದಿ ಮೈ ಲರ್ನಡ್ ಫ್ರೆಂಡ್ ಇಸ್ ಟ್ರೈಟಿಂಗ್ ಟು ಮೇಕ್ ಔಟ್.
ಯಾರು?
SPP ಅವರು ಆ ಮುನಿಯಮ್ಮ ಏಜ್ ನ ಡಿಫರೆನ್ಸ್ ತೋರಿಸಿದ್ದಾರೆ. ಗ್ರಾಂಟ್ ಆಗಿರೋದು ಅವ್ರ ತಾಯಿಗೆ ಅಂತ ಹೇಳಿರೋದು ಇಲ್ಲಿ. ಆಲ್ ದಟ್ ಮೈ ಲಾರ್ಡ್ಸ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವಿಲ್ ಕೈಂಡ್ಲಿ ಅಪ್ರಿಶಿಯೇಟ್. ಐ ಹ್ಯಾವ್ ಸೆಡ್ Tahsildar to verify the record.
ಇದರಿಂದ ಏನಾಗಿದೆ ಜಗದೀಶ್?
ಅಲ್ಲ, ಇವೆಲ್ಲ Annexure F151.
ಇಲ್ಲ, ಇದರಿಂದ ಕಾಂಪನ್ಸೇಷನ್ ಹೋಗಿದೆ.
Yes my lord.
50 ಕೋಟಿ.
ಅದೇ ಕನೆಕ್ಟ್. ಅದು ಕಾಂಪನ್ಸೇಷನ್
15.
ಕಾಂಪನ್ಸೇಷನ್ ರಿಲೀಸ್ ಮಾಡಿರೋ ತಾವು ಸ್ಟೇ ಮಾಡಿದೀರಾ ಕನೆಕ್ಟೆಡ್ ಕೇಸ್ ನಲ್ಲಿ crime number-
The modus operandi is blood. The Tejas Kumar being acted as assistant commissioner. Later he transferred to KDB.
ಆ ನಂಬರ್ ಕೊಡಿ.
Blood.
Crime number-
It is listed for tomorrow. The
ನಾಳೆ
Tejas Kumar
tag
got
along with
transferred to KDB.
tag the petition along with WP 17437 of 2026.
ಇವಾಗ ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇದೆ, ಅದಕ್ಕಾಗಿ ನನಗೂ ಸ್ಟೇ ಕೊಡಿ ಅಂತ ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ದು.
ಈಗ ಅದ್ರಲ್ಲಿ ಸ್ಟೇ
He
ಇದೆ.
himself filed an
ನಾಳೆ
affidavit
ಎರಡು
in the
ಮುಗಿಸ್ಕೊಂಡು.
contempt.
ಆಯ್ತು, I will try to distinguish my lords my case because there this very officer who passes this, he goes and occupies the
Sir,
position as special.
ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. You try to distinguish,
Lords.
but the petitions will extinguish.
Lords,
Yes.
you lordship, lords, till tomorrow my lords an interim order.
No,
because
no,
they have issued 35(3) notice.
ಪರವಾಗಿಲ್ಲ, ಏನ್ ರಾತ್ರಿ ಬಂದು ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರ? Yes.
But my lords, your lordship will kindly see. Compensation e officer ಇದ್ದಾಗ ಹೋಗಲ್ಲ. In the connected case what happens my lords? This very assistant commissioner in the connected case.
ಇಲ್ಲ, ಯಾರಿಗೆ ಗ್ರಾಂಟ್ ಗೊತ್ತಿಲ್ಲ, ಏನ್ ಗೊತ್ತಿಲ್ಲ. 15 ಕೋಟಿ ಹೋಯ್ತು ಪಬ್ಲಿಕ್ ಮನಿ.
Your lordship will kindly appreciate. After this 2019 order, I have become functus officio. I have no role whatsoever. I was never occupied any, I have never
problem,
occupied any
sir.
position as.
Foundation
Lords, my lords,
foundation for compensation is your order.
Lords, no.
Lord.
My lords, compensation is the order passed by special land acquisition officer.
Foundation ಅಂದ್ರೆ.
Lords, this order, my lords, has no relevance whatsoever because thereafter the Tahsildar has
We'll
verified
see.
the records. Then my lords, if
If Tahsildar is not the accused,
no, these not hauled into the web of the crime, then how can I be made as a
will come
party?
sir. FIR ಇದೆ ಇನ್ನು.
Your lordship will
ಚಾರ್ಜ್
kindly
ಶೀಟ್ ಅವರು ಬರ್ತಾರೆ.
see. My lords, your lordship will kindly see. If my order is the foundation, my lords, so will be the order of this honorable court which also reiterates my order.
What?
My lords, I only say verify the records.
Tomorrow, sir. Yes.
My name.
ಇರ್ಲಿ ರತಿ, if you be there. ನೀವು ಯಾವ್ದೋ ಅಲ್ಲಿ
Connected
ವಿಡಿಯೋ
case,
ಇದ್ರೆ
ready with
ಅನ್ಬಿಟ್ಟು
the statement
second
of
so what?
objection. The connected case, he had acted dual role. Being an assistant commissioner and he himself dispersed
That is
the.
a different person, not this person. That person.
I
is
And in
not
the contempt petition, he had complained, if he filed an affidavit saying that it's a genuine documents, we are dispersing the about.
That man.
Yes.
that man, not this person.
You wait, not
This
this
case,
man.
my lord, this person has passed in an order of changing the mutation.
I am not passed an order for.
ಆಯ್ತು,
change of
ಇಷ್ಟು ನಾಳೆ ಯಾಕೆ? No problem.
In connected case, what happens, my lords? This very person who passes an identical order, Tejas, he goes and becomes the special land acquisition officer.
ಆಯ್ತು, ಇರ್ಲಿ, we'll see tomorrow.
Please.
For petition number. My lord, petition number 1 ಇದೆ my lord.
My name may be shown.
Registry to print the name of B. Latif as appearing for the respondent ಲೋಕಾಯುಕ್ತ.
Correct.
ಯಾವ್ದು 122 ಅಲ್ಲಿ. Yes, no?
My lord, petition number 1 is a doctor, my lord. Petition number 2 is a advocate, my lord.
ಏನ್ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದೆ?
Kindly come to the page number 23, my lord.
ನಾನೇ ನೋಟಿಸ್ ಮಾಡಿರೋದ?
Yes, my lord.
Oh, yes, sir.
My lord,
SPP was asked to appear.
yes, my lord. ಆಲ್ಗೇರಿ ಮಂಡ್ರಿ ಗಸ್ತು ಆಲ್ಗೇರಿ ಮಂಡ್ರಿ ಶಾಖೆ ಹೊಸನಗರ ವಲಯ ಸಾಗರ ವಿಭಾಗ ಕೆ ಹುಣಸವಳ್ಳಿ ಗ್ರಾಮ ಸರ್ವೆ ನಂಬರ್ 72-2, 72-3, 72-4 ಹಿಡುವಳ್ಳಿ ಪ್ರದೇಶ.
Forest offense, sir.
Yes, my lord.
But yes, list the matter on 11th August.
Madam.
The learned SPP to secure instructions and make
My
submissions.
lord,
Next.
my lord, kindly come to the
Rosewood
page.
trees. Yes, sir.
My lord, kindly come to the page number 24, my lord.
Yes,
My lord,
next.
They come to my home, threatening my lord. Kindly come to the page number 24.
Huh?
Kindly come to the page number 24.
Come to your home and
And
lock.
lock open the lock, my lord. Clinic, my lord.
Doctor ನೀವು?
ಹೌದು. Kindly come to the 24. 70 ಕಿಲೋಮೀಟರ್ ಆಗುತ್ತೆ. ಮಾಜಾರ್ 13th ಮಾಜಾರ್ ಮಾಡಿದ್ದಾರೆ, 14th FIR ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ. ಮತ್ತೆ
Don't harass the doctor if he is a doctor.
ಅಲ್ಲ ಕ್ಲಿನಿಕ್ ಬ್ರೇಕ್ ಓಪನ್ ಮಾಡಿದ್ರು, ಲಾಕ್ ಓಪನ್.
Clinical Rosewood ಇಟ್ಟಿದ್ದೀರಾ?
ಇಲ್ಲ ಮೇಲೆ ಅದಕ್ಕೋಸ್ಕರ ಇಟ್ ಇಸ್ ನಾಟ್ ಕನೆಕ್ಟೆಡ್ ಟು ದೇಮ್. ಅವರೇ ಮೊದಲನೇ ಮಾಜಾರ್ ಮಾಡ್ಕೊಂಡು ಪೂರ್ತಿ ತಗೊಂಡು ಹೋಗಿ ಆನಂತರ kindly come to the page number 24.
List the matter on 11th. The respondent police shall not.
Forest official.
Yeah, the forest official shall not spread the matter till the next date of hearing. Yes.
Precipitate ಅಂದ್ರೆ ನೀವು
Hello.
ಮಾಡಲಿ.
Not to take any coercive steps against the petitioner till the next date of hearing. Yes.
Last time, Lord, it was an offense under 108. Lord, the allegation is that there has been offense of abatement of suicide. If the complaint is looked into at page 20.
Loan recovery agent.
I am a manager, my lord. I am not an agent. I sit in somewhere else. And the allegation in the complaint, if your lordships will see, our mane mele idar mele the property has been mortgaged. On this stray sentence, my lord, the 306 is. And if
ಹೋಗಿ
the
ಕಾಟ ಕೊಟ್ಟಿರ್ತೀರಾ?
manager, my lord, I am sitting somewhere else.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿರ್ತೀರಾ ನೀವು. ಅಕ್ಯೂಸ್ ನಂಬರ್?
My lord, I'm nowhere in the picture. I'm sitting somewhere else.
All right, yes.
If the complaint is
Accused,
looked,
sole accused.
kindly see, my lord, the complaint I'll
You are
read.
the sole accused?
Yes, my lord.
No.
Kindly see,
ಇನ್ನೂ
my lord.
ಕ್ರೈಮ್ ತಾನೆ?
Oh, the crime stage.
Where the investigation papers?
ಓಲಲ್ಲೆಲ್ಲ they've written the properties belongs to them and.
ಅದೇ ಕರೆಕ್ಟ್, ಅದು ಮಾಡಿರ್ತಾರೆ ಇವರು. ಏನ್ ಕಮ್ಮಿ ಇಲ್ಲ. Yes.
Now, my lord, if
This is why that Microfinance Act is also there. Anyway, you don't belong to that. But yes, let's, one HCGP, 2, HCGP ಆಗಿದೆಯಲ್ಲ, emergent notice. Notice ಆಗಿದೆ ನೋಡಿ ಮೇಡಮ್.
not yet.
Emergent notice to the complainant returnable by the 12th, list on 12th August.
But in the meantime, my lord,
Secure bail, sir.
what I'm saying is,
ನಿಮಗೆ ರಿಕವರಿ ಮಾಡ್ಬೇಕಾದ್ರೆ ತೊಂದರೆ ಕೊಡ್ತಿರಲ್ಲ, ಬೇಲ್ ತಗೋಬೇಕಾದ್ರೆ ಎಷ್ಟು ಕಷ್ಟ ಆಗುತ್ತೆ ಅಂತ ಗೊತ್ತಾಗ್ಬೇಕು.
I'll point out from the
Secure
very,
bail, sir.
I'll point.
I will not state, sir.
What I'm pointing out is,
Whatever you may point.
my lord, there is no direct evidence, my lord,
No problem.
forcing him to, my lord, there is no
problem.
nexus also.
ಲೋನ್ ರಿಕವರಿ ಮಾಡಕ್ಕೆ ಅಂತ ಕಾಟ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ಸೋತೋಗ್ಬಿಟ್ಟಿದೆ.
Kindly have a look at the complaint.
Your asset reconstruction company.
ARC, my lord, that to a manager, my lord. And my lord, it is not their case that this manager has even visited the spot.
Not necessary, sir.
If the complaint is, I'll not remove.
ಬರಲ್ಲ, objection ಹಾಕಿ, ಬರ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಬರ್ಲಿ.
In the meantime, my lord, they are asking.
Secure bail, sir.
So far as this particular.
Secure bail, sir.
My lord, taking bail is one aspect, my lord. The
No,
other
only aspect now. Take bail.
No, as regards, my lord, me being subjected to, my lord, unwarranted investigation.
No problem. ಅದಕ್ಕೆ bail ತಗೊಳ್ಳಿ, sir. I will urge all this in the bail.
My only contention that I'm advancing is that by virtue of, my lord, the latest order of, my lord, the Supreme Court at page 18, my lord, I have.
Oh, ಯಾವ್ದು sir? Bail da?
Yes, my lord, as regards the recovery agent or, my lord, the actions that are taken by the bank. My lord, it cannot be fastened with the criminal liability under
We'll
306.
see, I may quash it also later, ಗೊತ್ತಿಲ್ವಲ್ಲ.
But in the meantime, my lord, very purpose of filing of my petition itself.
Bail ತಗೊಳ್ಳಿ, sir. Secure bail.
But let there be no precipitative action, at least, my lord.
Let you take bail, sir. No. This is not a
Very
case where.
reading of the complaint, if your lordships will see, the complaint itself will not make out an offense under 306.
We'll see, sir. Yes.
If first three sentences, if somebody is writing that this property is mortgaged, will it be a 306 offense?
No, that's not, I'm not saying that, sir. I have not said anything. I'm only saying.
Prima facie, my lord, the allegations are
Take
barred.
bail, sir. Secure bail.
Otherwise, may I request, my lord, at least in a shorter date so that your lordships can, my lord.
No, you take bail. What's the problem?
ಅಲ್ಲ if it
bail ಸಿಗಲ್ವಾ?
ಅಲ್ಲ bail ತಗೊಳ್ತೀನಿ ನಾ
ತಗೊಳ್ಳಿ.
what I'm submitting is that meantime if I'm able to convince on the very basis of the complaint, my lord.
Bail ಸಿಕ್ಬಿಟ್ರೆ ಆಮೇಲೆ ನೋಡ್ಕೊಂಡು ಬಿಡ್ತಂದ್ರೆ. We'll take it on.
There is no material only, my lord. That is what we are
No
seeking the indulgence of this honorable.
The loan recoveries are resulting in terrible problems. We'll see.
He's an utter stranger. He's a manager. They don't even say that he has gone to the spot in the complaint.
Yes.
And if
Let's- ಯಾವತ್ತು ಕೊಡಿ ಡೇಟ್? 12th August.
In the fresh matters.
Oh, 100% fresh matters. Yes. PF ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
No, my lordship, last occasion only, my lordship has directed to get the instruction to consider the.
I take notice for R2 also.
Emergent notice ಆಗಿದೆ already.
My lordship, that is not.
A week's time is granted to learned, ನೀವೇ ತಗೊಂತೀರಾ? Learned HCGP accepts notice for the second respondent as well. Registry to print the name of HCGP as appearing for both the respondents.
318, my lordship.
ಇರ್ಲಿ ತೊಂದ್ರೆ.
4 acres of land have been.
1977, it has been
Documents
granted.
have been fabricated and mutated.
Granted, my lordship.
Matter. ಏನ್ ಪಬ್ಲಿಕ್ ಸರ್ವೆಂಟ್ಸ್ ನೀವು?
Agriculture is the lordship.
Agriculture.
1977
Bless
grant,
the-
my lordship.
Bless the matter
And,
on 4th August in the fresh matters. Yes. Next.
411, 413, no recovery from the petitioner, my lords.
ಇದು stolen gold.
Please, my lords,
Ah,
page
yes.
122, my lords, I'll point out this. my lords.
Really, no. There is in fact, my lord, what he does, he doesn't give us any information about accused being pledged in the gold. What happens? He has a CCTV in his this thing. The CCTV records everything.
No.
And we have recorded that, we recovered that, and then the FSL report confirms that.
ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಲ್ಲ?
Please come to
ಡಿಸ್ಚಾರ್ಜ್
page-
ಹಾಕೊಳ್ಳಿ.
No, please come to page 122, my lords.
These are the photographs and
122.
the
File
FSL
discharge.
report, my lord.
That's only page 122. One moment, my lords. I'll not take much time, my lords.
Yes,
Page
sir.
122.
ಹಾ.
Lords, this is a letter which I issued to the police inspector,
ಹ್ಮ್.
wherein the policemen come to my shop
and they demand gold.
Demand gold.
Please, that is what it is, my lords. On 9/8/2023 at nearly 12:20 AM, your police team with 2 accused who were handcuffed came to our shop and started demanding.
That's in 2023, sir.
Please,
What
my
has
lords.
happened now?
Now, my lords, there is no recovery from the petitioner, my
Now,
lords.
what stage of the proceedings?
My lords, it's still, it is for framing of charge on next Tuesday. my lords.
Let it be, no problem.
He is not given the, in fact, my lord, he denied the entire allegation. His
Before
own
that, you want to file discharge before that, you file.
Let's,
Ilandra will post it on 13th
let's, your
August.
lordships, my lords, 413 is not at all applicable because I've never been convicted for 411.
Yes.
Plus, I've never been convicted for
We'll
411.
see
My
on,
lords,
thir-
with respect
on
to
13th,
411.
on 13th we'll answer, yes. List on 13th August. Next.
My lord, for change of investigating officer, I'm filing the transcript of the video.
This already been, in fact, investigation officer has changed on, my lord, on 27/6/2026 itself.
Yes, madam.
Now been handed over by Sulibele.
The petitioner is before the court seeking the following prayer. The learned SPP on instructions would submit that the investigating officer is already changed on 26/7/2026.
27/6/20.
27/6/2026, and is a new investigating officer has taken over the investigation. In that light, the prayer of the petitioner has now been met. Therefore, petitioner is reserved liberty to knock at the doors of the appropriate fora in the event of need. The petition stands thus disposed. Next.
Lordships, is a victim's petition. Petitioners, petition number 3 and 4 especially on minor girl children. They suffered violent mob attack in Ugani, Kolar, Kolar. Violent mob attack and resulted in sexual assault as well, in the sense of POXO, because petition number 3 and 4 are minor girl children.
All right.
However, the investigating officer, FIR was launched, but it was a very light FIR. POXO offences were not invoked deliberately. And immediately there was a counter case launched against the minor girl children as well, saying that to give it a color of a civil dispute.
All right.
So
now what are you here for?
I'm seeking for monitoring of investigation. POXO is not invoked. It's a very serious offense. If I may request the lordships to come to page number 31.
What is the stage of the investigation now?
It's certain statements are recorded with the magistrate, but POXO is not invoked. That is a very serious offense.
20th, FIR is dated 20th June, your lordship.
Correct. You produce the stage of investigation by the next date. POXO ಈಗ ಇನ್ವೋಕ್ ಮಾಡಿಲ್ಲ, ಆಮೇಲೆ ಬರ್ಬೋದು, ಗೊತ್ತಿಲ್ಲಲ್ಲ.
Prima facie, there are incriminating materials to show. Page number 31.
ಹಿಡಿದು ಎಳೆದಾಡಿ ಬಟ್ಟೆಗಳನ್ನು ಹರಿದಿರುತ್ತಾರೆ.
Yes, Your Honor. There's also attempt to commit penetrative sexual assault.
Section 8 and 12 are ಇರಲೇಬೇಕಾಗಿತ್ತು POXO.
We'll examine what.
You have to, because look at the complaint. Either at someone's behest, you have not added it.
Immediately they file a
Come to
counter
page
case.
31, last 7 lines at page 31, straight away section 8 and 12 POXO.
Even 2 lines above that, your lordships may notice, ಕೈಗಳಿಂದ ಹೊಡೆದು ಕಾಲುಗಳಿಂದ ಒದ್ದರು. That is also.
That is assault, fine.
Yes, Your Honor.
Now
Sexual assault.
even sexual assault.
Sexual assault as per POXO.
Sexual
Only for
harassment
minor.
as per POXO 8 and 12.
Any act that has physical contact resulting in
No,
sexual
that's what that is there. That is clearly there. How did you not invoke? You seek the permission of the magistrate and now invoke it.
In fact, there has been no stringent action taken on the accused. I'm told they are only relying on the counter case, Your Honor. I am feeling threatened in my own house.
Challenge ಮಾಡಿಲ್ವಾ?
ಅದು ಮಾಡ್ತೀನಿ ನಾಳೆ we are.
ಮಾಡಿ.
But
Yes.
another.
The learned SPP to secure instructions as to why the offense under POXO is not included as one of the offenses in the FIR when the complaint clearly makes out the said offense. Less the matter day after tomorrow.
Fresh matters may.
Yes. Next.
Grateful.
Preparing for the petitioner, please. That's 31R of the Atrocities Act is invoked, minutes. That's page 21 is the Facebook post, minutes by Times of Karkala, stating that one Sudhir Bangera has been arrested for making caste remarks against the minister. Minutes, I comment, page 22 is my comment, minutes. For that comment, minutes, I have been booked for SC state.
Page 22.
2 minutes. Page 22, annexure B1 minutes. Annexure B is the post that one Sudhir Bangera is arrested for making caste remarks against the.
In the meantime, yes.
Great.
Next. Yes, Swarup.
My lords, 31R and 31S of Atrocities Act. Petition number 1 is the principal, petition number 2 is the secretary of a school. There was a dispute, there was certain loss of certain articles in the school. So everybody were directed.
Who is the complainant?
Complaint is another teacher, my lords. Now there's an employment dispute. She resigns from the post, that is at page number 24. She says some of her salary was deducted. That is the reason for her resignation.
Salary ಕೊಟ್ಬಿಡಿ.
Subsequently, she says 2 years salary ಕೊಡ್ಬೇಕಿತ್ತು ಅಂತ ಅಂದ್ಬಿಟ್ಟು.
ಕೊಡಿ.
So then she has registered this complaint under Atrocities Act saying that, and also my lords.
Get the investigation papers. List the matter day after tomorrow in the fresh matters list. Investigation papers be secured by the state by then.
Meantime,
Day after tomorrow. Yes.
Meantime, my lords, because now their principal and secretary of the school for running has been hampered because.
ಏನ್ ತೊಂದ್ರೆ? Teachers will run the school. Principal ಅಲ್ವಲ್ಲ.
Still, my lords, just.
No, day after tomorrow will grant.
Grateful.
Salary ಯಾಕೆ ಕೊಟ್ಟಿಲ್ಲ?
My lords, now there was certain loss of certain articles. So everybody were directed to pay 852 rupees. It is not the case that she has not been paid salary. She says now since I have been terminated, 2 ವರ್ಷದ salary because there was a contract ನೀವೆಲ್ಲ ಸೇರಿ lock-in period salary ಕೊಡ್ಬೇಕು ಅಂತ. That is not paid, she has registered this now.
Yes, yes.
This is even according to her, it's an employment dispute. And it is covered under your lordship judgment because she says inside the chamber.
Investigation, yes.
But it's in the meantime until.
Day
then,
after tomorrow, sir.
Grateful.
Past over 28.
Well, this is a matter where cancellation of bail against that the present
yes.
petition is filed. I've given the synopsis, my lords, and in convenience volume. Yes. I've given the synopsis and a
ಎಲ್ಲಿ
convenience
SPP
volume.
ಅವರು ಬರಕ್ಕೆ ಹೇಳ್ತಾರೆ.
About 25 dates of importance, my lords, of events that have happened. My lords should.
Now bail is cancelled.
Bail is
Challenges to the cancellation of bail.
Second time, my lords.
Second time. Papers ಕೊಟ್ಟಿದ್ದೀರಾ ಸ್ಟೇಟ್ಗೆ?
They have the interview.
ಅಲ್ಲ ಈ synopsis or whatever you gave.
I'll give even the synopsis.
Copy ಜಗದೀಶ್ ಸರ್ ಕೊಟ್ಬಿಡಿ. We'll take it tomorrow at 2:30.
Please, my lords.
Jagdish sir, just look into it.
On the first occasion when it was cancelled, Madras High Court reversed it, my lords. Then the investigation was transferred to Bangalore. Again, an FIR is registered, again cancellation.
Let me see. You have given it to me as well, right?
My lords, in fact, my lords, on cancellation of bail, a
That
note
time-
which has
that
done,
time
more
already,
I'll
yes.
give it, my lords.
ಅದೇ ತೊಂದ್ರೆ. Yes, tomorrow.
Oblige.
My lords, the charge sheet has not been filed, my lords. The complaint is on 14/6/2025, my lords.
You are the complainant.
Yes, my lords.
ಒಂದು ವರ್ಷ 69, 64 ಸ್ಟೇ ಆಗಿದೆಯಾ ನೋಡಿ ಅವ್ರು ಹಾಕಿ ಏನಾರು.
Illa, my lords. Page number 54, my lords. They withdrew the petition.
The learned HCGP to accept notice and secure instructions with regard to the stage of investigation as the crime is registered on 14/6/2025, a year ago. List the matter on Tuesday in the fresh matters list. Yes.
Petitioner, yes, sir. Page number 23, 28, my lord. We have entered into the franchisee agreement. We have clearly mentioned that applicable law and settlement with disputes appoint as a arbitrator. They have recently the Honorable Apex Court.
ಅಯ್ಯೋ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ ಸರ್.
But the offense 420 and Buds Act, Swami.
ಇದು ಬಡ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಇದೆಯಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಬಡ್ಸ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ನಾವು ಸ್ಟೇ ಕೊಡಲ್ಲ ಸರ್.
ಅಲ್ಲ, the Honorable High Court of Andhra Pradesh, same there are 600 outlets in the Andhra
ಕರೆಕ್ಟ್, ಅದು
Pradesh.
ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಆಗಿರೋದು.
Mediation, ನಮ್ದು mediation ರೆಫರ್ ಮಾಡಿ ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲ we are in the ಜೊತೆಯಲ್ಲಿ ಇದೀವಿ ಸ್ವಾಮಿ ನಾವೆಲ್ಲಾನು. We are ready ಇದೀವಿ. mediation ರೆಫರ್ ಮಾಡಿದೆ. We are ready to, this is.
ಫಸ್ಟ್ ಎಲ್ಲ ಮೀಡಿಯೇಷನ್ ರೆಫರ್ ಮಾಡೋದೇ ಬೇಡ, ಇಲ್ಲಿ ಯಾರಿದ್ದಾರೆ ಅವ್ರಿಗೆಲ್ಲ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
Vandana Jain's case, recently Honorable Apex Court has granted any agreement between the two parties. They are not registered any criminal case from in page.
ಅದು ಆ ಕೇಸಲ್ಲಿ ಸರ್.
ಅಲ್ಲ,
ಈ ಕೇಸ್ಗೆ ಅಪ್ಲೈ
ಅದರಲ್ಲಿ ಜಾಯಿಂಟ್ ಸರ್, my lord, in this my agreement in page 28 clearly mentioned that any dispute arise between the
ನೋ
parties,
ಪ್ರಾಬ್ಲಮ್ ಸರ್. ಈಗ ಎಷ್ಟು ದುಡ್ಡು ಇಸ್ಕೊಂಡಿದ್ದೀರಾ ಎಲ್ಲರ ಹತ್ರ?
3.5 lakh.
Each
3.5 lakh.
How many people?
46 people are in complaint.
ಕೊಟ್ಬಿಡಿ ಮತ್ತೆಲ್ಲ.
ಅಲ್ಲ, ನಾನು ಇದರಲ್ಲಿ we have give the goods, we have do the interiors in the shop, ಇವೆಲ್ಲ ಮಾಡಿದೀವಿ. ಇದನ್ನ ಕೂತ್ಕೊಂಡು ಮಾತಾಡೋದಕ್ಕೆ ಒಂದು ಪ್ಲಾಟ್ಫಾರ್ಮ್
ಮಾತಾಡಿ.
ಅದಕ್ಕೆ ಸುಮ್ಮನೆ matter may be referred
I
to
will refer to
ಅಲ್ಲ, ನಾನು
mediation.
investigation
No question of stay.
ಅಲ್ಲ ಸುಮ್ಮನೆ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಬೇಡ ಸ್ವಾಮಿ ನನಗೆ.
ಮತ್ತೆ?
Matter may be referred to mediation. In the meanwhile, not take, I have taken the bail, we are ready to.
Bail ತಗೊಂಡಿದ್ದೀರಲ್ವಾ?
Bail ತಗೊಂಡಿದ್ದೀನಿ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ. Mediation refer
The
ಮಾಡಿದ್ರೆ
learned counsel for the petitioner submits that the petitioner has received 3.5 lakhs from each of the complainants who are 46 in number. The learned counsel submits that the petitioners are ready and willing to return the amount, but has some dispute with regard to certain works done by the petitioner and the amount to be paid by the complainants. Therefore seeks reference of the matter to mediation. Therefore, I deem it appropriate to refer the matter to the mediation. However, the reference of the matter to mediation will not come in the way of the petitioner cooperating with the investigation.
The issue is that there are victims from all across different parts of the state. New mediation ಅನುಕೂಲ ಆಗುತ್ತೆ.
Oh,
Andhra Pradesh and Telangana, there are 600.
The reference of the matter to mediation, ಅಲ್ಲ ಬೇಡ ಅದು ಬೇಡ. The complainant ಯಾರಿದ್ದಾರೆ ಇಲ್ಲಿ?
Complaint is the one is the franchisee.
No, it is better investigation goes on in such cases.
ಅಲ್ಲ ಇದರಲ್ಲಿ in the meanwhile, my lord, ಇದರಲ್ಲಿ they are not attracted. ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಎಲ್ಲೂ
ಯಾವ attracted ಇಲ್ಲ.
attract ಆಗಕ್ಕೆ ಎಲ್ಲಿ ಮೆನ್ಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಇಂಟ್ರೆಸ್ಟ್ ಆಗ್ತಾ ಇಲ್ಲ ಇದರಲ್ಲಿ.
ತೊಂದರೆನೇ ಇಲ್ಲ. Investigation ಮಾಡಿ final.
There are 52 people have come forward. Amount is 1,89 lakh. Let him deposit that amount here, my lord. Then
ಅಷ್ಟು ಮಾಡ್ಬಿಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ
ಅಲ್ಲ ಅದು ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬಿಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ನಾವು ಇಂಟೀರಿಯರ್ ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ವಿ, 1.5 ಲಕ್ಷಕ್ಕೆ ಇಂಟೀರಿಯರ್ ಮಾಡಿಸ್ಕೊಟ್ಟಿದ್ವಿ.
ತೊಂದರೆ ಇಲ್ಲ. ಈಗ
2 ಲಕ್ಷ
ಕೆಲಸ ಮಾಡಿ
ರೂಪಾಯಿಗೆ
ಎಲ್ಲರ ಹತ್ರ ಇಸ್ಕೊಂಡಿದ್ದೀರಲ್ಲ.
ಅಲ್ಲ ಸ್ವಾಮಿ, we have given the goods to the all purchase.
You do one thing, for about 1.2 crores deposit ಮಾಡಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಕ್ಕೆ ನನ್ನ ಅಮೌಂಟ್ ಅವ್ರ ಹತ್ರ ಅವರೇ ನಾನು ಕೊಡ್ಬೇಕು.
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
ಅಲ್ಲ ಸ್ವಾಮಿ ನಾನು ಇದಾಗ್ತೀವಿ. We have entered into the MOU ಸ್ವಾಮಿ, complaint and me. Date ಕೊಡಿ.
Let the investigation go on.
No madam, my lord, one gate may be adjourned, may be given. I given the MOU in between the complaints and me.
No problem. List after 4 weeks. Yes.
ಅಲ್ಲ ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ.
ಆಯ್ತು. August 23rd.
In short date ಸ್ವಾಮಿ. 10th or 5th.
10th August. Fine.
Much.
List on 10th August. Yes.
For the respondent, in this 10th case, my lord, there was a settlement in between the parties with
ಈಗ intermodal ಇದೆಯಲ್ಲ, ಇನ್ನೊಂದಿನ ಕೇಳುವ. That's the matter on 4th August. Intermodal continue. ಸಾಕು ಮೇಡಮ್.
4th ಬೇಡ ಸರ್, 5th or 6th.
ಇಲ್ಲ 6th August. Matters admission ಅಲ್ಲಿ ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ ಅದೆಲ್ಲ ಆರ್ಡರ್ಸ್ ಕರೆದಿದ್ದೀವಿ ಮೇಡಮ್. ಎಲ್ಲ ಆಯ್ತಲ್ಲ. Admission ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ that will come.
57 my lord, EC Act my lord.
20 ಇಲ್ಲ
my lord, EC Act my lord.
ಯಾವ ಆಕ್ಟ್ ಆದ್ರೂ ಅಷ್ಟೇ.
Serial number
49.
Beyond this I can't work,
number
sir.
62 498.
ಯಾವ್ದಾದ್ರೂ ಆಗ್ಲಿ, ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ, dates will be given by me, not here.
Yes, I would like to.
One submission. My lord given an interim order, but dictated order, but there is no in the order sheet.
That we will see. Which is that number ಕೊಡಿ.
57.
I wanted to submit
serial
this
number
death certificate.
62.
ಯಾವ್ದು death certificate?
List number 40, sorry.
File in the registry.
Well, serial number 62, matter may be referred to mediation.
No,
All
no,
the
sir,
parties
nothing.
are ready.
All matters, dates will be given which are not
498
reached.
498 AM, my lord.
70, my lord, already